Hello, everybody, and welcome. We are getting ready to watch this hearing. Bryan Kohberger. Hello, Kate, and welcome. So here is the finished product. As I said, there is a wet spot still here. I just finished doing this morning, so there is a wet spot still there. So I will make sure that's cleaned up before I ship this out to you guys. And even a little wet spot here still. But I'll make sure that's all cleaned up and perfect for when I ship it out to the winner today. We will be having the draw at the end of the hearing for the book and the diamond painting that will be included with the book. So if you have not got your name on the wheel yet, $5 super chat, get your name on the wheel, and we will be drawing this right after the hearing today live. You guys will be able to watch it live. So make sure that you are on the wheel if you'd like the book. That's the Idaho Student Murders by Howard Blum and the diamond painting. Nana, good morning. Hello, Kat. Hope everyone is doing well and is having a great week. So for those of you who were with me on the last live regarding the change of venue documents that we went over, we know that the prosecution filed their objection to changing the venue. Well, there's a few things that have been put into the record. We're going to go over one of them while we wait for the hearing to begin. Carol, hello. Charissa, hello. Happy Thursday. We'll go over it because now Ann Taylor has replied to the state's reply. Let me just get it up here on screen for you. I think it's this one here. Yeah, so here it is here. And what I found interesting about this, I'm going to show you, they show a couple of their graphs. So we're going to go over that. I'm not going to go through this whole thing. This is like 23 pages again, typical of Ann Taylor. Another thing that I found out, you guys, is Ann Taylor is the lawyer now for another case, which is a death penalty case. So she was already complaining she didn't have time and they had to push this out until, the summer of June 2025. They still need more time and all this. Meanwhile, she takes on another death penalty case. So it's not really making sense. She wants what she wants, and she's going to do whatever she needs to do, even if it's, to me, it's petty what she does. We know when she went back to the 1800 law and it was like a 103-page document, like that takes time. It's like you're saying you don't have time to go through all this discovery. Yet here you are with these petty, I've never seen so many petty motions, but it is what it is, right? Christine, hello, long time no see. Glad you are here. We are going to be able to watch the hearing today live. Hopefully it's good sound today. They do use the court's audio and video for the streaming. So I'm just hoping I will have the volume cranked as high as I can crank it. And let's hope that we can see it good. I will also go full screen with the hearing once it starts. Okay, so here's the document here, you guys. Reply to state's objection to defendant's motion for a change of venue. Like I said, I'm not going to go through it all because it's all just very repetitive. But there are a couple of things in here that they talk about, which I feel like in Anne's backhanded way, it's like, this is how I'm going to prove it. I do feel that they can get an impartial jury in Latah County. I do feel that. But I feel like they're capitalizing on maybe some of the people that were interviewed that said certain comments. But if you did a phone survey of 400 people and you've only got 4 or 5 comments that you feel were disturbing, well, why don't you tell us about the maybe 100 or so comments where they said, yes, they could be impartial? Why are you only including the comments made that, goes in your client's favor? You know what I mean? Yeah, emotions are her middle name. Another thing, you guys, Summer Dawn is not in here yet, but Summer Dawn sent me some information. And in the last time we went over the documents, I had said to you, why is Ann Taylor pushing so hard for this to be moved to Ada County, no other county, even though in their own surveys there was other counties that were better suited because they had less media coverage, less people saying that they know about the case, less of everything, right? That would be more in Bryan's favor. There was 2 other counties, but they're saying, no, 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 let's disregard that. We wanted an Ada County where there was more people in Ada County that had heard about the case and were against Bryan Kohberger. Why wouldn't you push for the other 2 counties, right? You want the county that is going to be best suited, that has heard the least, that, doesn't have an opinion yet on his innocence or guilt, but they're not. They're pushing for Ada County. And Summer did some digging. Summer Dawn, she's one of my mods. And she found there is even a street in Ada County called Ann Taylor Road, named after Ann Taylor. So what really is her connection to Ada County, and why is she pushing so hard for Ada County? Anyway, I do have those in email, but I don't know if Summer wants me to share them because her email address is on them. But I might be able. Let's just go over this really quick because there's a few things I want to show you on this. Then I'll pull up the email and see if I can show it without her email address being shown, and I'll show you what I mean, because she sent me the mapping and everything where it says Ann Taylor Road, and it's right by the courthouse and everything. So is she very well known in Ada County and liked? Is that why she wants it in Ada County? Because Ada County is 300 miles away. Why is she pushing so hard for Ada County? That could be the reason, right? But let's go into this. She says, the pressure to convict Bryan Kohberger is so severe that Latah County survey respondents said if he wasn't convicted, okay, so we got 1, 2, 3, 4, 5 comments from 5 of the people that they interviewed. What about the other 395? What did they say? Did they say that they could be impartial? Did they say that they hadn't made a decision? They didn't include those, right? They only include this. They burned the courthouse down. Outrage would be a mild description. Another one said they would probably find him and kill him. You know what? Things like this, you guys, are said in every case. Every case. They said in the Karen Reed trial, if she was found guilty, there'd be riots in the street. There wasn't. There's just some people that have this mentality, but that doesn't speak for the 400 they interviewed. 5 comments does not do justice for saying this is a mob mentality. What about the other 395 that you interviewed, right? What did they say? There would likely be a riot and he wouldn't last long outside because someone would do the good old boy justice. They said this in the Karen Reed trial. Did that happen? Enraged, strong opinions, firing of officers, riots, parents would take care of him. Are you kidding me? So they said the mob mentality within the community is the exact reason that statutory grounds prior to jury selection exist to move the venue. So they also quote other cases. Let's just go to that. Like I said, this is 23 pages and it's very repetitive to what we've already seen. Defendant's motion change venue. They cite other cases. To me, this is irrelevant. These are different. Now, if these were comparing Latah County to Ada County, I would see how these would be relevant. But You're not seeing that. These are totally different cases with different circumstances. So they do, and they're really pushing for, look at Ada County again. They're really pushing here for Ada County. And I think that she has connections to Ada County. So anyway, and again, here's United States versus James Cloud. Between these counties, the county that it happened in and the other counties, I really don't see how that is anyway. I'm going to make this smaller. So this graph here is volume of media coverage over time, Latah and Ada counties. Latah is in blue and Ada is in red. So look at, I got to make this smaller so you guys can see it all. So look at this. In January of 2023, right down here, I've highlighted it. The red line is way above. This is April 2023. That's when the probable cause affidavit came out. There was more coverage in Ada County than there was in Latah County. And then after the arrest affidavit came out, the probable cause affidavit, it was higher in Latah County. You can see by the blue here. But there was still a lot of coverage here in Ada County. They also have a bigger following in Ada County than they do in Latah County because of the population. But look at this. And then as we get into July down here, right here, this area, July and August, it's ramping back up for Ada County. Ada is way higher than Latah County for July and August of 2024. It's way higher. And it was basically in line from May 2024 to the end of, well, till June, the beginning of June 2024. And then Ada County was right in line with Latah, and now it's even higher than Latah County for media coverage. So it was very high in the beginning, and it's going higher than Latah County now. So their own graphs are shooting them kind of in the foot, because between June, let's see here, June of 2023, it drops off for Ada County, but it's still kind of high in Latah County, right? And then high again. This is when December 2023, when they had some motions hearing on the evidence, on certain pieces of evidence. And that's why it went so high again in Latah County. There was documents that were released. But there was still a lot of interest here in Ada County also. Again, in April of 2024, there was a spike here again in Latah County. And I believe that's when there was another, I don't know if that was the motion they filed to dismiss or whatever. So I could see why it went high again in Latah County. But they were both on point here, like in March, a little bit higher here. But in comparison, these graphs are showing it's pretty much on point. When it spikes in Latah County, it spikes in Ada County. Here, even in August of 2023, 126 in Latah County, 99 in Ada County. That's pretty close. You know what I mean? It spikes again here, but it spikes again also in Ada County. Another spike here in Latah County, but look at the spike here too in Ada County. So this is Latah, this is Ada. But look at down here now at the end to where we are now. From May, like 54 in May, 65. Only a 10% difference here in May. But come from mid-May on, it is pretty much in line with Latah County, and now it is above. There's an 18% interest or incline in Ada County, and only it's gone down in Latah County. So this is very interesting. It has stayed on point, basically very close and similar since May until July, where it spikes again in Ada County, but it doesn't spike in Latah County. So I do believe that the prosecution is going to point this out in the hearing today, where this is really spiking, and Latah County and Idaho, Moscow, Latah County and Ada County, this is getting confusing, very much is staying on point in both. So I think that the prosecution will use this to, especially this spike down here, to prove that it's spiking again in Ada County, but not in Latah. Volume of media coverage over time since his arrest has really gone down everywhere. There was a big spike. Here's that spike again when the probable cause affidavit finally came out that we could read it. That's where this high spike is. And that's expected in any case in any county. But the coverage has really gone down across the board. So I do believe that the prosecution is going to use this chart in their fight today. This is a chart that the defense has put in. And like I said, when the probable cause affidavit came out is right here. And look at the spike. It was higher in Ada County than in Latah County. And over time, it's slowly gone down. It spiked a couple times. These were major hearings, though. But pretty much on point here. But now Ida County has really spiked compared to Latah County in June, July, and August. So I wonder what they're going to do with this information. I do believe that the prosecution is going to use that. I do believe way back here, the prosecution is going to also, let's make this bigger for you guys, is also going to use these comments that some people in the survey made. Well, if you're going to put these comments in, you should really, give us an indication of what the comments were from the other side of this. The prosecution also did say in their reply, their objection to moving the court case to another venue, said that they didn't have the full report. They have since filed more paperwork in the case saying that, look at, since going over everything, we do have the information. So they wanted to make a point of the judge knowing that, yes, they do have those charts that I just showed you, but they were buried in the paperwork. So that's why they didn't really see it until, it was claimed that they did have it when they thought that they didn't. So they have made a point of letting the court know that they have found those records. Hello, Ada Jeannie. Nice to see you. It's going to be starting in about 15 minutes, you guys. We're just going over the latest paperwork that was just filed over the last 2 days before court starts. So let's stop sharing that. Here is the book and the photo this is a diamond art painting that I did, you guys. It doesn't do it justice right here, but it is really sparkly. I could probably turn on this light. There you go. Now you can see the sparkle in it. My light over there is not, there you go. You can see all the sparkle throughout it. So I'm going to be drawing a winner for this at the end. You guys will be able to see it. You'll see your name on the wheel. You'll see me spin the wheel. You will see the program that I use actually will tell you who the winner is when it stops on the name. It pops up. It's fun. We'll be doing that at the end of today's hearing, and somebody is going to win this book in diamond painting, and it will be shipped out to you tomorrow. So if you are the winner at the end of this video, when we do the draw, if you are the winner, please make sure you email me right away, and because I want to get this shipped out tomorrow with your mailing address. So I'm glad you made it too. So let me just see. And a lot of people are making a big deal. Let me just show you this. are making a big deal about these supplemental requests for discovery. This is their 17th supplementary request for discovery. This is normal in cases. Usually you don't have this many. It seems Ann Taylor likes to do this at least twice a month. This is just keeping it on record that they have requested any discovery that has come in that has not been sent to them. So, say yesterday somebody came to the prosecution and said, "Look, I seen Bryan Kohberger coming into the house." They haven't disclosed that yet, right? So this is just the defense keeping it on record that they want any discovery, whether it's good or bad for them, they want it. So just keeping it up to date. So in case anything's come in since the last request for discovery, they are requesting anything new that they may have come across. A lot of people are saying, the prosecution's not giving them the discovery. Yes, they are. Like I said, this is normal in court cases, but it's not normal to request it this often. Usually you do it once every month and a half or so, just in case something new did come in and, the defense is putting the prosecution on notice, hey, we want anything new that you've gotten. So people shouldn't be making such a big deal about these requests for discovery. Oh, the 17th one. It's normal. It's keeping it in the record. It's keeping it on the record that they're requesting it. So something comes up in trial. It's like, well, you didn't give us that in discovery. Well, you didn't ask for it, right? But whatever. That's what it is. Let me see what else is in here. Not really, nothing new. Notice the state's objection. What's this? Oh, here's that. Also, might as well show it to you. We've got a few minutes before the case starts. This is what I was talking about here. State notice on state's objection to defendant's motion to change the venue. Upon review of the defendant's reply brief and the supporting declaration of Dr. Veronica Dahar, as well as a review of the documentation submitted by the defendant with his initial Willow can't talk today, so please just ignore me at times. The state provides the following notice. Portions of the state's brief indicate that the state was not provided comprehensive survey data from the defendant. This is incorrect. The state was provided raw data from the surveys as well as a declaration that analyzed some of that data when the defendant filed his initial motion to change venue on July 22nd, 2024. Through the state's argument remains unchanged, the state does not wish to create an impression that the state did not receive all the survey data. To that end, the state submits this notice in advance of the hearing. So, I mean, they came clean and, made the court aware that they were wrong in a portion of what they submitted in their objection. But they did make it clear that the state's argument remains unchanged. So that's always good, like even the prosecution, hey, you make an error, own up to it. Okay. Okay, so I'm just checking to see order sealing exhibits. What's this? What else can I show you guys? We've got like just over 5 minutes, you guys, before it's supposed to start. Oh, look at this, you guys. There is an order sealing exhibits. The court having before it the stipulated motion to seal exhibits and good cause appearing now. Therefore, it is hereby ordered that portions of the exhibits to the memorandum in support of motion to change venue contained on the USB flash drive hand delivered on 7/22/24 shall be temporarily sealed. So there's exhibits that for this change of venue that are also sealed. I believe that should be public. If you are asking the public to foot a bill to move this case 300 miles away, I think that they should have all the information on why they feel it is necessary and all the evidence to show it's necessary to foot a bill to move all of this case. That's a lot of money, you guys, 300 miles away. But the judge has sealed it. That's interesting. What's this one? Oh, another huge document giving reasons. We're not going through that. This one's only... well, this one gives a little bit more info. Let's see. This says order to temporarily seal exhibits. Okay, so this is stipulated motion to seal the portions of the exhibits to be sealed contained in the USB flash drive that was hand delivered of the defendant's witness and exhibit list for the motion to change a venue hearing. The parties must agree the sealed portions of the exhibits will be utilized in open court. Oh, so we're going to see those exhibits today, what's been sealed. But why have they wanted it sealed until today? The documents contain facts or statements that might threaten or endanger the life or safety of individuals. Ooh, what are we going to hear today, you guys? What are we going to hear and what are we going to see today? It is necessary to preserve the right to a fair trial, and disclosure would constitute an unwarranted invasion of personal privacy. So we're going to find out. Even though this has been sealed, we are going to find out today. And it says the documents contain facts or statements that might threaten or endanger the life or safety of individuals. So that's going to be interesting. This is going to be interesting, you guys. Because until today, this has been sealed. But they are saying that the exhibits will be utilized in open court on August 29th. And the parties agree that the sealed portions of the exhibits will be utilized in open court on August 29th. And they wanted them sealed because, in partial, the documents contain facts or statements that might threaten and endanger the life or safety of individuals. It's necessary to preserve the right to a fair trial, and the disclosure would constitute an unwarranted invasion of personal privacy. So we're going to see this today. Woohoo! Hopefully. Unless they black that part of it out. I don't know what they're planning on doing. But until today, this is sealed. But the parties are agreeing, it says right here, that the parties are agreeing that they will be utilized in open court on August 29th at the hearing. Yeah, have been really boring. This is going to be interesting because I really hope that they do not, that the venue isn't changed. To me, you guys, Ann Taylor was not going to settle for anything less than this trial being held in 2025. She stomped her feet. She yelled and screamed. The way she talked to the judge, like putting the judge in his place type thing and scolding the judge. And It's like I've never seen that in any case that I was ever part of. And I worked in criminal justice in the criminal law field for over 30 years. I never seen an attorney scold a judge like that and get away with it. But anyway, and it's almost like what Ann Taylor says goes. But anyway, so she's going to be stomping her feet on this again, you guys, and I do feel that it should be held in the county and where it happened. And I do believe that they can't say that they can't have a fair trial until they do try and sit a jury. That's what voir dire is for. And she only mentions is the negative things that have come out. What about all the positive? Be fair in all of it. You know what I mean? Good morning. Good morning, Jean P. Risa, good morning. Yep, hopefully something interesting happens. Sorry, you guys, I have picked up a cold. Yay, me. Not. But I have picked up a cold, and my summer colds are the hardest to get rid of. So we are still waiting. Any minute now, we should get the stream up. Once it starts, you guys, I will put the stream full on the screen here. But again, for those just joining, a $5 super chat gets you in the draw. We will have the draw at the end of today's hearing for the book, The Idaho Student Murders by Howard Blum, and the diamond painting. I'm going to throw that in with the book too. So if you are the winner, I'm going to say that if you are the winner at the end of today's hearing, I'm going to draw this live. If you're the winner, I need you to email me your address, your mailing address, so I can get this mailed out to you tomorrow while I go out and do a bunch of other things that I need to do. Sorry for that's my light, you guys. I gotta try and, there's things that are interfering with it. Anyway, hopefully you guys can see it good. Let me just check and see if this is up yet. We know they're always a couple of minutes late. So once it is up, I will be sharing it any minute now. Let me just check over here and see what is going on. Okay. Still not up yet, you guys. Let's see what chat is saying here. Good morning, Missy. Okay, Mitch says, yeah, I was just speaking about that at Anne has ties, I think, everywhere. I was speaking about that at the beginning of the video. Why I think that she is pushing so hard for Ada County, even though there's other counties that were more that didn't know about the case and were open to hearing the evidence before making a decision. They were more unbiased against Bryan Kohberger. No. Those are still too small. Let's go to Ada. She's really pushing for Ada County. For us to find out, I believe it's the street that either the court or something is on Ann Taylor Road or Street. There's an Ann Taylor Road in Ada County. Like I said, Summer isn't here, or I would ask her if I could show it to you because she sent it to me, but it would show her email address. Oh yeah, that's what I wanted to do. I wanted to check and see if I could show it to you without showing her email address. Let me see if I can do that. Give me a second, you guys. Okay, I'm going to save this. I'll save it in here. There it is. Okay. Let me get out of there. Let me bring this up. I gotta put it over here so I can show you. Okay. I'm going to show you this quickly because the hearing's going to start any minute. Look at. This is Ada County Courthouse, West Ann Taylor Street. This is Ann Taylor Street. West Ann Taylor Street. And it goes right to the Ada County Courthouse. So here's Ann Taylor Street. There's a street in Ada County named after her. So just to show you. Okay, so let's get rid of this so I can bring up this because this is going to start any minute, you guys. The stream is still not up yet. It ties between her and the judge, okay, Mitch says. Thank you, Missy. Yeah, I've never seen a lawyer be able to get away with that. Like she scolded him and more like it was more like she was a judge and he was the prosecutor because she put him in his place. And it's like even some of the looks that he gave, it was like, okay, judge, get some balls, say something. But he didn't. Sorry if you guys just heard my tummy. So the stream is still not up yet, you guys. We are still waiting for the stream to come up. I guess this is typical. I think they're always late, eh? This one, and I don't know what's wrong with Idaho because they're always late. They're always late. The problem with the defendant's experts, however, is that their opinions are directly contrary to the law. They're going to be arguing all this, you guys. It's going to be interesting. And it's going to be interesting to see what the judge actually does because, I don't know, it's crazy. Come on. See, the trial court does not need to find that the jurors are entirely ignorant of the facts and issues involved in the case to hold that the mere existence of any preconceived notion is the guilt or innocence of an accused. Without more, it's sufficient to rebut the presumption of a prospective juror's impartiality. would be to establish an impossible standard. And that's exactly what the prosecution is saying that the defense is doing, is they're making it impossible, and they're setting such impossible standards in Latah County compared to Ada County, that they would never be able to rebut these standards or whatever. Okay, Nana, you take care, hon. We'll be here. Hello, Carly with an I. Hello to all, and thank you, Willow, for all your hard work. As far as the judge and Taylor go, maybe there's something we don't know. Maybe. A lot of people are saying it. And like I said, I've worked in criminal justice system for over 30 years. I'm now retired. I say retarded now, but I'm now retired, and I have never seen in Canadian legal system ever, or even in the US, the trials, and I've covered a few of them, you guys. I've never seen a lawyer able to talk to a judge in that manner and scold him on a live streamed about for the world to see and get away with that. And it continues. She's calling the shots. And there's so many people that are saying this judge needs to grow a set and start taking his role as a judge and not just a buddy. Hey, buddy, what do you want to do today? What can we agree or disagree on today? You know, like, it's just, to me, it's weird. It's weird. The interaction between the two of them is weird. Weird. So come on, let's start. The stream is not up yet, you guys. As soon as the judge gets this stream up, I will be putting it full screen here for you guys live. It's not up yet. Now, see, if Court TV or somebody would have been in there and been able to do all the recording of this, we would have at least been able to see the courtroom right now. But it's not. It's the court's own equipment they're using. So the judge doesn't put it up until he feels like putting it up. So as soon as the judge puts this stream up, you guys, I will be putting it up for you. But it has not started yet. It was supposed to start 10 minutes ago. And that's another thing I don't like, the tardiness. And it's every hearing. Every hearing. Good morning, Cleta. And welcome. We are just waiting for the live stream to be put up by the judge. As soon as he puts it up, we will be live streaming it right here, full screen. But they're being tardy like usual. But so far it is not up yet. There we go. We've got it up, you guys. Let me get it up on screen here. Okay, let's get it full screen. Let me get the volume all the way up. Okay, here we go, you guys. Here we go. So Bryan Kohberger is not even there yet, you guys. Okay, so put one in the chat, please, if you can hear them kind of chit-chatting. Thank you, Carol.
Where's he from? Oh.
My earbuds are dying, so once it starts, I will mute myself. Thank you, Missy. Once it starts, I will mute myself so I can use my own speakers and take out my earbud and charge it. My earbuds are dying.
Oh, okay.
So Bryan Kohberger is not even in the courtroom yet, you guys. I do have the volume up all the way. It's going to be loud once they come in, you guys. The judge is not in the room yet either. Oh, they've muted.
Oh, thank you. I appreciate it.
Not muted.
All rise. Thank you very much. Please be seated. Good morning. So let's get on the record, please. We're now on the record. This is State versus Bryan Kohberger, case number CR 29222805. Mr. Kohberger is in the courtroom. He is represented by Ms. Taylor, Mr. Logston, and Ms. Massett. The state is represented by Mr. Thompson. Ms. Jennings, okay, I didn't see you immediately. Ms. Beatty and Mr. Nye. We're here on a motion to change venue from Latah County to Ada County, filed by the defense. Preliminary, anything, Mr. Thompson?
In your honor, not from the state.
Okay, thank you. Ms. Taylor?
Your Honor, just that there is a stipulation that the court received the exhibits that were filed along with our declaration and our memorandum in support. That's correct, Your Honor.
All right, so we're talking about all those slides? There were like 100 slides.
There were 100 slides, Your Honor. We're talking about those, but in particular, the references to all of the media coverage, the articles that were contained, the table with the links to all of the articles that depict all of the media coverage.
So are you going to show those publicly, or those are for me because I'm the one who has to make the decision?
Those are for you. Yeah,
Oh, okay.
We'll have PowerPoint presentations today, but we will not be going through the hundreds of articles that have been provided for the court's consideration.
Well, I'm thankful for that, because I did look through all that, and I thought, oh, this would be not a good thing to, push out to the public, because we're trying to protect that, right?
Your Honor, we are, and I think it would take an extraordinary amount of court time to try to read through all of the articles or review all of the bits of news coverage that have happened in this case. We do intend to offer a little bit of a preview throughout our testimony, but certainly not the hundreds of articles and news stories that have existed.
Well, that was my other concern. So, all right. Well, call your first witness.
Your Honor, Ms. Massa, we'll start.
Okay. Mathis, thank you.
Good morning, Your Honor.
Good morning.
Your Honor, as we get started here today, what I'd like to do is provide you with a roadmap of where we're going with our witnesses. The standard here is whether there's a reasonable likelihood that pretrial publicity has affected the impartiality of prospective jurors. To establish the quantity of pretrial publicity, we will call James Todd Murphy with true scope. To establish effect on partiality, we will call Dr. L. Alili to discuss the social science behind juror decision-making. Then we will call Dr. Brian Edelman about the survey and what it means. And finally, we will call Dr. Dare about the validity of the survey methodology. We are not calling today Scott Sunby, but as you listen to testimony today, please keep his sworn affidavit in mind. With his 39 years of studying capital juries and teaching at the National Judicial College, he is considered by the United States Supreme Court an expert in this area. He has published this book. It's called A Life and Death Decision, A Jury Weighs the Death Penalty. And this book is a culmination of interviews of over 1,200 capital jurors and how capital juries make decisions. Research shows that when a small community creates pressure to impose death, an Eighth Amendment violation may occur. Through these witnesses today, we want to avoid beginning a trial with, as Mr. Sunby states, quote, a thumb on death's side of the scale, end quote. And with that, I call James Todd Murphy.
Okay, thank you. Okay, maybe Mr. Murphy, come on up this way, or however you can find your way through. And please face the clerk, raise your hand.
You solemnly swear or affirm that the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth under penalty of perjury.
I do. All right. Thank you, sir. Please have a seat there. And once you're seated, please state your name and spell your last.
James Todd Murphy. I go by Todd, my middle name. Last name is Murphy.
All right. Sir. Ethan Chapin.
Mr. Murphy, how are you employed?
I'm the president of TrueScope. That's spelled TRUESCOPE. It's one word.
And can you explain what TrueScope is?
Sure. TrueScope is a media monitoring and analysis service. We wrap our arms around all the media types out there. You can do it on a global level or a geographically isolated level. Normalize all that data from television, radio, newspapers, magazines, social media, online sources. Index that with metadata so we know date, time, placement. We assign sentiment metrics to it. And from that, we can extract data sets for what our clients need, specific to topics or phrases.
Can you explain how you track this media intelligence that you just described?
Sure. So we have feeds that are coming in. For example, we acquire a feed from X, formerly Twitter. We have an online feed that accesses all available online sources. We have a broadcast feed of TV, radio, and podcasts. All those feeds come into us as they're broadcasted, as they're posted, as they air or are printed. We don't do any modification of the text or the context. We just take it as it was provided by the content owner, index, store it, and then run queries against it.
Where did you travel from to be with us here today?
Our North America headquarters are in Omaha, Nebraska, where I live.
Would you tell the court about your background in media intelligence?
Sure, might sound cliche, but I was born into the business. My father acquired press clipping service called Universal Press Clipping Bureau in 1959. Eventually met my mother. Without further detail, eventually I became in existence. It's a technical phrase, I'm not sure. So working alongside my father growing up was just part of the DNA. I studied psychology and communications in college, and when I graduated, the internet was beginning to become a thing. And so I saw a future of data mining and expanding what was a press clipping service into the future. So my full-time employment with Universal at the time started in 1991 and came to today.
Beyond your 30 years of experience that you've described in your educational background, do you have other qualifications in this area?
Yes. So in the mid-90s, I developed a framework for comparative media analysis where we could take those data sets and compare. My first project was letting hospitals compare themselves to others to see how one brand of a hospital might compare to another within a community or market. I also invented the first multi-channel media monitoring software that would let us monitor multiple TV channels on one computer and write the closed captioning text to a database simultaneously. Innovations not quite as exciting as those continued throughout the years. I also made other acquisitions, which I then folded into Universal, buying up other monitoring services in Alaska or Wisconsin or wherever. Eventually merged my company with TrueScope, a technology company out of Australia. TrueScope owns Universal Information Services at this point, and we're adding AI and other natural language processing to what we do. The tech.
What about organizations? Are you part of any organizations in this field?
I am. There's a global organization of all media intelligence services called FIVEB. That's spelled F-I-B as in boy, E-P as in Paul. Every continent except the uninhabited ones have many, often multiple media intelligence or media monitoring services. They belong, or most belong, to this organization. My peers in this organization elected me president to lead this organization at a global level last year. I'm currently the president of FIVEB.
And have you ever testified related to your expertise before?
I have been asked to do that. I have done so, yes.
Before you start talking about the data in this case, how closely have you followed this case on a factual level?
I kind of have a personal standard operating procedure that when a client engages us on a topic that I feel for our company may become contentious or may have downstream effects where I might be called to objectively testify, I purposely remove myself from evaluating the content of the data set related to the subjects they're asking us to monitor. So while I have made myself familiar with the search strategy, the keywords, the phrases, which would include the defendant's name and the family names of the students that are victims, I have done very little. I paid very little attention to the media exposure on this. In fact, I just learned that the judge of this case has a last name that sounds like he was born for this role. That was last night. I didn't know who the judge was. For coincidence. My apologies for not knowing who you were until last night. Thank you.
Are you familiar with Ms. Saucier, who testified last year in this case?
Yes, Jean Saucier is my right-hand person. She's a senior vice president of client success. She has a media measurement background that started years before she came to be under my employment. I would venture to say she's as much of an expert in this area as I am. And if she was actually here, I'd probably say she's more of an expert, but since she's not, I'll claim that for myself.
So for context purposes, when she testified about data in TrueScope, is it the same set of data that you've just testified to?
Exact same data. We work at the same company. We have access to the exact tools. She works with clients directly as yourself, and I work directly with her.
How is TrueScope using media intelligence in this case?
I'll say it maybe functionally. We have been asked by you, our client, to track specific topics related to this case, names associated, and I might say the more unique a phrase is, the more accurate our media monitoring can be. If the name was John Smith and Susan Jones, then we have to do much more Boolean logic, apply more Boolean logic to make sure that we're focused on extracting. It's very specific. So for you, we've built a search query using Boolean logic and AI to focus on the stories that are of interest in this case. The second half of what we're doing, so that's the media monitoring. We first capture the data. That creates a data set. Then that data set is analyzed by our analysis team, which is led by Cheryl Lewis, Theril Lewis, Lews. And she has an assistant data analyst who they're trained in a way that we call cross-coder proficiency. So whether Cheryl analyzes a story or Perry, her assistant analyzes it, they analyze it in the same manner. That also creates a check and balance that if something in the media monitoring function picks up a story that matches the name Judge, but for some reason isn't the Judge associated with this case, the analysts then at a human level can say, that's the wrong Judge, and it would be removed from the data set at the analysis level.
What objectives is TrueScope trying to achieve in this case?
We've been primarily asked to look at the without even being hyperbolic, would say an extreme amount of media coverage, its impact on a population or a community, and the statistical volume of that media exposure on various communities across the U.S., but focused on several counties within Idaho.
How long has TrueScope been gathering data for Mr. Kohberger's case?
I believe we were engaged on February 15th, 2023. We have some ability to pull some data forward from that time, but that's when technically the engagement came.
And you've talked about the media types and the data that's gathered. Is area or location of media coverage able to be determined?
Yes, in most cases, maybe I'll separate that into two areas of media. You have traditional media, which would be television, radio, newspapers, magazines, even online news sources. Those are all tied to a specific city and state. You have the Moscow Daily News, and the metadata that we have attached to that source would say, okay, that publication name is in the city of Moscow, in the state of Idaho, and has a circulation figure of, I'll say, hypothetically 3,000 readers. I don't know the exact circulation of that specific paper. For television, each television news affiliate, local news comes from what's called a local news affiliate. It may be the ABC affiliate, but it may have call letters such as KXLY, I think is one of the Spokane channels. And they may be an NBC or an ABC affiliate, but they're the local affiliates who's in charge of airing local news. And Nielsen media data, Nielsen services, you may have heard of Nielsen boxes and market ranks and things like that. They know that that station is in this city, in this state, and each affiliate is part of a DMA, a designated market area. Stop me if I'm going too far down the rabbit hole, but a designated market area, although the news may come out of Spokane, Washington, the designated market area is a radius around that can take in additional cities, counties, and at the functional level, consumers of news, viewers in this case.
Is frequency of media coverage able to be determined?
Yeah, we since on television, newspapers, online, demographics can change over time, can change by day. So a good example of frequency, why frequency matters. A local news affiliate might have a 6 to 7 a.m. newscast, a midday newscast, a 5 p.m. and a 10 p.m. Depending on what time zone you're in, those can be adjusted based on network. But let's say that they ran a story about anything. They might run it in the morning where the demographics skew one way. They might run it at midday, which might have a much smaller audience or potential viewership. They might run it at 5 o'clock, which would have people who come home from work early or those who are unemployed. And then at 10 o'clock generally can be the largest audience. So knowing what time they run it lets us know the demographics, the audience, and even a vanity metric called ad values. We won't get into that, but what time a story airs and how many times it runs we aggregate that and we can say, okay, this story ran 4 times on this channel on one day and had a total viewership potential of, say, 50,000. That doesn't mean I watched it at all 4 times. That just means the viewership at each of those times has the potential to see it. And that's where frequency comes into play.
Are there types of media coverage that TruthScope does not gather?
We don't track anything that's illegal. We don't go behind, we don't penetrate privacy rules such as your personal Facebook pages if they're marked to private. We also don't look at streaming entertainment channels such as Peacock, Hulu, where the content on those channels often is broadcast originally in a specific time zone. We call that an ephemeral broadcast, where it aired at 5 o'clock and then was lost to the ether. But Hulu and those streaming channels give the opportunity for that story then to be posted, and you can watch it at your leisure in a time shifting. We don't monitor those adjacent streaming channels, because they're subscription based, demographics are different, and we already have the content as it was aired originally.
I'm going to hand you what's been stipulated and admitted as a part of Exhibit C. I've shown the state, Your Honor.
Thank you.
Can you tell the court what that is?
That is a very base level spreadsheet of all the media exposure. Just looking at some of the topics specific to this account that you've engaged us for, including the topics that you've specified we monitor for your account. It includes various things like the type of media, so it might be Twitter or print or broadcast. It would include the metadata we include, city, state, circulation, viewership, things like that. There's also hyperlinks. As a client of ours, you would receive, if you exported this from your workspace or we exported it for you, you would have a hyperlink. You would click on that. Because we have a cookie on your computer, it would open that hyperlink and you could see the full story. Unless it's an online story or a social media story, then we take you directly to that end source. So if it's MoscowDailyNews.com and it's in front of their paywall, you would click on that link, you can view that story yourself.
Is Exhibit C in front of you specific to Latah County?
Yes, I see under county, spot checking it and spinning through where it can be determined either all Latah County related. Some of them are cities within Latah County.
Is the list of Exhibit C approximately 1,360 entries long?
Yes, I can confirm that's the number of rows, which and each row would indicate a individual media mention, or also known as a media story, an article or a news story on a broadcast.
And Your Honor, I won't have him hand that to you now, but for purposes of the record, that will be a paper copy for the court's file. You have that in an Excel spreadsheet that's much easier to read than what is in that paper in there.
Right, okay, so this was agreed by the state too. So I just want to make sure, because I have the exhibit C also that was attached to your brief,
Which is
which is 300 pages. So, but then we have the additional C, which is more I guess thorough.
so this is a part of C related to TruthScope, which is this list of the 1,300 stories. And then I'm about to get into the other part of Exhibit C, which is TruthScope's report.
Okay. Okay, great, thank you. Just wanted to clear that up.
Did you prepare some other documents that represent media coverage in 4 counties in Idaho for this case?
We did. Once TrueScope had, and it's an ongoing thing. We're constantly monitoring your news. So even this morning, you would have received a report of any media exposure that has happened since yesterday morning. It runs on a 24-hour cycle where we push out a report to the clients, but we're collecting it in real time. So if a client wanted to look at their workspace at 3 p.m. today, all that news would be in there. I may have digressed from your question.
That's I'm going to hand you an exhibit.
Okay.
This is the second part of C. And I'm going to put that in front of you because it might be easier to see. You've got 2 screens.
Yes, that was the second part of my answer. We did prepare a media measurement analysis. Cheryl Lewis's team, and that's part of the combination of services that we're providing.
Okay, looking at this page here, can you please explain to the court what this is?
Sure. You have 2 pie charts. On the left, you have the volume of media coverage specific to the keywords and phrases searched for our client related to this case. You see on the left, out of all the media coverage between January 2023 and July 15th, 36% of that coverage, or just over 36% of that, was seen or had the opportunity to be seen in Latah County. On the right side, you have another pie chart that shows the population of Idaho, and it shows what percentage Latah County represents of the total percentage of Idaho, which is 2.75%.
On the second bullet point of notes there's some reference to census. Can you explain that note?
Sure. The census data used for this was from, I believe, July of 23. Of the 40,924 people in Latah County, we were asked to look at age eligible to serve on jury duty amongst all of that, the people in the county, which equated to 61%, or just under 25,000 people of the nearly 41,000 all are age eligible to serve on the jury.
Right.
In Latah County.
Going to the next page. What does this page tell the court?
This is the same analysis framework performed on a different county. Again, on the left, you see the total media coverage in Idaho for the same date range, but 34% of the media coverage was seen in Ada County, which is just a couple percentage points below that of Latah County. The primary difference is the right-hand pie chart, which shows the population of Ada County relative to all of Idaho, and it's over a quarter of the state population, 78 or 26.42%.
What conclusions do you draw when you compare the 2 counties' data?
There's a lot more people in Ada County, and where I would be going with that as a media analysis, when I would interpret this from a media analysis perspective, is the propensity to dilute the media exposure in a larger population is a factual function of that. If you have a certain number of stories divided by the population, the number of stories a person can see is fewer if the population is larger. Did that answer your question, or was I?
Okay, I'll follow up with another specific one. Out of the 2 counties, where is the most opportunity for a resident to view stories about this case?
It's by far in Ada County. When we did the analysis of the age eligible process, nearly 300,000 people in Ada County are jury age eligible, compared to just under 25,000 in Latah County. I'm
gonna just ask my question again. It was probably inartful on my part. do more people in Latah County, is there more saturation in Latah County or more saturation with media coverage in Ada County?
Yes. A person in Latah County would be exposed to far more media coverage than people, a community in Ada County.
Can we now switch to the third slide? What does this show?
This adds in 2 additional counties that we were asked to look at. It reflects media exposure specific to Bannock and Camden counties.
And and then there's also a gray area rest of Idaho. You just want to explain what we see here?
Sure. So if you look at the volume of media coverage for the same feed range that the first 2, Latah, Ada, and then 4 counties we're looking at, out of all the media exposure for the state of Idaho, Latah received 36%, Ada had 27%, Bannock 1.56%, and Camden just over 3%. The rest of Idaho had just under a third of the meetings. So outside those 4 counties, the rest of the counties in Idaho, for the rest of the people that, the rest of the regions in Idaho would have been exposed to approximately 31.53% of the media exposure.
You turn next to, I believe it's page 5. Explain what opportunities to be seen are and the differences in the counties.
Sure. So in this pie chart, again, we're looking at the same date range. Opportunities to be seen are maybe best described relative to probability versus possibility. Each person in any of these 4 counties, or the rest of Idaho for that matter, have an equal possibility to see a story. It's like flipping a coin. You can flip a coin 100 times and the possibility of it coming up heads is equal every time. The probability of it coming up heads every time is much different. Probability is a mathematical statement, a quantitative measure. And so opportunities to be seen are dependent on the media type. So we measure opportunities to be seen for, say, newspapers based on their circulation. These are paid subscribers who you then infer pay to receive that news, they consume that news. Television has Nielsen audience figures. Nielsen measures those in smaller markets quarterly, in larger markets 6 times a year, I believe. Any of the broadcast markets we're talking about and the DMAs affecting this pie chart would be measured quarterly. So opportunities to be seen are the possibility that people in that county would see it. It's the volume of those opportunities that creates the potential opportunity or probability that they've been exposed to X number of articles or media mentions, discrete articles, stories about this topic you're having us track. The numbers reflected on the pie chart show that over half of those opportunities to be seen reside within Latah County, nearly 60% or 57.03%. The opportunities to be seen per person in Ada County is 31.2%, not quite half, but nearly half the opportunities. And that's a simple mathematical function of all the media exposure in that county divided by the population, or in this case, potentially age eligible for jury population.
And in terms of the green sliver there, Canyon County is close to Ada. And so if we assume that Canyon County residents might review Ada County news with its population of 180,000, is the dilution of Latah County or the the dilution of Canyon County is still significantly greater than the saturation in Latah County.
If I understand the question correctly, how I may answer that is Canyon, and I would also say Bannock, unless you don't want me to mention Bannock, but the media exposure specific to those counties is statistically insignificant relative to the rest of Idaho, Latah County, and Idaho County. In fact, if you combined all those two and grouped them into either one of those, it wouldn't change the inferences that we make on the data between Ada and Latah.
Can you turn to the next slide now? Tell the court which line represents which county and the color.
Sure, the darker line, the red line is maybe the easier one to see. That's Ada County, and the darker line, it's a blue or might look black on the screen, is Latah County.
And Judge, for your purposes, this is C1 that was filed with the reply, which is an update from the original memorandum to include a more recent date, the date that we filed, August 19th, the reply. So I don't know what one you're looking at, but the one on your computer screen is the one that we're talking about right now.
Thank you to tell me that.
Could you explain, Mr. Murphy, what the purpose of showing this over time does for the court?
Yeah, one of the more interesting charts that we develop for our clients is media coverage over time. And in this case, we're looking at January 1st of 23 through August 19th of 24. If you look at the red line, which is Ada County, you can see that aside from May 2023, it often lags by volume of coverage behind Latah County. In most cases, by 50% or more of the media coverage. So if I rephrase that in maybe simpler terms, the media exposure in Ada County for the majority of time between January 2023 and August, continuing into August 2024, has been far less in Ada County than in Latah County.
And what can you tell from the spikes? Have you correlated those with case events?
Sure. It might be convenient to look at it analogous to maybe a stock portfolio. Oftentimes a peak is followed by a valley, unless you invest in NVIDIA. But May 2023, you see 198 stories. I believe that highest peak for Ada County was the indictment is what's driving that peak. Now, when you compare that to Latah County, I can see that moving towards that indictment, there was ongoing media coverage. So while Ada spiked, it had a quick uptick in what I would call a fairly slow decay because of the extreme nature of the topic of the story. When we look at Latah County, it is more consistent. And after the indictment, Latah County surpasses media coverage over time consistently up through August of this year.
And this was filed with the court on August 19th, and we're here on August 29th. Have you been able to review and see what's going on with the coverage regarding this case right now as we sit here?
Yeah, I took a look Tuesday. I started seeing the media exposure ticking up again. It was fairly high yesterday. In my professional opinion, I would wager it's going to be extremely high today. And that's a function of public interest in an extreme news story. A story, you may have heard the phrase, this story has legs. A story that is extreme, unique, atypical, has greater legs than, say, high school football scores you hear on the 10 o'clock news on a Friday night. Those would have a very fast decay of memory on consuming viewers. This type of story will remain on the mind and be of interest up to and beyond the conclusion of this case, however that might be.
Would you flip to the next slide? This green line, what does it show?
It shows somewhat of a similar pattern across the entire country. It's the same date range. It's also showing media coverage over time, but it's looking at all media exposure nationwide. So while you feel things very acutely locally, even a story as extreme as this garners less interest the further you get away from the local community. And to look at this on a nationwide chart like this, you can see it remains in the mind, and these are large numbers. The indictment of over 13,268 or 13,268 media mentions on May 2023 shows that the nation was interested in it, but that decay has been faster on a nationwide level, just because according to the decay of engagement on news stories, the further you get away, the less, I don't mean to sound callous, but the less interesting it is if you're in Florida than if you are in Latah County or something.
So in terms of looking at decay, I want to ask this in the context of the story waning for the court's purposes of projecting, say, months down the line next year at trial. Based on the data that you're seeing, is this story waning in the news?
No. In fact, if we could make one more line on any of these media coverage over time charts, you would see an upslope on the first one, this chart. You already see it ticking up, the one that compared Latah to Ada. If we could bring that chart forward to today, you would see that going up, and that will be consistent anytime this case has significant news or a significant hearing in Latah and Idaho County. It will be of interest. And I would say that the delta or the difference between Latah and Idaho County will continue to be statistically similar. It will probably potentially always be of greater interest in Latah County than in Idaho County. Not to diminish the interest in Idaho County, it's just, I believe it's further away than Latah County from where the alleged crime was committed, or the crime was committed.
Is Nez Perce and Lewiston are they a part of Latah County's designated market area?
To my knowledge, yes.
What does that mean for Lewiston and Nez Perce to be a part of the designated market area of Latah?
That's real simple. If the population in another county or cities.
Nez Perce is a county, Lewiston is a city.
Okay, so the population of those, I guess, could you rephrase the question?
What does it mean for those for Nez Perce County and Lewiston City to be a part of the Latah County designated market area?
Okay, so that would increase the population of people that have opportunities to see the story within the same designated market area. So if you're in Latah County, you have the same potential to see the stories in Nez Perce and Lewiston. Does that change the mathematical outcome of the original pie charts we looked at? Those two counties combined with Latah County would have to exceed the population of Ada County in order for this dynamic to change. I don't know how many people are exactly in each of those counties, but if together with Latah County, they exceed 295,000 potential jury eligible jurors, then you might be able to say the impact from the media on those two populations, or exposure to media could be equal. But if Nez Perce and Lewiston are smaller counties and together with Latah are still significantly lower than Ada County, that's not going to change the determination I've made in this data.
I have no further questions.
Thank you. So, is it Ms. Beatty here?
Yes, Your Honor.
Thank you. Cross-examination.
Just briefly, Your Honor. Good morning, sir. Just for my own clarification, on those pie charts, when it says Latah County and Ada County, are you limiting that to the boundaries of the specific county, or are you talking about the broader designated market area?
When what we're looking at is media mentioned that impacted the county.
The county specifically?
Right. So,
Thank you, sir.
Yeah.
So in looking at those line graphs that you presented, I noticed that they started in January of 2023.
correct.
So December of 2022, Mr. Kohberger was arrested. Were you able to make any determinations of media coverage in December of 2022 at the time Mr. Kohberger was arrested?
We were not engaged nor tracking the media.
Okay. And that's not possible to go back and track that.
We can do what's called a back search, but we can't. Certain media types have expired. Online news links, social media might have been taken down. So you can do it. I wouldn't say I would present it with confidence.
Thank you.
I can show you a number.
Thank
but
you.
it's-
So fair to say, though, that there probably would have been a pretty substantial spike at that time as well.
I would say yes.
And possibly, although you can't say for sure, that spike could have been even higher than any of the other spikes on this graph, possibly.
The possibility exists.
Thank you, sir. So for the first 6 months on this chart of volume of media coverage over time for Latah and Ada County had more intense media coverage in January, February, March, April, May, and then June, and then in July, there's that crossover where Latah County is higher than Ada County. So fair to say for that first 6 months, Ada County did have at times fairly significantly more media coverage than Latah County.
Correct.
Okay. And council talked with you about these peaks and how they correspond with specific events in the case, such as court hearings. Would you expect that if the court were to make a decision to start closing certain hearings, particularly evidentiary hearings as we approach trial, that would be a mitigating factor that would decrease the amount of media coverage in this case?
I can't say yes or no on that. I would say it depends. If those closed meetings were a public record, then the media most likely that's following this would still have a high probability of reporting on it. They may just not have any image or interviews or some of the elements that go into a more engaging news story.
So the coverage might be less intense.
Intense is a qualification that I'm not able to make. I can't tell you how intense something impacts you as a viewer or a consumer.
Sure, thank you. And I noticed in that chart of Latah County and Ada County coverage that in the last couple of months, that coverage intensity in both of those counties has become pretty close again. Is that fair to say?
Yeah, yes.
And so based on these charts, it's really not beyond the realm of possibility that Ada County could again surpass Latah County in coverage, at least at certain points, correct?
Again, there's an equal chance of possibility. The probability based on the data, I would say is no, in my professional opinion. We've already seen an uptick, and it appears that in Ada County, the news is much more focused and attentive, even to what I might consider a less weighted story. I think there was a story recently about a memorial garden or something that this county garnered quite a bit of media exposure. But that's logical. Sure.
Well, in June of 2024, it looks like they got so close that they were just 2 points apart. Is that correct? Latah County just 2 points above?
Yeah,
And you're not willing to testify that there's a possibility that Ada County could potentially surpass Latah County in the future?
I'll absolutely guarantee that possibilities are always equally available.
Thank you, sir.
Thank you for understanding.
I have no further questions.
Okay, thank you, Ms. Beatty. Ms. Mathis?
Mr. Murphy, in terms of this discussion on Ada versus Latah, you mentioned the Nielsen rankings. Could you please tell the court the difference between what the Nielsen ranking is? And then I'll follow up with what Latah's is and what Ada County's is. So what's a Nielsen ranking?
Sure. So I don't want to assume that most people have heard of the Nielsen ratings, but anyone who's involved with selling advertising or the news media knows that Nielsen for more than 50 years has measured the top 200 designated market areas. New York City is number one. It's the largest DMA. The media in that market reaches the most people. And so it's a measure of how many active news consumers is the way I would describe it, are in a city or a city's area. I know we're looking at counties, but your designated market area here in Latah County fall under the radius, I think I mentioned earlier, Spokane, Washington. In Ada County, their designated market area is Boise, Idaho. A different deal.
And what's the Nielsen ranking of Latah County?
It's ranked 64 out
And
of 210,
and what is Boise?
97.
I have nothing. So I should follow up and say, in terms of how that's measured, 64 mean that is a higher rank than Boise at 97.
The DMA in which Latah County resides has far more opportunities for media stories to be seen based on the strength of the DMA. As you get down to the smaller DMAs, for example, Glendive, Montana, has historically been market 210 last. They have one CBS affiliate. There's just not a lot of news coming out of an area, a DMA like Glendive. But on the two counties you're talking about, they reside in a DMA that's 64 for Latah County. A larger DMA is going to have more media opportunities to be seen and more media outlets available. As you get to smaller markets, you have fewer and fewer media outlets serving there.
Nothing further. Thank you.
Thank you, Ms. Beatty.
Nothing from the state, Your Honor. Thank you.
Okay, may this witness be excused?
He can, Your Honor, and the exhibits that are with him can go for you for the court's paper file for the record.
Thank you. Okay, sir, you're free to leave or you're free to stay. Thank you. Appreciate it. You being here. Thank you. Thank you. They're very small letters.
I agree, Your Honor. It was really hard to get them on one page. Sorry about that.
Thank you. Why don't we take a quick break and maybe come back at 10:20. Okay, thank you.
Well, court is on break. Thank God that one is over with. There's going to be another one similar to him, but it's like we showed the graphs before the hearing even started. And it's like, how do you explain those graphs? And it's like, when the prosecutor asked, what's going on here? I don't know what's going on there. But anyway, when the prosecutor asked about, what about the media coverage and everything in December and stuff? Like, why don't you have that? Like, why don't you have that stuff, right? I don't know why that just went small, but we'll have it back up on screen whenever it starts back up again. Why don't you have the statistics for that? Right? And they don't have it because it shows that there was more saturation in other counties. So it's like, holy crap. Okay, let's get this back up. Okay, let me see how I can, there. We'll keep that up just so you guys can see. I'll move these over. This is what we are drawing for at the end of today's hearing. Sorry about the, that's my camera up above. So sorry about that coming into the picture. But anyway, let's see. I can't get it out. But anyway, that's my camera. But this is what we are going to be drawing for at the end of today's hearing. A $5 super chat gets you on the wheel and also very much helps support the channel so I can continue bringing you guys these live hearings and stuff like that. Carol, it says there is nowhere that isn't informed of this case. Yeah, I'm in Ontario, Canada. And in my area alone, there's thousands that know every in and out of this case. So Carol, it says, is that a double negative? I'm not sure what you mean by that, Carol. Kat says, need more coffee to stay awake. Yeah, like that was pretty boring. And the thing is it's so one-sided. Like even in those graphs themselves, when we went over it before the hearing even started, it showed that if you go by population, there's been more saturation in Ada County than there has been in Latah County. If you go by their own graphs, but it's like when you look at the graphs, they're projecting, it's almost like they're projecting something else. You know what I mean? But if you're good at math and stuff like that, it's like, okay, there's 5,000 people in Latah County that's seen it, but there's like 80,000 in Ada County that's seen it. You know what I mean? So it's pretty much equal. And that's, I don't know how to explain what I'm trying to say. So just hypothetically, say you got 10,000 people that live in Latah County. Out of those 10,000, 1,000 are very informed in everything else, right? That's 1,000 people out of 10,000. So there's 10%, right? Now, say Ada County, there's 20,000 people in Ada County. And out of 20,000 people, there's, I don't know, 4,000, 5,000. That's a lot more percentage-wise of people per capita that know about the case. So you got 3,000 over here that know so much about the case that may be called for jury duty, and you got 1,000 here. You know what I mean? So it's deceiving in a way, I find, because if the per capita in Latah County is 10% that know and could be jurors and blah, 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 and they know of the case, but then you go to Ada and there's 40% of the population that can be called as jurors, and those 40% know of the case and have followed the case, then there's a big percentage difference there per capita. So some of these are very deceiving. Teresa Jane says, I just made the biggest glass mason jar of iced coffee, complete with caramel drizzle and whipped cream. I'm so jealous right now. That sounds yummy. Yes, I think there is more people that have seen coverage in Ada County than there is in Latah per capita that are of being able to be called to the jury. Because don't forget, some of these people that are in Latah County, and I think it was Kat that made it earlier that said, a lot of those people are gone for the summer. So you're not getting, so they're gone for the summer, so they're not seeing all the information. Whereas in Ada County, those people are still there 24/7, 365 days a year, and they're all still seeing it when Latah isn't. You know what I mean? So, but they're not showing that. And we've seen clearly on the graphs that there is a higher uptick right now in Ada County over the last 4 months than there was in Latah County. So there's more interested people right now in Latah County than there is in Ada County. In Latah, hang on. Being in that one video where they showed the last 3 to 4 months has been a higher uptick of people that are following this and watching this in Ada County than there is in Latah County. Latah County kind of dropped again. And in the first 4 or 5 months of this case, after Bryan was arrested, Ada County had a higher by thousands on the scale than in Latah County. Where Latah County went higher on the scale is when there was a court hearing, which is normal. People that live in that community want to know what's going on in their community. And there's a huge uptick only when there's a hearing. Otherwise, they are pretty much equal. And now, actually, Ada County has overtaken with saturation Latah County over the last 3-4 months, right? But they don't want to talk about that. Well, they should have, but there was a lot of those months, like 3-4 months at the beginning, and these last 3-4 months where there is more coverage and more interest in this case in Ada County than there is in Latah County. Right at the beginning of the case, and now as we're getting close to trial, there's more interest in Ada County than there is in Latah County. And it shows it on their own graph. And then when asked about the graph for December, oh, well, we don't have that. Why? Was it right off the charts for Ada County and they don't want that in there? You know what I mean? But I mean, this case is off the charts, even here in Canada. Like, there's only one other comparable one to this in that we, as like me and other Canadians, was the oh gosh, oh, I got a brain fart. The only other one that was this big in Canada was what's her name there? Her boyfriend killed her on the van trip thing. That was another big one here in Canada. Like, speaking as a Canadian, that one in comparison is pretty much in comparison to this. Like, it was all over. Anyway, it was funny. The other day I was watching an American and he was covering Gabby Petito. Yes. Thank you, Kay, Mitch, and Charissa. That one was huge here. Lori Vallow, Chad Daybell was kind of, sort of like, if you ask somebody, hey, did you hear about the gate? No, not really. You would get the odd one, but ask about the Gabby Petito case or this case, and it seems everybody around here knows about it. Right across Ontario, Canada, anyway, like, because I got friends that live all across Ontario, and it's like, yeah, it's big news here too. It's big news, big news, big news. And the only other one that I found was as big as this was the Gabby Petito. Anyway, there's this US vlogger that I guess he covers a lot of criminal stuff in the US and criminal cases and that. And he tried to get information on some cases that have happened here because they think around my area here, Ottawa area, that we have a serial M going on where there's been 3 or 4 women that have been attacked. And he's trying to get information on the case and he can't get nothing. Nothing. Because here in Canada, we don't have lax laws like in the US. Like in the US, you can look up somebody and get their whole criminal history and where they live, and you can that doesn't happen here in Canada. So he was a little frustrated, I will say, at the least. But he was writing to Parliament here and everything, saying that he wants information on these cases and it should be available. But it's like, and they wrote him back saying, we're not the US. But so that's just like, for in comparison, you guys, like I cover a lot of the cases in the US because of that. We don't have, even as Canadians, we have a freedom of information here, but you get next to nothing. Everything's redacted. Everything's redacted. So what's the sense, right? You can't get to 99% of the information you can get on somebody if you're in the States. Here, you're lucky to get 1%. You don't get their criminal history. You don't get, like, we can't go in and see court filings like we can in the US. You can't do any of that here in Canada. So it's odd. And now that our Prime Minister has put a kibosh on us sharing or finding Canadian news and even US stations, we're blocked from seeing it. We're blocked. Like right now, if I try to share with you, actually what I tried to do the other day, there was something here in Canada and I tried to share, like go to the station to try and get it so I could share with you. I can't get it. I have to watch it on TV. If I go to like Global News or something like that on YouTube, I can get Global News and watch it, but I can't share it. It's weird. It's really weird. It's really, really weird. It's like we're becoming a communist country here. Trudeau's got to go. That's for sure. I don't think he's going to win in the next election, to tell you the honest to God truth. And it's funny because he's the son of one of our good presidents. His father was a president, prime minister. His father, Pierre Elliott Trudeau, was our prime minister for many, many years. And now Pierre Elliott Trudeau, his son, is Justin Trudeau. And I swear to God, he got in because of his looks. Everybody was going gaga over how good looking he was, but his wife's now left him because he's a cheater. And anyway, it's like I don't even turn. If I do turn on the news, it's only for the weather, and then I don't listen to it anyway. I jump on YouTube and go watch Ryan Hall. And I watch his radars and everything to see what we're going to get here, and that's more accurate than our own. So kind of ironic, right? But yeah, I'm hoping that Justin Trudeau gets out of office at the next election because he's trying to mute us. And I mean, I'm surprised he doesn't want us to have chips in our arms so he knows everywhere we go. But it's been horrible. It's been horrible for us Canadians, especially for people like myself that are on YouTube. He's even trying to restrict us now on YouTube. So I can't guarantee that in a year from now, my YouTube channel is going to be here. I may be restricted by my prime minister, which means all he wants, if you're a Canadian YouTuber, this is one of the bills that he's trying to pass. If like myself, I'm a Canadian YouTuber, he wants it that I can only discuss Canadian events. You know what I mean? It's like, what? It's crazy. And if my channel plays US content, then I'm going to be banned from being able to have a YouTube channel if I'm Canadian. It's crazy what this prime minister of ours is trying to do, especially to people like myself. Let's not discuss politics. My kids stop speaking to me. But yeah, so there's a lot of restrictions he's trying to put on us, and it's horrible. So when I do say, you guys, that I'm having a hard time getting information, now you know why, right? So I'm very thankful for those of you who do come to my rescue when I ask if you guys have any information on something, to share it with me, because I can't access it unless it's shared with me. So, okay, looks like they're coming back. Well, now we get to see the behind the scenes workings of what they can do on their Zoom thing. Layout, reset, sections, new slide. Find, replace, select. They can choose how many cameras they have. That's pretty cool. I've never done a Zoom, like hosted a Zoom, so this is the first I'm seeing behind the scenes designs and whatever for it. So it looks like they're getting ready to come back here, you guys. I see their pointer. That's not my pointer moving on the screen. That's theirs. There we go.
All rise.
Okay.
Please be seated. Okay, let's get that on the record, please. Back on the record, State versus Kohberger, CR 2922-2805. Sorry for the delay. I think we had to adjust some mics, make sure everybody can hear. And counsel and Mr. Kohberger are here in the courtroom, so we're ready to go forward. Next witness.
Thank you, Your Honor. We will call Dr. Anani L. Alili.
All right, thank you. Thank you, ma'am. Please raise your right hand.
Do you solemnly swear or affirm that the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth under penalty of perjury? I do.
All right, thank you. Please have a seat, and then please state your name and spell your.
Her name's Anani Alili. Last name is EL-ALAYLI.
Thank you. Ms. Taylor.
Thank you. Good morning. I can see you brought some papers to the witness stand with you today. Will you identify what those are?
Yeah, it's just copies of the slides. It's nothing. None of them in case I couldn't see.
Okay, and if the slides, does that refer to the PowerPoint presentation that you for us to share today?
It's
okay. At this time, will you place that document in front of you face down? And if you have difficulty seeing the slides, let me know and we'll have you turn it over so you can track and help us understand what you're going to teach us today, okay?
sure.
Yeah, I want to make sure then the state has stipulated to admit that.
That's correct.
Those slides. Okay, thank you. So all the slides that we might be considering today, you agree to.
That's correct.
Okay, thank you. Go ahead.
Thank you, Judge. Will you tell us what you do for work?
I'm a professor at Eastern Washington University.
What do you teach?
I teach social psychology, which is the study of how people interact with each other and influence each other, how we're all affected by social situations.
I'm going to ask you some questions so that I can understand your background that led to your ability to teach. But I want to know if you're here today in your capacity as a professor or in your separate role as an expert consultant.
And here's my separate role as a consultant. So what I'll be talking about today is based on my expert opinion, based on the research I've conducted and what I've learned about in the field, and it's not affiliated with the university.
Thank you for that. Now let's go to your education. What degrees do you hold?
So I have a bachelor's in psychology, and I have a master's and PhD in social and personality psychology, with a focus on social psychology.
What does that mean, a focus on social psychology?
So our area, like I mentioned, it studies how we interact with and influence each other, the power of the situation and how it affects us, like how we're all behaving differently here than in our living rooms. It includes things like how people influence us to purchase things. Like I teach a class on social influence, or influence us to donate money. And then my specific area of focus is on social cognition, which is how we select, remember, and interpret social information.
How long have you been teaching?
I have been teaching since before I graduated from my PhD, so since the late 90s. But I started my positions as a professor in 2002.
2002?
2002 at University of Florida, 2003 at Eastern Washington University.
In your role as a professor and a professional, have you written articles and been published?
I have
How many, roughly?
roughly 15, give or take.
Do any of those relate to human bias?
Yes, most of them. So a lot of them are focused centrally on bias, and then many of the others are tangentially related to bias. So it could be biased perceptions of ourselves, how we tend to overestimate ourselves in a lot of ways. It includes biased impressions of individuals, like you might take one thing about a person and make a whole bunch of conclusions about them when you don't know them. And that could influence how you perceive their behavior later on. It includes biased perceptions of groups, so stereotyping and prejudice. And I've also studied biased impressions of businesses.
Have you consulted as an expert in other cases besides Mr. Kohberger's case?
Yes, I consulted in a case around 2016 or so, and then I was involved in the non-dissemination hearing here as well for Mr. Kohberger's case.
So you're telling us that you've testified before in Mr. Kohberger's case. Is that correct?
Correct.
And have you testified as an expert in any other hearings besides that one for Mr. Kohberger?
For Mr. Kohberger, no, just that one.
How
One-
about other people?
Yes, one for, in the case I didn't seek it out. I have a full-time job, plenty to do. But I've been asked to do expert testimony, and I feel like it's the right thing to do to share what I know about bias.
Thank you for that. What is your role today? What did we hire you to do and ask you to do?
So my role was to evaluate how publicity about a case could shape potential jurors when they come in and sit on a panel, and to see if maybe people who were living in Latah County or have some connection to Latah County might potentially have more problems being objective because of media saturation and other issues.
Did you prepare a PowerPoint to help walk through what you have to share today?
Yes, I did.
I'm going to do my best to open that up. I am trying to find the right.
You would just go to slideshow, right to the top, maybe 6 down to the right. One more, right? And then on the left, or just from beginning.
Okay. I think we're there. Thank you for helping me through
I
that.
do this regularly. I'm teaching.
All right. I want to know if this is the background of the research on potential juror bias. What do you know about that?
Yeah, so there's been a lot of research on how publicity affects potential jurors. It says roughly 40 years. Really, it's been longer because in the 1960s, there were some high profile cases. And so social scientists wondered, does it matter if there's a lot of publicity about a case? Could that potentially make jurors less objective? Could that influence actual outcomes in a case? And so the research started then, kind of trickled in, and then became more and more popular. And then in 1999, there were enough studies that somebody conducted what's called a meta-analysis. And another one was conducted in 2022. So it's nice to have a recent one. A meta-analysis is when you take a bunch of studies on the same topic and you statistically combine them into one giant study. So they do this in every field. They do this in medicine, every discipline, where you really want to know an overall effect of something. Because I might run a study on the effects of pretrial publicity and find maybe a small effect, and somebody else might find a big effect, and somebody else might find no effect. And it's hard to trust any one study with, a few dozen participants, or even if it's hundreds. I would want to see lots of studies. Just like if I were trying to decide if I want to take a medication, I don't want just one study that tells me it works or doesn't work if I have a serious illness or the medication has serious risks. But I would be much more confident if there were a whole bunch of studies, dozens of studies combined, and thousands of participants' data. And so a meta-analysis basically does that. It narrows down a specific topic, in this case, the effects of pretrial publicity on judgments, and it examines overall, combined, is there an effect? And so there were, like I said, one is quite recent from 2022. So it's the simplest way to describe this research. It's the easiest way for somebody to know where it stands, even if they don't read all the articles. And what this work has found is that if somebody's exposed to publicity about a case, something about the defendant, something about the case, fact, fiction, that the tendency is, if you look at everything as a whole, for it to affect judgments, and specifically how much you like the defendant, your inclination to say that they're guilty, your judgments of their criminality, etc. And this has been shown with individual judgments of guilt, but even more so with group judgments, with juries. And it looks at participants who are randomly assigned to get pretrial publicity information or not, so that you can really determine cause effect. So this would be a formal experiment. We do lots of studies, and experiments are the ones that I like to look at, because what you do is you hold everything constant except for one thing that you change. You get one people, one experience, another group of people, another experience, and then expose them to all the same things. So all the same trial stimulus materials. And you see, okay, the people who got some information ahead of time that they weren't supposed to pay attention to, did they evaluate the evidence differently? Did they come up with different judgments? And so the meta-analysis in 2022 is based on over 11,000 total participants, and it summed up the studies on that specific topic.
And the sum up, what was the sum up?
Yeah, essentially what's on the slide there are the main findings. The fact that if you get exposed to publicity, you're more likely to render a judgment of guilt, and less likely to, or have lower liking for the defendant, and have higher ratings of their criminality.
Based on your years of teaching and work and understanding human bias, do you know why this happens?
Yes, if you don't mind advancing to the next slide, I have a couple sections here. One is on why we sort of soak up this pretrial publicity in the first place. And then the next section is on why that stays with us through a trial if we are to serve as jurors, even when we don't want it to stay with us. And so if I'm to start with the first topic, why is it that we soak this up in the first place? One reason is because of how we process information. Since the 80s, social psychologists have studied this model that suggests that it's pretty straightforward. Sometimes we think deeply about things and we scrutinize arguments and find flaws in them. And then sometimes we make quick decisions. We like decision shortcuts. And we only have so much cognitive capacity that the vast majority of our decisions and thought processes are more automatic. And we call this peripheral root processing when it involves an influence situation. So if you're making some kind of determination about something, whether you should purchase a certain car or vote for a certain political candidate or something like that, you can go through and you can analyze every single thing and try to be as objective as possible, or you can make a decision in 2 seconds. Oh, my neighbor has that car and they like it. And so the problem with peripheral processing is sometimes you're going to come to a conclusion that you wouldn't have come to before if you had thought about things more methodically, more systematically. And so the reason this applies here is because people, when they're consuming media, are often processing peripherally. Why? Because they might not be completely able to focus on a story, or they're scrolling quickly through a newsfeed. So if you're scrolling through a newsfeed or a social media feed, or if you're watching the news while you're cooking dinner or something like that, you're taking in information, but you're not able to really devote the resources cognitively to nitpick. And so you'll see something like Bryan Kohberger arrested for the murder of 4 students, or you'll see something like this: among items taken from suspect, knives, guns. And automatically, when we're processing at the superficial level, which again, most of the time we're doing, we'll say, oh, okay, so they found the person who committed the crime and they have evidence. And we don't take it a step further. But if you actually stop and think, then you realize, oh, wait a minute, people get arrested all the time and it turns out they didn't commit a crime. Or wait a minute, we all have knives in our homes, but we haven't all killed somebody. I have a lot of knives in my kitchen. A lot of households have guns. And so we don't take that extra step to really think deeply about things a lot of the time when we're consuming media.
It sounds like you're telling me that we're just absorbing information. And in Mr. Kohberger's case, from the media, people may take bits and pieces, and that starts to create a level of knowledge or human bias.
We might feel like we know about something more than we do, yeah.
Are there other ways that bias gets created?
Yes, and it looks like you advance to the next slide. So one thing that's relevant here too is listening to authority figures. So I mentioned that we're processing superficially a lot of the time, peripherally, and one readily available peripheral cue a lot of the time when it comes to this type of situation is hearing information from authority figures, people who have status or expertise, any kind of power, and we tend to listen more to people in those positions. And yes, a lot of the time they have more knowledge, but there are big problems with this. One is that we assume that they're accurate. We forget that they're humans too, that they make mistakes too, that they have biases too. Like if I'm in charge of trying to make a community feel safe by, arresting the right person for a crime, I have a motivation. I want to make sure, I want to convince myself maybe that, I've caught the right person. And, if I'm in that position, doesn't make me less biased, right? We all have biases, all humans have biases. And so, and they also could be wrong. Like I said, people can get arrested for a crime when they didn't commit it. And what we found in research over many, many years, decades, is that if somebody has any kind of indicator of authority, even if it's something as minor as height, but certainly, an occupational status, title, that people will take their words so far that they'll do things to contradict their own morals, and they'll be influenced in areas beyond the person's expertise, like a doctor influencing you in your relationships or something that's totally irrelevant. And so we take it a little bit too far. And in the case of Moscow and Lake Tahoe County, it's a really small community, right? And so the authority figures are often going to be people who are known and well trusted. And, so that makes this effect even potentially more problematic. And, as you know, Chief Fry, the chief of the police at the time, had said that he was certain that he arrested the right suspect and he didn't have any doubts. And so the community would say, okay, well, the chief of police is sure, so then I can be sure too. But like I said, we can't assume And there's no trial that had taken place yet. And so we can't assume that that's accurate information, but we tend to take that a little bit too much at face value.
The example that you gave of the police chief speaking out and offering what he thinks about a case, is that something that creates more bias in the minds of the Lake Tahoe County residents that heard that?
Yeah, I mean, they're familiar with him. They know him to be an authority figure. They may know him personally or trust him personally. And so, yeah, somebody outside of Lake Tahoe County, they'll still be affected by his authority status, but maybe not as much, right? And then he also has power over people in that community, and that seems to carry some weight when it comes to this type of influence. And then also, the president of University of Idaho saying, we can feel safe now, they found the person. It sounds very conclusive when there hadn't been a trial yet. And so another authority figure is pretty major in an area like Lake Tahoe because so much is centered around the university.
Are there other ways that you found that create bias?
Yes, if you don't mind advancing to the next slide. This is the phenomenon that goes back maybe a century. We've been studying this in so many different contexts, tons and tons of research on this phenomenon called classical conditioning. And it's basically when we make associations between things and it causes us to have reactions that we didn't have before. Like, for example, if your alarm clock, we don't really have alarm clocks that much anymore, but if your alarm sound on your phone, if that's what you use, wakes you up this morning and you have kind of a negative response to it, it might be because you associated it with waking up before you wanted to. Before, I know I always try to choose a sound that I don't have an aversion to, but then it doesn't take long before now I have a negative reaction. So you make this connection, right? But if that same tone was used every time a loved one texted me, then I wouldn't develop an aversion. I might develop a favorable reaction. So classical conditioning is when we develop a response to a stimulus. It could be a sound, it could be any stimulus at all, including a person, because we've connected them with something that it has been paired with, especially repeated pairings. So in this particular case, if the defendant's name is seen throughout media and social media a lot, or his image is shown alongside things that are aversive, negative words, things like terror, murder, evil, or alongside known killers, alongside details of the murder, alongside information about, tragic consequences, things that make us feel bad. What happens is it doesn't take that many pairings, and then his name alone, which was once neutral, because most people wouldn't have known him, becomes conditioned, and it evokes those same kinds of feelings. And they've done studies like this where they can make this happen within minutes. If I could take a picture of any of you or multiple pictures of any of you, show those interspersed with pictures of other people, and at the same time present words, consciously or not consciously, that say things like terror and evil, and at the end of the study, I can ask people, what do you think of this person? And the rating will be lower. And so if you get that exposure a lot, like in Lake Tahoe, where people are getting a lot of media exposure and also social media exposure and having a lot of discussions and attending, vigils, and they're really being exposed to kind of all these emotional reactions. If they're thinking about him at the same time, they can't help but make that connection, even if they don't think he's guilty.
Let me make sure I understand how big this is, how far-reaching this is. We've been with this case pending for 1.5 years, and there's been, suffice to say, a lot of media coverage. There's a lot of pictures of Mr. Kohberger in the media. Do you mean that when we walk into trial and the room's full of potential jurors, there's going to be a great majority of them that before we sit down are going to have a feeling of bias against Mr. Kohberger?
Yeah, I do. And we've seen the pictures, these ominous headlines, and that connection can't help but be made.
This all the way that bias gets created, or do you have another one?
I have one more. As far as things that happen largely while the publicity is coming in and you're getting exposed to it. And it's sort of a category of a lot of different influences that are emotional and motivational. And this one I think is especially relevant to, sourcing people out of Lake Tahoe County to be jurors. So the media played a role and inducing some emotions like it does. It likes to attract attention, things like fear and anger and sympathy and empathy. But in that community, people are going to have those emotions anyway from everything that's going on. But if the media uses phrases like killer on the loose, everybody stay vigilant, make sure you report all suspicious activity, then they're arousing that even more. And so what happens is when we have emotions like that, they filter in how we process information. Just like when you're angry, you're more likely to remember things that have made you angry in the past than things that have made you happy. And when you're angry, you're also more likely to have kind of an agenda with new information coming in. And so, for example, and this is something that could stay with somebody, this distorted information processing could stay with somebody and could get, there could be a resurgence during a trial where it keeps affecting somebody as they are reminded of their emotions. Because, they've associated moods with different judgments of guilt. Like, for example, if you're angrier, you tend to be more punitive and you want retribution. And in fact, in one study, they associated anger of mock jurors during a trial with support for imposing a death sentence for somebody. And they, when they were angry, they were less likely to pay attention to defense arguments. So people aren't trying to be biased. It's just that when we're in moods, those moods filter how we process information, how we take it in. And, I think I may have mentioned this already, but there's also kind of an emotional, motivational component to feel like the person who committed the crime is under arrest. It is the right person. I think I mentioned it as, being a motivation by the police, but the community has this motivation too in Latah because they were living in fear during all these weeks where they were trying to find somebody to arrest. And somebody was arrested and people could take a sigh of relief. But that sigh of relief assumes that he's guilty. And so we have this coping mechanism, basically, where we want to get rid of these negative emotions. And one way to do that is to feel like, oh, well, if he committed a crime and he's under arrest, then I can feel safe now. And so that's something that could come into play too if you live within the region where the event occurred.
And that's because of the fear that was associated with
any of the emotions really could potentially distort information processing. That last point relevant to fear, but a lot of research on how anger influences judgments and how sympathy for victims, empathy for victims influences judgments. And certainly if you are in Latah and have attended vigils or offered social support, that you're really getting a lot of that empathy and sympathy as well, or if you're exposed to the personal media stories about what happened.
So I think I understand the ways that the human bias just gets bigger and more solid in a person. What happens if we seat a Latah County jury and those biases aren't there? What happens as we put on the trial and evidence is presented?
Yeah, well, I mentioned this one can get carried through the trial, this idea of motivational and emotional sources. But there are other things that can happen during trial too that kind of exacerbate the problem. And one of these is confirmation bias. So this has to do with us wanting to confirm our expectations of things. And one of the most fundamental human needs we have is a need for predictability. You don't want to walk into this courtroom and feel like you have no idea what's going to happen. That's uncomfortable. We want to feel like we know what's going to happen, and we know how people are going to behave. And so part of this need for predictability is that it causes us to distort reality a little bit. And so in one way that this does this is through the confirmation bias, which is once we develop an expectation of something, once we decide that this is true, this is the case, or the defendant is guilty or not guilty, or the defendant lives a certain lifestyle or behaves a certain way, or has, then once we decide something, everything goes through that filter. I talked about an emotional filter. This is a cognitive filter that we actually process information differently based on what we expect to see and hear. It's just like if, you're going to meet up with a friend and you think somebody called your name, you expected it. And so it made you hear it even when it didn't happen. And if somebody does call your name, you hear it more readily. So we're kind of tuned in. And so the processes I mentioned here, this filtering can happen via 3 different processes. One is selective attention. So if I'm a juror and I have expectations about Mr. Kohberger, it doesn't have to be just that he's guilty, but it could be expectations about him as a person. if I have expectations coming in and I'm getting all this new evidence during trial, going through that filter, I'm paying attention to information that backs up my idea. Well, I have this idea that he's a bad guy, and this information backs that up. So I pay extra attention to that. And then they talk about something where, where he was kind to someone, and I really have to pay much attention to it. So, we have this filter, and then we process information too in a distorted manner. We actually will change the information to fit in with what we think. It's just a way of our minds simplifying our worlds. And while these processes all help us not be overloaded cognitively, they distort what we take in. So we have to be aware of them. And recall is distorted as well. So, a trial takes place over a long period of time, potentially, and somebody has to remember a lot of information. And if they have distorted recall that's consistent with their expectations before coming in, that's obviously problematic.
Is that the only thing that happens when we have new information at trial?
No, I have a couple other things that I'd like to talk about. And the first one is belief perseverance, which is really a direct consequence of the confirmation bias. So it's just like it sounds. This is the tendency for our beliefs to persevere, even in the face of contradictory evidence. Confirmation bias supplies us with this filter. And because we have this filter, if somebody gives us all these facts that go against what we think, logically, we should just change our minds. A lot of the time we don't. In fact, there's some evidence to suggest that sometimes we even cling more closely to our beliefs. And anyone who's looked at anything on social media has probably seen evidence of this, where somebody has a strong belief about something and then somebody provides actual facts that contradict it. And then instead of saying, oh, you're right, I see your point. Of course, that can happen sometimes. The general tendency is for people to still stick with their beliefs anyway because they formed them. When you're in the process of forming your beliefs, that's different. But once you've formed something, it tends to stick. It's the same thing with stereotypes. Somebody has an assumption that elderly people are bad drivers, and they see a whole bunch of evidence suggesting otherwise, and even research studies and things like that. Then they no, I still think elderly people are bad drivers. So that's belief perseverance. And in some cases, people will even double down. Again, social media, they might even get more aggressively in line with their initial opinion after seeing evidence to the contrary. So this is one reason that's directly aligned with confirmation bias.
It sounds like they can work together when somebody already has a bias. They've already made decisions about it.
Yeah, really any expectation or decision or judgment, even if you don't know that you have it. I heard the phrase of growing legs. Well, there's a famous social influence researcher who used that same phrase with decision making. Like once you've decided something, your decision grows legs of its own. And so now it's not just the normal information necessary that for any rational person, because we all kind of have this tendency to be irrational in situations like this. But it ends up causing us to distort reality a little bit and need a lot more evidence now than we should to change our minds.
What else impacts getting new information during the course of the trial?
We'll advance to the next slide. I want to mention a little bit about cognitive dissonance. And cognitive dissonance is an uncomfortable feeling we have when we have like an inner clash, like an inner hypocrisy, like if I'm religious, but I don't adhere to one thing about my religion, and then there's this inner clash, and we don't like that feeling, and we like to reduce it, minimize it, prevent it. So why is that relevant here? Well, if somebody lives in Lake County, they might have a dissonance experience because if they start during trial to believe that, oh, maybe the defendant is innocent, maybe he shouldn't be convicted, that belief might be battling another belief about loyalty to their community because they know the community wants closure. They know that the community wants him to be guilty. They know the community wants to feel safe. And so they have this inner clash. And what happens when we have this inner clash, lots of things can happen. But one thing that could happen is we could distort reality. That's another reason for kind of being a little bit less accurate when taking in information. So if I'm a juror from Lake County, and I'm starting to kind of think, oh man, maybe he didn't do it. there might be part of my brain convincing me that no, he's guilty because of this inner clash. I want to get rid of the clash.
Is that because of the loyalty a person would feel to Latah County, to their community?
I think that's a big part of it. And there could be other reasons with regard to community connections that could create that clash too.
Like a concern that they might be known who
Yeah,
they are as a juror?
a concern that they might be known. They're this kind of picturing yourself sort of coming back to your community with the news that you were involved in a process that actually, acquitted somebody, for example, and having to face people in your community, which is something I touch on later a little bit too.
All right, should we move forward?
Yeah.
All right. I know the court's gonna want to know, can we fix this?
Sure.
Can we get our jurors in here and tell them, don't bring your bias in? Can we fix this? What do you
Yeah.
think, knowing what you know about human bias?
I would love that to be the case. I just don't see that as feasible when bringing jurors out of Latah County. And I can tell you some problems with all the methods that people try to use. It's just, if you look at the research, there are limitations to these. And so one of them, of course, is juror selection. Let's try to find people, for example, who haven't been exposed to publicity. So there are problems with that. Can you recount all of the publicity that you've been exposed to? No. If I asked you to tell me about all of the interactions you had with people over the course of a week, you're going to have forgotten some, right? But doesn't mean they're not going to be affecting you. So maybe when I was at the grocery store, the person checking me out had a negative expression on their face, and I didn't recount that to you, but maybe that memory is there and it's buried. And when I go back in the grocery store, I'm a little colder to them. And another possibility too is that retrieval cues can make some of these unconscious memories actually become conscious, and maybe they affect us at that level. So if I'm a juror and I'm sitting in and hearing all of this evidence, something might remind me, oh yeah, and I remember they found this information, and maybe it's something that's not admissible, but now it's affecting me. And I didn't report that I knew that because I didn't remember that I knew it until something cued that up. And so that's a retrieval cue, is basically something that reminds you of what you know and can't articulate yet, or maybe don't have knowledge about it at a conscious level. And so there's a problem with that, picking people who haven't been as exposed to a case. And of course, in Latah, we talked about the saturation of media. It'd be hard to find somebody to even say that, but if they say that, I don't know if that really would be something we could rely on as being totally correct. And then this is something I focus a lot of my research on, and it's bias. So there's a lot of research on how we overestimate ourselves. We have overconfidence. We tend to rate ourselves as better than average, like better than average in intelligence. There's one study where the vast majority of people rated themselves as better than average drivers, but we can't all be better than average. And it included people who had gotten into multiple car accidents. So while people might be thinking that they're making an accurate assessment of themselves, when they're asked, hey, do you have any bias, for or against the defendant? Do you have any, or are you capable of setting aside your bias? People probably often believe that they can set that bias aside. Because it's in line with all of this research that we know about how we tend to overestimate ourselves. So they're going to say they're less biased than they are. That's been shown over and over again in a lot of settings. And by the way, the people who are the most biased have the most distortion when they're estimating their bias in at least some cases that they've studied so far. That's the research I've done too. And then also they're going to be biased about how much bias they have. That's called the bias blind spot, which has been studied too. So I might acknowledge that other people might be biased, but I won't be biased, and then I'll be capable of setting it aside. So that's one process, jury selection that we would hope would work, but there are a lot of drawbacks to it. So I wouldn't rely on that.
Do you think that it's less likely to work in a situation like this with the amount of negative media coverage that has been going on for a long time?
Yeah, if you ask somebody from Latah County to forget everything that they've heard about the case, forget all the discussions they've had, forget all of the media they've been exposed to, forget all the emotions that they've experienced, set all that aside. I mean, can you really do that? Can you unhear things and unfeel things for an extended period of time to be objective? That's quite an undertaking. So yeah, I think that's problematic.
You mentioned extended period of time. This trial is projected to take 3 full months. Is that what you mean by extended period of time?
Yeah, really. The longer it is, the more potentially distortion there can be because your decision has grown legs and things are getting filtered through filters. And then emotional things can carry a little bit more longevity. So I wouldn't expect it to just go away if it's a long trial by any means, but I'd expect to see it in a short or long.
Is there anything else that can be attempted that might or might not work?
Yeah, my next slide is on instructions. You know what? And of course, people would want to try to give instructions to jurors to be unbiased. And like I said, people overestimate their ability to do this. They don't even think they're that biased to begin with. And the first step to not being influenced by bias is to acknowledge that you have bias. So there's already an obstacle there. And then you have to have the motivation to not be biased. And I hope jurors have that. You also have to have the cognitive capacity to be unbiased. And that's where we run into a lot of problems because their cognitive capacity is going to be occupied by serving as a juror, paying attention to information. They don't have time to spend 80% of their mind, trying not to be biased and catching all the bias. And in fact, there's research that suggests that when we try to suppress thoughts, that we can think about them even more as soon as we let our guard down, which is very soon because you have to think about other things at some point. So if I try not to think about something like an argument I had with somebody, or somebody tries not to think about cigarettes, but they're trying to quit smoking, they could do that for a really short amount of time. But as soon as they think about something else, their mind gets flooded with those thoughts. Because in order for you to not think about something, you have to think about it so that you can catch those thoughts. And that process is automatic. Most of what I've been talking about today is unconscious, automatic processing, and that's why it's so hard to control. And with regard to instructions to disregard information, whether it's something that people learned pre-trial or something they learned during trial that turns out to be inadmissible, the research shows that those instructions typically don't work, and sometimes they can backfire, partly because of this thought suppression rebound effect. And then there could be other reasons too, like people not wanting to be told how to think. And I mentioned too that, it applies to emotional information too. So factual and emotional pretrial publicity would still have influence, even if people say, don't let this affect you. I wouldn't assume that works at all, unfortunately.
How about jury deliberation? Will that work if you have a juror in there who's going to maybe accidentally bring something in or interpret something based on something they heard before, or they've remembered something over the course of trial? Will the other jurors push it out, help them not to think about that? Will the group overcome that bias?
Yeah, so we would hope that you get a bunch of people together who are trying to be objective for them to sort of correct each other. And while some of that might happen, what the research has shown is if some people are exposed to pretrial publicity and some aren't, that can spread. Because you can't expect a juror to remember where they learned things. Like maybe they have information about DNA evidence and some of it came from trial and some of it didn't. And how do you disentangle that? That's really, really hard to do. And so they might spread it unintentionally. It might be spread intentionally too. But even if we're assuming perfect jurors here, it might spread unintentionally and then sort of contaminate the jurors during discussion. And then there's also this phenomenon we've been studying for a long time called group polarization, which is when you get a group of people and if they're leaning towards a particular opinion, when they discuss a topic, that opinion gets stronger and stronger the more they discuss it. Another thing you could see potentially on social media, like groups that, are invested in a particular issue. And so if the group is leaning towards negative judgments about Mr. Kohberger or judgments of guilt or anything, even a little bit, then discussions could actually make it worse and worse over time. It could get polarized. So I don't anticipate that discussions would fix the problem. In fact, I would expect it to exacerbate the problem. And that might be why in that meta-analysis I talked about, the effect of pretrial publicity was stronger when it came to group judgments, verdicts versus individual judgments of guilt.
Based on your years of teaching human bias and your extensive study of human bias, do you have an opinion about whether the extensive pretrial publicity has impacted the Latah County jury pool?
I do. I think it would be so hard to be a member of that community and be able to come in and be objective, and arguably impossible. So we don't have a known method for undoing things, and the things have been done. They've felt the emotions, they've seen the publicity, they've had the discussions, they've been to the vigils, and even if they want to be as objective as possible, and even if we disregard some of the limitations I talked about before, research has not uncovered a way to undo this after it's there. And so the recommended best practice by the vast majority of researchers on this topic is find people who don't have that information, restrict that information in the first place. Find people who don't have that information. And the same goes for that emotional experience and investment and so on. Utilize jurors who've had less exposure, they have less reason for prejudgment, less motivation to find the defendant guilty. It doesn't affect them, their feelings of safety, the community. They don't have to worry about reporting back, and other people maybe ostracizing them if they didn't make the judgment that was expected or wanted. And so my recommendation would be to find a community to recruit jurors from that's as far removed from Latah as possible, physically and psychologically.
Thank you. I don't have any other questions for you, but if you hold on just a minute, I think Ms. Katie might.
Okay.
Thank you, Ms. Taylor. Debate.
Your Honor. In any jurisdiction where there's been a tremendous amount of pretrial publicity, at least some of these biases would apply to a prospective jury pool, correct?
Yeah.
And the best thing, if I'm understanding your testimony correctly, for this trial would be to have a jury pool with the largest percentage of jurors who hadn't formed an opinion on this case already. Would that be fair to say?
I mean, you need, I can't speak to percentages. You need somehow to find enough people to serve on the jury who have not been exposed. Now, this is a high profile case, so we know that exposure is all over the state, and of course, this is part of it. But if you can have less exposure, you have less bias potential.
In a case like this, where there's been so much exposure across all counties, are there unique challenges in selecting a jury that would apply anywhere?
So, well, I mentioned some unique things about Latah County and emotional investment in the community, concern for community members, and having felt that fear and wanting the defendant to be guilty so that they could resolve the fear and anger. So there are all those emotional and social connections, and of course, Dr. Edelman's report, which will come up later, shows that a lot of people who live in Latah County are connected in some way to the university or the police involved in the case. So they actually, know people or they lived in Latah County. And so those kinds of things make, because it's such a small community, make Latah a unique experience.
And so you've reviewed Dr. Edelman's survey.
I have.
So does it sound correct that 75% of folks in Latah County are not affiliated with the university?
I don't recall his percentages.
Okay.
So offhand, I'd have to see the report. I could look at it if you'd like.
Okay. And I should be more precise. I believe the question was, are you or a family member, a student or employee at the University of Idaho in Moscow? And the percentage of folks who responded no was 75%. Does that sound right?
I couldn't tell you without seeing it. Sorry, I don't remember.
Would it surprise you to find out that 60% of Latah County residents who were surveyed reported that they did not feel higher levels of stress or anxiety during the hunt for the killer in this case?
I don't know. I don't know what percentage I would have estimated. I just would have estimated it to be higher in Utah.
So is one strategy that the court could use in any jurisdiction, whether the trial lives it or stays in Latah County or moves to Ada County, would bringing in a larger jury pool alleviate some of these concerns across any jurisdiction?
Well, if we're talking about Latah County, a lot of the things that I mentioned were not in the survey. So, there are emotions I mentioned that weren't assessed during the survey, impressions of Mr. Kohberger that weren't in the survey. So it could be that 90% of people think he's a bad guy, but they don't think he's guilty. And then that still could influence judgments. So it's really hard to answer that question without, I didn't make the survey. And even if I did, there'd be a lot of things that I would miss too, so I can't make that determination. About you said maybe you can restate it and I can.
No, I appreciate the answer. Thank you. Now, I guess the last question I'll ask you is, would you be surprised to find out that in the survey, when jurors were asked, potential jurors who were responding to the survey were asked what their opinion is of Bryan Kohberger, the highest percentage of prospective jurors that were surveyed who had no opinion of Mr. Kohberger were Latah County survey respondents? Did that surprise you?
That they have no opinion about whether he is guilty.
I think the question is just, do you have an opinion of Mr. Kohberger?
Well, it's a high profile case that had a lot of coverage and the percentages are so high that of people who have an opinion. I imagine, I don't have those in front of me, but in statistics, we call that a ceiling effect when all the percentages are high and you can't really see differences. So I don't know if we're talking, I don't know what numbers you're looking at, but I don't know if that applies or not in this particular case. So
Thank you. I have further questions.
Ms. Taylor?
Anything else? Yes, just a few questions for you. Your focus is on human bias, right? Okay. And you talked to us about media exposure and how that forms bias. Are bias and forming an opinion, you're willing to say, different things?
Bias can come from lots of things, one of which is an opinion that was formed, and then bias can shape another opinion that gets formed, if that answers your question.
It does, thank you. You talked to us a little bit earlier about how that bias gets formed, and then you told us sometimes we won't be able to spit out our entire bias or what we looked at to form bias. Is there a danger in a case like this, where there's been a lot of media coverage, that somehow we seat a jury, but they start remembering things they read in the paper and trying to make the evidence fit into that filter?
Oh yeah, of course. So Dr. Edelman's report, I remember, said that people didn't list everything that they recalled, but when they were prompted to ask about to indicate whether they remembered specific things, then they remembered a whole bunch of things. The same thing would happen during a trial, right? Those retrieval cues, anything that reminds you of something. So our minds have kind of an association network. All of our memories are sort of connected in some way. You could just mention the word white, and maybe I think of snow. So our memories can come up from so many things that I would be surprised if there weren't some memories rekindled.
Thank you. That's it for me.
Thanks, Ms. Taylor. Any more questions?
No, thank you, Your Honor.
And you made this witness to excuse?
Yes.
All right. And no objection to that. All right. Okay. Thank you. You're free to stay. You're free to stay or leave. All right. Thank you very much. That was very interesting. Thank you. Okay, next witness.
Next witness is Dr. Bryan Edelman.
Okay. Dr. Edelman. All right, welcome back. Please raise your right hand.
You solemnly swear or affirm that the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth under penalty of perjury.
I do. All right, thank you, sir. Please have a seat, and then please state your name and spell your last.
You're gonna speak slow today, I promise. It's Bryan Edelman, Edelman.
Sir, go ahead, Steve.
Thank you. Good morning,
Good morning.
Dr. Edelman. I see that you brought some things to council table with you.
I did.
What do you have?
It's just a copy of my presentation.
Your PowerPoint presentation? Okay, and is that face down? Perfect. Will you let me know if you need to flip it over to refresh your memory?
I can tell you the second you start, I won't be able to see anything, so I'm gonna read it.
Okay, Your Honor and Counsel, then I'll ask if he can leave his PowerPoint presentation face up so he can help us understand this testimony. No objection to that.
Okay, thank you. Go ahead.
All right, let's start with your background.
Going back how far? Let me try it.
Well, let's start with what you do right now and then work backwards and forward. How about that?
Okay. I'm a trial consultant. So in that capacity, I'm often in a courtroom doing jury selections and assisting with that, running juror questionnaires, helping attorneys craft oral voir dire questions. And I also do pretrial research, so that's focus groups and mock trials. And then I also do post-trial interviews and do a lot of presentations and writing in terms of trying to educate or help the legal community. And then I also serve as an expert witness in this capacity. And in that scenario, I'm often focusing on pretrial publicity, the impact of pretrial publicity, and whether or not a defendant's due process rights may have been undermined by media coverage. And I also do post-conviction work, which kind of ties into that, where I might be brought in to look at a case to see if there was a lot of media coverage and whether or not there should have been a change of venue or a request for a change of venue, and looking at the adequacy of voir dire to uncover what jurors knew. So that's kind of reviewing the voir dire transcripts and use of challenges, that sort of thing.
How long have you been doing that work?
That part, since I think the first one, maybe like 2011, 2012, something like that.
Where do you do that work? What company?
So all over the place. So all over the country in state and federal cases, Florida, Michigan, Washington, DC, Idaho, California, Texas, New York, a bunch of others. So quite a bit.
How were you educated to do the work then?
So I have a background in social psychology. So a PhD in social psychology from the University of Nevada, Reno, which is a program that really focused on psychology and law. That's where the judicial college is, and something called the Grant Sawyer Center for Justice Studies. Am I going slow or I do it better? Okay. And while there, I worked at the Grant Sawyer Center for Justice Studies as well, and did research on the death penalty, so on pretrial release programs and the impact of media coverage, so kind of similar to this. And when I finished that, I went to England and got an LLM in international humanitarian law, and then came back here and started working at a trial consulting firm. I think I started in 2000, I want to say 2004, that sounds about right, 2000, I think. And then started my own or co-founded Trial Innovations, where I am now, with a business partner in 2011.
Do you do any teaching about your
Teaching? So I do like CLE classes and things like that for bar associations. I've done it for public defenders, for district attorneys' offices. I've been like a visiting lecturer at like different law schools, at the ASTC, which is the American Society of Trial Consultants. Did classes on like trial consulting and change of venue. I think I've done one at APLS, which is like the American Psychology Association, a legal society. And I'm sure there's some others out there too. ABOTA is one, and that might be more on like jury selection. That's like a legal organization.
Are you a member of any organizations, professional organizations specific to your work?
Currently, I don't think I normally I'm a member of ASTC, which is American Society of Trial Consultants, but I might have forgot to pay my dues this year, so maybe not.
Are you usually a member
Yeah.
of that organization?
And same with APLS. That's
What's APLS again?
That's the American Psychology Association, and it's the legal society division. And then I also do for like the ASTC, I've been on like a committee that helps write some of the professional guidelines, particularly around change of venue.
And I understand you do consultant work. Do you testify as an expert?
Yes.
What states?
What
Roughly?
states?
Roughly?
Okay. Kind of the ones I mentioned earlier. I'm sure there's more. So, Florida, Michigan, California, Washington State, Washington, D.C., Texas, Idaho. Wish I had a map in front of me right now. Tennessee, Georgia, Minnesota, and I'm sure there's others, but it's been a long time, so I've done a bunch of them. I've probably done over 100 that I've been retained on for in some capacity related to pretrial publicity in both state and federal cases.
I heard you mention Idaho. You've testified as an expert in Idaho, is that right?
I have.
How about in this case? Have you testified before in this case?
In this case, I
Yes.
did.
All right.
Yes.
Last time we were here, we were talking about a survey that was in progress.
Yes.
So have you now completed your survey?
Yes. So I completed the survey in Latah County and then conducted several comparison surveys after that hearing in Ada County, Bannock County, and Canyon County.
Before we get to all of those, I'm going to start a PowerPoint presentation that you've provided for us today, so you can walk me through the process of what you do and how that works. Give me just one moment.
Sure. I'm going to flip this over then.
Thank you for that, for the patience. I think we have it now. Will you give us a or an overview of what we're going to talk about today?
Yes. So the presentation is broken down into 3 parts. So the first part is just kind of a cursory review of some of the social science research, some of the basic general research, foundational research, and then research specific to pretrial publicity and juror decision-making. And then to get into the actual change of venue analysis, which focuses on the media coverage, so the extent and nature of the coverage, and in addition to whether or not that coverage has had any impact on the jury pool. So that really gets into the survey. And the last part gets into the unique challenges that cases like this pose when we talk about jury selection. So is what you're an effective remedy in cases like this, when there's been a lot of media coverage and people have a lot of knowledge about the case.
I heard you say cases like this. What do you mean?
Sorry, when I say what?
Cases like this.
Oh, cases that have a lot of media coverage. So in a normal case, like a car accident or something like that, people come in, they might have general attitudes about drinking and driving, but they don't have case-specific attitudes about this person that are well developed from information I know about the evidence in the person and so on. When you have a case like this, people come into the courtroom with case-specific attitudes that are well developed and based on, it could be emotional information, it could be evidence that they already have read, seen, or heard. So they have very well developed attitudes. So that's a unique thing because they're no longer blank slates when they're hearing evidence. They're confirming what they already know, as opposed to jurors who don't know anything and are learning and building attitudes and knowledge structures as they go.
All right, let's go to the background of why we do this, why this matters.
Yeah, so there's decades of research in general documenting the impact of pretrial publicity on decision-making. And it kind of falls into two areas. So there's what we call field research, which is kind of similar to like a change of venue survey. So people are exposed to pretrial publicity in a naturally occurring setting. I read the newspaper, I watch it on the news or on the news when I'm cooking dinner, whatever it may be. And so we see natural exposure and we're able to assess the impact of that coverage on pretrial opinions. But there's some limitations to that. We can't really learn how pretrial publicity impacts decisions, and we can't really learn the types of pretrial publicity that are most impactful, and whether or not remedial measures like an admonition or voir dire mitigate the impact it has. That's where experimental research comes in, because it's a controlled setting and we can test things like what types of pretrial publicity are most prejudicial, how does pretrial publicity impact decisions, and things like do remedies work, and so on.
Do you have an example to help me understand maybe the difference starting with field research?
Sure. So the one we're looking at here is one of the earlier pieces that was published, and it looked at 3 cases that were high-profile cases in California. One involved the murder of 2 police officers, I think it was in Yolo County, and then the murder of a dental hygienist from a prominent family. So it was the status of the victim was important in that. And then I believe a third one was a rape of a young girl. So the 3 cases, and they did surveys to assess the impact of that media coverage. And they learned a couple of interesting things. So they learned that people who consume news, whether they watch it on the news or they read the local paper, develop more case knowledge. So the more often I follow the news, the more likely I'm to have detailed information about that specific case. So there's the first relationship that we look at. And then the next thing is case knowledge impacts presumption of guilt. So people who have well-developed case knowledge, they've read a lot about it and they know a lot of detail, they're more likely to think the defendant is guilty. They're more likely to have an opinion about that. And that stands out as more important than a host of things. They looked at gender, education, attitudes towards the criminal justice system. And ultimately, case knowledge was 10 times more impactful, more important than attitudes like towards the criminal justice system. So it wasn't something like, I'm just a pro-conviction person who tends to favor the government and think people are guilty. It was far more important than that when it came to these attitudes and opinions they developed.
It sounds like the field research has been important in your profession.
Yes.
Fair to say?
Yeah.
Help me understand what experimental research is.
Yeah, so these are more, again, traditional studies where we are able to control. We can look to see, maybe we're testing to see what types of pretrial publicity are most impactful. Maybe we want to know if voir dire is an effective remedy at mitigating the influence or impact. An interesting study someone recently did was looking at the set-aside question. And they were looking to see if you did something like normally what happens to the jurors on the spot, it's just like, what do you know about the case? And it's kind of like on the spot, I need to think about it and try to recall everything from memory and spout it out right there. So the remedy was, what if the person was given time to write down everything they know and think about it, think, can they really be fair, and then come back to them and then ask them again. So they were looking at that as a remedy. So that would be an example of an experiment. And like globally, what we find is exposure to pretrial publicity impacts perceptions of guilt, and it influences the defendant's credibility, likability, and sympathy towards the defendant as well. And overall, most of the research shows that judicial remedies are not effective. We talk about admonitions, so like the judge telling the jurors are not allowed to consider media coverage; they have to set that aside. Voir dire, kind of like I was mentioning before, those don't mitigate the impact of media coverage. Delay is another one. Sometimes there's a long delay between when someone reads the coverage and when they come and do the experiment to see if that mitigates the impact. So overall, those are the key findings and takeaways from the experimental research.
All right. You have a slide in here called, I'm not saying this word correctly, Potower and Singer. What's this about? How is this important?
So this is, again, just an example of some of the research. So in this study, the researchers recruited people who had been excused for jury duty, so they were at the courthouse. And they were put into 2 different conditions. So in one condition, the experimental condition, they read an article, and that article contained information about the defendant. It was a criminal record. And it also included a retracted confession. So they were looking at something that was inadmissible. It wasn't going to come in, I believe, in the story. And the control group read the same article absent those 2 pieces. Didn't mention anything about the criminal past, criminal record, or the retracted confession. And what they found, if you go to the next slide, is that there was a significant effect. So those participants who are in the experimental condition, the ones who had been exposed to the background, the criminal background information and the retracted confession, were much more likely, I can tell I'm talking too fast, were much more likely to convict and perceive the defendant as guilty compared to the control group. So that was a significant effect.
That seems like a pretty high percentage. This is an experiment with 2 otherwise equal groups of people, some exposed to negative publicity and some not, and almost 30% of the people in that experimental group would have voted to convict just based on that difference alone.
So 28 percentage points higher. And again, it's a controlled study. So they're controlling for everything. So the only variable really that should be that's impacting is the fact that one group heard this negative prejudicial information, the other one didn't.
Seems like a high.
What's that?
That seems like a high amount.
Well, it's a significant find. It's statistically significant.
All right, let's talk about pre-trial publicity.
Okay.
How does it impact information that you might get in trouble?
Yeah, so we already heard about this a bit in terms of this selective process for filtering information. So the one that really is significant for me that stands out is the belief perseverance research. I'll tell you why. And like it was mentioned, so a common study would be someone would read an essay. For example, it might be an article about why risk-taking makes you a good firefighter, and people who are cautious that's not a good characteristic. And then someone else might read the exact opposite, where implying that cautious people are better firefighters than risk takers. And then they're asked to write an essay, and whichever one they read, they're more likely to write to support or write an essay that's consistent with what they read. And then later, when they're confronted with information that disconfirms whatever they had read and written, they're resistant to change. So we see that in our everyday lives quite a bit. And the thing that really is significant to think about is jurors who come in as a blank slate in a normal case, who haven't been exposed to media coverage, have no opinions or attitudes that are specific about the defendant, about the evidence, about guilt. And they're just processing evidence in a controlled setting through direct examination and cross-examination. The rules of evidence apply. So they're learning and they're developing opinions. They're considering the evidence for the first time. That's the ideal situation. In a high-profile case where jurors have been exposed to a lot of coverage and they end up serving, they already have well-developed attitudes about the defendant. So opinions of the defendant. They have well-developed attitudes about guilt, for example. And if they have case knowledge that they've already been exposed to, not in a controlled study. So maybe it's information in this case about cell tower data, or information about a vehicle being seen on video, or what the results of DNA tests are. And it's not under a controlled setting of direct examination and cross-examination, and another expert from the defense side where they weigh all that. It's in the context of a news story. You know, there's editorial, there's public personalities, it's Nancy Grace, there's all this sensationalism around it. So they're being exposed to all that, but they're also getting the information, the evidence within that context that they're going to hear at trial. So when they hear that information, it's not new, and they're not considering it and weighing it as a blank slate. What they're doing is just activating the beliefs and the knowledge structures they have, and it's just confirming what they already know. So one side is just giving you the information I already have, which strengthens it, and it makes that information more accessible in memory and so on. And then the other side is giving information that is attempting to disconfirm what I already know and believe, and it's scrutinized in a very different way. They're much more likely to reject it, they're much less likely to attend it, short and long-term memory, and it's really shifting the burden. So now the burden, whether intentional or not, is shifted on the defendant to change that juror's mind. And that's what we see when we talk about a filter, like our knowledge is, our impressions serve as a filter for processing new information. So it's really important to think about putting yourself in the shoes of the juror and what the task is and what that's like when you already have all this information compared to a jury who doesn't have any of that.
Sounds like a tough road that can be created by a lot of media exposure.
Can be.
Can you tell us about any studies you know about how evidence might be evaluated?
Yeah, so this is just an example again. So in this particular piece, the researchers were looking at something called pre-decisional distortion. It's kind of like disconfirmation bias. So people were exposed to negative pretrial publicity or positive pretrial publicity about the defendant. And then there was delay. So I think it was like 5 days or something like that. And they watched a murder trial where a husband was accused of murdering his wife. And it was intentionally balanced. So it was kind of like a 50-50 split of guilty, not guilty. And what they found was that at each point in time, they would stop and do a case evaluation and assessment. And people hold the evidence to be consistent or supportive of whichever leader they had. So if they had started the case where they were supporting, they had been exposed to negative pretrial publicity, they would be supporting conviction, let's say the prosecution. So they didn't look at that evidence just for the probative value, but it anchored closer to it supports conviction. It's consistent with the belief I already have. And it was consistent like that throughout the entire study versus those who maybe had seen neutral pretrial publicity. You didn't see that. So people were more likely to consider the evidence primarily for the probative value.
How about when you've had a lot of pretrial coverage and then you have a lengthy trial? What do you know about a risk of confusing where you heard the information? By that, I mean bringing in something that you heard a long time ago that didn't come to the trial.
Right. And think about it based on what you were saying. These studies we're talking about an effect that was discovered with maybe 1 or 2 articles, and it still had an impact. Case like this, you're talking about inundated with pretrial publicity over a significant amount of time, repeating information, and then new information that's sensational. And so it's constantly reactivating those memories and making those knowledge structures more accessible, both consciously and unconsciously. So those attitudes are even stronger. So you would expect to see an effect like this to be even more robust in a trial setting over the course of weeks, months, or whatever it is.
All right, let's talk about surveys and what you do.
Sure.
Tell me what you do when you want to do a survey.
What do I do?
Yeah.
Well, so there's 2 different phases. So I don't start with I'm going to do a survey. So when I'm first asked to look at this, the first thing I do is collect a newspaper coverage. And I try to take a conservative approach. So I take the papers that have significant circulation in the county, that are based in the county. So I'm not looking, for example, at a paper in Spokane or in Ada County. I'm just looking at the ones here. And I read that coverage and I make an assessment if there's extensive coverage and potentially prejudicial coverage. So what is the nature of the coverage? Does it include inadmissible content? Does it include a lot of detail about test results like DNA results and things like that? So conviction prone evidence. Is it have presumption of guilt or guilt oriented detail? For example, public officials making statements about a defendant's guilt, victim families talking about that, things like that. Emotional pretrial publicity, because we know from the research the most prejudicial types of media coverage is emotional pretrial publicity, inadmissible content, and information about the defendant's character. So those are 3 big ones. So really looking at that. In every case is different. So in some cases, it's all about the community impact, and there's candlelight vigils and memorials, and it just shocked the community. In bigger places, you don't see that as much. So it might be something very different. So it's always dependent on the case. If there is not a lot of coverage or it's very neutral and basic, I wouldn't recommend doing anything else. So it would just stop there. If it's extensive coverage or sensational coverage or something like that, we would move to this next step, which is doing a phone survey in the venue. Sometimes we do a comparison survey, sometimes we don't.
All right, I think you told me a little bit about the analysis of the coverage. But will you again tell me what you're looking for specific to a county before you decide to do a survey?
I'm sorry, the main thing I'm looking for.
When you're deciding whether or not to do a survey?
It really depends on the case, right? So every case is different. There's no like, I'm looking for X and is there or not. Every case is unique. Every case has, like, sometimes an example would be maybe this case went to trial 5 years ago and there was a conviction and then the conviction was thrown out. So really the unique thing there is exposure or knowledge that this person's been convicted is highly prejudicial. Sometimes there's a confession and you know, we know from the research in the Supreme Court that confessions are considered one of the most prejudicial things that could be out there in terms of media coverage, that when we talk about change of venue. So maybe that's a factor. It always just depends on the case.
And do you look at the coverage to the local area you're talking about?
Yes.
What did you find for Latah County as far as coverage?
So just looking at the Moscow Pullman Daily News and the Idaho Argonaut, I found 240 articles going from 2022 to 2024, stopping in June. So I don't know what's been published since in terms of collecting the coverage. So that's the extent of the coverage in those two papers. I believe I also provided the Lewiston Daily, I think it is, or the Tribune, is that right? As well, because in the survey, a lot of people mentioned they read that paper. So I put that in there as well and turned that over. And I think that was like another 200 articles or something like that.
Do you know the total number of newspaper articles you collected from those three papers between the dates of November 13th, 2022 and June?
Yeah, so approximately 444.
Now you've provided this chart and you have Mr. Kohberger's name highlighted at the bottom of this.
Yeah.
What's significant about this chart that you've presented?
So one of the tricky things is always what is a lot of coverage. So there's no decision that I'm aware of where it says if you have X number of articles, that's considered sufficient for a change of venue. So what I did was I pulled cases where the population or the county where the case was initially venued were between 27,500 and 62,000. And I did that because we fall somewhere in there. We're at like 32,500, I believe, 18 or over here. So I was just trying to look for a range of cases to get a decent sample size and look to see how many articles were published in those cases and what the median was. So it's not impacted by extremes. And what I found was these 16 cases that fall within that range, and the median number of articles in those 16 cases was 85. And in those 16, there were 12 change of venues granted in that case. And if you look at those which had more than 80 articles, should be 85 median, it's 78%. And Kohberger would fall at the bottom right now because he's at 444. And I think, is it Daybell would have been, I think there was approximately 200 and change in that one. I know that one was recently moved to Ada County.
And these are articles from the three newspapers, only not talking about any other source of media coverage.
Just the three papers.
Okay. Let's talk about how much media coverage there is. It's not just these three newspapers, is that right?
Right. So I did an analysis of the coverage that's in the declaration, which is more of a qualitative analysis. So I'm not going to go through that because that would be pretty laborious. So what I have here is looking at kind of consistent, some of the television coverage and some of the information that's been spread through more informal channels, such as social media.
What did you find?
Yes. So again, like this is really looking at what people are seeing on social media and through informal communication networks. And the reason I did that is because it's a small county, and in small counties, people talk. So people are more likely to know, rumors and speculation because people know the victims, they know the defendant, or someone's worked with somebody who knows the defendant or victim. So from my experience, you have a lot of information disseminated through informal communication channels and through social media in high profile cases.
Did you find that in this case?
I did. There was quite a bit.
What are we seeing on this slide?
So this is just an example. I went on Facebook and just did one search, which was just the search term was Moscow murders to see what would come up. And this is what we would call a results page, essentially. So if you hit play, you can see the extent of content that's out there from groups that are just talking about this case and sharing information and discussing what they think happened, and videos and posts, which may include anything from influencers and podcasters to sharing traditional news stories through local newspapers or television stories. But there's quite a bit. And again, this is just one search.
It looks like you did a screen capture so that you could show the results from one search term.
Yes, this is me just scrolling through the search engine results page from that one search term. And what you're seeing is a combination of everything. And then if you click on the tabs like posts or groups, you would see other categories. What's remarkable is the number of groups that have been created discussing this case. Some of them local, some of them national, with, some of them have hundreds or thousands of members, others have hundreds of thousands of members. So this case has captured the public's attention.
We'll just keep scrolling for a minute. I think this goes on a little bit.
Sure. These are all groups that you're looking at right now. So these are just Facebook groups that have been created talking about this case. These are videos.
And these all popped up from that one search term.
I don't think we need to advertise all these, honestly.
Okay,
We've been trying to protect from this kind of stuff.
Your Honor, and
I'm aware of it. I don't look at it. I don't read it. We know it's there.
may we take a brief break, Your Honor?
Sure. Go off the record.
Can you believe this? So one-sided, and it's like I walked away for a bit, but came back, and it's like one of their witnesses is contradicting the other witness, and they're basically saying that the people of Latah County cannot be fair, cannot be unbiased, cannot follow jury instructions, jury rules, etc., etc. These are the same people, these are the same taxpayers that are paying her salary. And she's basically saying that they cannot be fair and just. Only Ada County can. Only Ada County. Ada County is the only county in Idaho that can be fair. The same Ada County that has a street named after Ann Taylor. I don't know what connections she has there or what the people there think of her, but I think by her trying to force it to Ada County, she must know that they have a very high likeness of her. There's a reason she does not want this in Latah County. And as far as I'm concerned, you should be tried in the county where you committed the crime. Their own graphs and everything have showed that Ada County has had just as much publicity, if not more, 8 months of the time. They had more publicity, more everything there than Latah County did. Right now, if you look at their graphs, their own graphs over the last 3-4 months shows that there is more out there in Ada County right now regarding this case than in Latah County. More interest, more publicity, everything. And another thing, it's like there's a lot of things we can't get past. Hey, if you can produce, and the one saying, oh, our minds can't be changed. People's minds cannot change. Once they hear things and this and that, they have a preconceived notion of what is. And if they think he's guilty, I thought he was guilty 100% at the beginning. I'm giving him 10% now. Show me the K-bar knife that he bought with the sheath, because they have the receipt of him buying it. Show me it. Show me the Dickies outfit that he bought. Show me it. And you know what? I will go back to, okay, this guy ain't guilty. He's got his K-bar. He's got his knife sheath. He's got his Dickies. It's not him. Same as he's stargazing on a night where it's overcast and cloudy as F. You can't see a star even if you tried. But he was out there stargazing in a park that's closed. And this is a criminal justice PhD student who should be one of the ones that does follow the law, breaking a law going into a park that's closed at dusk. Doesn't look too good on him, does it? Especially on a night where it's so cloudy you couldn't see even the moon, let alone a star. You know what I mean? So it's like, and here she is scrolling through all these saying, okay, I put in Moscow M's and look at, but you can see where it's been cut. So they've videotaped themselves scrolling through stuff, but you can see where the video's been cut and pieced together. That's not just one scroll. And they're from different sites. One was from Twitter and one was from, Twitter is now called X. And I think one was from, one was Twitter and one was TikTok. So don't tell me that's one scroll. You lied. That's not one scroll. And you can see where the video is cut. But he's trying to project to the judge right now that this is him just scrolling through one inquiry. It's not. He's pieced these all together. And I mean, they're trying to put more bias out there by what they're doing right now. So thank God the judge put a stop to that. Right? Again, you guys, here is the book. We're going to be drawing for this book at the end of the hearing. This is the Howard Blum, The Idaho Murders, and the diamond painting that I did here, which probably not going to show up good right now, but you can see how sparkly it is. I will be putting this in with the book. So if you do want a chance to win this, $5 super chat. Nobody's helping me out today. Nobody. It keeps the channel going, you guys. It keeps me, even if you don't want to enter into this, but to help the channel and whatnot. I've been here for over 4 hours now. So super chat, super stickers, they all help to support the channel and to help me be able to continue to bring you stuff like this. So it does help. I just throw in an extra bonus for every $5 super chat. You can win this, which I will be doing the live draw at the end of the hearing today. So please don't go anywhere at the end of the hearing because I will be doing that draw live at the end of this hearing. Let me see if I can see what other people are saying. So what I'm seeing from News Nation, you guys, is an attorney for one of the family of the victims of the Idaho forest saying they want Bryan Kohberger's trial to remain in the original county. Other people are saying this is a waste of time and serves to continue victimizing the family and friends of the community of his victims. Like, people are outraged. Thank you, K. Mitch. Thank you. I appreciate you. Let me put you on the wheel. I think you do have one already, but I will put you on again. Thank you, K. Mitch. I appreciate you. So you were on the wheel twice now. Thank you, thank you, thank you. A lot of people are outraged, and you got to remember that to move this trial, all the family, friends, the people of that county that have had to endure everything that goes with this, would all have to go 300 miles away if Ann Taylor is to get her way yet again, right? It's craziness. To move all the prosecution team and everything else, all the paperwork, the judge, everybody has to be put up in motel rooms because it would be 300 miles away. It's just not, it's not proper. And that's just one aspect of it. The other aspect of it is it has shown that there was just as much publicity in Ada County, if not more, than in Latah County. And over the last 3-4 months, it has picked up almost 100% more in Ada County than in Latah County by their own graph. So it's craziness. It's pure craziness. So they are on a break, you guys. Let me just see what else is being said over here. Bryan Kohberger says he'll be lynched if acquitted as he begs the judge to move the trial. Well, what do you think happened to the University of Idaho 4? What do you think happened to them? I don't think it's a break for lunch. They didn't say. The judge wanted the defense to stop scrolling through all the articles that they were putting on screen about Bryan Kohberger from Twitter and TikTok and shit. So they asked for a sidebar. Hang on a sec. Let me go back over here. Oh, there was also Facebook groups being exposed. You don't think he'd be if he's acquitted, you don't think he'd be lynched in Ada County too, who has had major coverage of this case? It doesn't matter where they have this case in Idaho. If he thinks he's going to be lynched, it could happen anywhere. You don't think, even if they do move this to Ada County, you don't think for closing arguments, everybody ain't going to come from Latah County that want to be there to see him either found guilty or not guilty? You don't think a lynching wouldn't happen no matter where, if that it was to happen? You don't think that would happen anywhere? Like, it's crazy. Does he think he's not going to be, if he was acquitted in Ada County, do you not think that there wouldn't be people there lynching him like he says would happen in Latah County? They could move it out of state and it would happen there. They could move it to Canada and it would happen here. If he was found not guilty, I mean, unless, and like I said earlier, you guys, if the defense happens to come out and says, well, look at, here's his K-bar knife and sheath, here's his Dickies that he bought, that would really make me question. I think it would change my mind about whether he was guilty or not. But it's never going to happen because it's his knife sheath. It's got his DNA on it. Where's the Dickies? Where's his knife? Where is it? That could prove, boom, right there, that it wasn't his. It wasn't him. Why would somebody sit in jail all this time if they could prove their innocence? Right? Thinking Ann doesn't want a full courtroom. Oh, it's going to be full anyway. No matter where it's held, it's going to be full. Brian Elderman. The guy's a joke. Thank you again, K. Mitch. I'm just reading some of these things that are. The This is from ABC. County commissioners approve $150,000 boost to Bryan Kohberger's trial expense budget for Idaho murders. Wow. They just boosted the budget another $150,000 for Bryan Kohberger's defense. That's on top of what they already spent. A lot of people are saying that these witnesses that were on the stand today, these people really have zero faith in jurors' ability to remain impartial and put aside what they've heard. There's a lot of people are saying it should be kept in Latah County. A lot of people are commenting also on Bryan Kohberger not wearing a tie today. A lot of people are saying that moving it's not going to make an impact. You can move Bryan Kohberger's trial to any county in the state of Idaho and potential jurors are going to be pissed. They just put another 150,000 K into it. Well, it's pretty bad when you see what Ann Taylor's doing, like especially that one hearing where she spent hours going over how laws aren't really laws and this and that, and grand juries, the way that they decide whether he gets arrested or not, indicted or not, is not what it's supposed to be. Like going back to 1800 law and everything. Meanwhile, the time that it took for her to put that 100 and something page report together and fight about it in court over 2 days? She's getting paid for that. Right? You don't grasp at straws like that and try to have everybody interpret the law the way you want it interpreted, even though over the last 100 years, this is the way grand juries have convened and come to their conclusions by, and you want to change that, Anne? And you're picking this case to change it because you're getting $200 and something an hour? Right. But she's trying to say that the people of Latah County can't do that. The only people that can do that, K. Mitch, are the people in Ada County. That's what she's trying to project. The only people in all of Idaho that can do it are the people of Latah County. I'm just scrolling here, you guys. Seeing what everybody's saying. The first witness, people are saying, did the defense really need an hour for that crap? It's a 7-hour drive from Leyda to Ada counties. And they expect people to do that. That's what I think she's trying to do, Carol. Is she's trying to make a name for herself. Maybe Anne is setting up for an appeal by saying, look, the trial was moved to Ada County and Bryan could not get a fair trial in Ada County. But she's requesting the trial be moved to Ada County. So why would she then say that Bryan could not get a fair trial in Ada County? She's the one that's requesting Ada County. She doesn't want it moved to any other county but Ada County. Even though there's other counties in their own statistics that had less information about the case. And less people thought automatically that he was guilty. Even though there was other counties that were better for Bryan, she doesn't want them there either. She wants it in in Ada County. Oh my gosh, an hour ago, or no, this was 17 hours ago. Apparently, illegal aliens tried to hijack 2 buses full of kids in San Diego. Wow. These illegal immigrants coming in. I was reading, I think it was on X, that there were illegal immigrants that had crossed in, and they're in Colorado, in Aurora, Colorado, and they've taken over an entire housing complex. Garbage outside is piled like 30 feet high outside the buildings, and they've taken over. They're knocking on doors with guns and everything and robbing people, and they've taken over the whole complex. I don't know if they're going to present. I hope they do, K-Mitch. I hope they have some rebuttal witnesses here. It's 3:15 in the afternoon here, so I guess it's around noon there. So maybe they are taking their lunch right now. But the police are claiming ignorance. It's true. I just seen that. I was looking for stuff on Bryan Kohberger on X, and I just seen this, that illegal immigrants tried to hijack 2 buses full of kids in San Diego. Wow. I'm just scrolling, you guys. Oh, no water or sanitary. Wow. So you're talking about the apartment buildings that the illegal immigrants have taken over? They have no water or sanitary system? The people that have to live there? And I'm sure like people just can't pack up and leave because they're being robbed, right? Wow. That's horrible. Bring in the army. Okay, give me a few minutes, you guys. I got to make something quick, just like a toast or something to take my stomach pills with. So it looks like they're probably on break for lunch. It's going on 3:30 my time. So give me a few minutes. I still got it up, so you guys aren't going to miss anything. I will be back in a few minutes. I just got to make something because I got to take my stomach pills with food. So I'm going to make some toast or something, and I'll be right back.
All right. Let's get back on the record. Thank you. We're back on the record. This is State versus Kohberger, case number CR 29-22-2805. Counsel are in the courtroom, and as does Mr. Kohberger. We had a certain break here so that we could discuss about what we want to send out to the public. But we also have to make a record on that. So what we're going to do is we're going to take a break. We're going to make sure that we have the families of the victims can observe if they want to on Zoom. Some are here. And we're going to come back at 1:30. Did I say that right, Ms. Taylor?
Yes,
You
Your
can
Honor.
correct me if you need to.
Yes, and I believe that the court will not be live streaming about the first 15 minutes after our lunch recess, and then live stream will pick back up.
Yes.
Do I understand that? But the courtroom is otherwise open?
Yes.
Got it. Thank you.
Yes. So it's kind of a compromise, but we thought there were certain things that maybe we don't want to send out to the public. So I don't necessarily know what it all is, but I need to look at it and see it for on the record. So that's how we're setting this up. Okay, Mr. Thompson, anything else on that or corrections?
No, Your Honor, we appreciate the court's concern. We have the same concerns, and I think this is a reasonable way to proceed. We'll reach out to all the families.
Great, thank you. Okay, so we're gonna take a break, and we'll start up at 1:30, but the first 10 minutes will not be streamed. All right, thank you.
It's been 3 years since Deanne Warner
Well, hello everyone and welcome back. So we still got, I think, about 15 minutes, you guys, because it's supposed to start back at 4:30. But he said the first, and then they need another 10 minutes or something. That they need to show something that we're not allowed to see. The family and that can see it, but we can't. So don't forget that at the end of the hearing today, we will be drawing for the book and the diamond painting. Now I can show this. Nice. You can see this sparkle in it. So we will be drawing for that after the hearing is over. Don't mind this. This is just reflection from what's up above. So that draw is coming at the end of today's hearing. I may do it a little bit earlier. We'll see how it goes, you guys. I'm keeping an eye on. And if they're par for the course here, they're supposed to be back at, well, they start court back at 4:30 and they're usually late. Thank you, K-Match. Thank you. Carol says, well, la-di-da, as my mom used to say. Yeah, they're always late. Always late. I knew it. Well, had my phone on charge. I think it's fully charged now. Thank you, K-Mitch. Oops. There we go. I didn't know where my chat had gone. So I'll make it big for now until this starts. Okay, so I'm just going to go and check my stove and that, you guys, and I will be back. Like I said, it is starting. Where did I just put that? I'm just going to put that. Because I think it's going to be at least 4:45. So we got about 15 minutes. So let me go and check on my oven and stuff, you guys, and I'll be back. All right, y'all. Okay, so we're back. I'm just watching now to see when this. Like I said, we know that they're always late to begin with. There's no link to the live, so we got to wait for the link to come back up so I can get it back up on screen for you guys. Married Pa Humbug, Carol says. Yes, and I made it. And I painted all the inside of the framing and whatever. I didn't make this frame, but I did have to do alterations to the inside for it to fit in there the way it does. But it's really nice to see it in person. On here, it doesn't do it justice. You don't get because of my light. See my light over there? The sparkle. You can see the sparkle, but it's nothing like natural light. The natural light, it lights right up. It sparkles really nice. So for those coming in, we are doing the draw for this at the end of the hearing today. Scrolling across the bottom, $5 super chat, get your name on the wheel. We'll spin the wheel. We're going to do that all live. So you guys will see the wheel spinning. We'll see who wins as soon as the hearing is done today. I had a little something on there. I had to get that off. That bugs me. All right. Again, I keep refreshing this. Still no Zoom. Still no Zoom. Come on. Still nothing, you guys. I've been checking out Twitter, X, whatever you want to call it, to see what people are saying, and it's pretty much split down the middle. Whether it should change venue or not. I don't think it's really going to matter if they change venue regarding outcome or getting a jury seated. The only difference is going to be the cost, because it's going to be 300 miles away. So like the family members and whatnot are going to have to pay accommodation. They're going to have to pay accommodation. They're going to have to pay traveling expenses, because I'm sure they may like travel out there, say on a Sunday, because it's a 7-hour drive one way from Moscow, Idaho to Ada County. So it's a 7-hour drive. So they'll probably go out on a Sunday, stay Sunday night, Monday night, Tuesday night, Wednesday night, Thursday night, Friday after court. They're probably going to want to go to bed before driving out Saturday morning to go home for one day and just to come back. You know what I mean? I don't know. It's just a lot of traveling for family, for friends, for other people in Latah County that want to be at this trial, to bring all the prosecution and all their evidence and all that stuff, and you know, keeping the evidence secure and moving the judge out there. And it's just a lot, you guys, especially Ada County. Now, why is she pushing so hard for Ada County? Did you guys know that I've just joined that there's a street in Ada County named Ann Taylor Road? Ann Taylor Street? Yeah. So I think there's more to the reasons why she wants this move to Ada County than what's being said. She's also taken on another death penalty case. Like, she's having a hard time taking care of one death penalty case. Now she's taken on a second one, and apparently he's a white supremacist, the second case. So it's like, wait a minute, you're complaining that you got to put this trial out until 2025 because you're going to need all that time to go over the evidence. Then why are you taking on another death penalty case, right? You can't even handle the one you got. There's a lot of weird comments on Twitter regarding this case. It's like, and everybody's saying, like, there's a lot of comments that I'm seeing, and I'm not going to respond to them because it's not on my Twitter account, but I'm just reading through some of the latest comments on the Bryan Kohberger hearing that's going on. And a lot of people are saying, oh, well, the judge is going to move it because he doesn't want an appeal. What they don't understand, this is a death penalty case. It's automatically appealed. If he's found guilty, there's an automatic appeal. So don't say it's, oh, he doesn't want an appeal. There's an automatic appeal on death penalty cases. So, I mean, that argument just doesn't float the boat. You know what I mean? Let's see, what was this comment? I just seen a good comment. And now I lost it. They're saying sanity's overrated. Huh? So this should be starting up again anytime, you guys. Oh my God, they're having a debate over there on Twitter, and it's like, oh my God, some of the crazies. Like, I respect everybody. If you think he's not guilty, good. If you think he's guilty, good. In the end, I want the person responsible to pay, whether that be Bryan Kohberger or someone else. If it's Bryan Kohberger, full extent of the law. If it's not him, then acquit him. It's going to be up to a jury of his peers. And that's what the justice system gives us. The right to have our case heard by a jury of our peers. Right now, I'm leaning towards guilty. Are there things that could change my mind? Absolutely. Absolutely, 100%. There are things, if come out in court, or if there's things that I don't see being proven, I'm big enough to say, even if I still think he did it, but the evidence isn't there, if it's not beyond all reasonable doubt, then it is what it is. But if there's evidence that proves it wasn't him, I'll be the first to take back every nasty thing I said about him. Do I have a little bit of wiggle room there to change my mind? Yep. When I hear the evidence and the evidence comes out in court, then I will say 100%. But right now there is some wiggle room there where he or his defense could prove, even though they don't have to prove it, if they come out with damning evidence that proves it wasn't him, then it wasn't him, right? Let me go back over here. I'm just watching this fight going on over on Twitter, X, whatever you want to call it. And they still don't have the Zoom link up yet, so they're late. Surprise. I made myself a French vanilla coffee. And you guys, if you want And, and I'm not sponsored. If you want a good mug that keeps things either really hot, and it does keep it hot for 6 hours minimum, and I mean it keeps it hot. And not burning, scorching hot, but hot. Like coffee should be able to, yeah, and take a little sip of it, blow on it a little bit. It keeps it really warm, really almost hot for 6 hours. Or it keeps something cold with the ice still floating in it for 8 hours. It's this Contigo. You can get these at Walmart for $14.99 Canadian. So I'm sure it's a lot cheaper in the States. And they don't look at, I'm doing it right over the diamond paint. They do not leak. They do not. Well, you can see where I've been drinking from it, but they don't leak. You can turn this thing upside down. Everything. It does not leak. So I go with these. I got 2 or 3 of these. Yeah, and that's the fair thing to do, Carol. If I see evidence that he's not guilty, then he's not guilty. Right now, and don't forget, we don't know all this other evidence that they could have come across because everything's under seal. I feel that Ann Taylor is doing a lot of this sideshow act to delay. Okay? If she had a strong case to prove he was not guilty, or that it was going to come out that he was not guilty, because to me, her proving him not guilty, even though they don't have to prove him not guilty, comes out in cross-examination of the prosecution's witnesses. Okay? That's where the defense can catch the prosecution in slip-ups or things that are wrong or whatever. Okay? Of the cup, it's Contigo. It's a Walmart. You can get these at Walmart. That's the cheapest place I found to get them. At Walmart, I paid $14.99. That's Canadian. And at Canadian Tire, which is like a hardware store, you can get them, but they're $23.99 at Canadian Tire for the exact same thing. So I found Walmart was the cheapest place to get them. But like I said, if there's stuff that comes out that contradicts what the prosecution has, then I'm going to change my mind. But only from what we know, with the evidence that's been presented that we are able to see, I feel there's a lot of circumstantial evidence there that points to Bryan Kohberger. But you got to keep in mind, there's a lot more that we don't know. And just because Ann Taylor says something doesn't mean it's true. People are taking things that she says as fact, and it's not so, right? What's fact is what is fact, which can be proven as a fact. Things that she's saying aren't proven as fact. Like when she says, well, there's no indication that he was stalking. She can say that stalking, there's different levels of stalking. There's different ways of stalking. You know what I mean? So what does that really mean? We don't know. We don't know, because we do know that he was following Maddie and Kaylee. He was following them. He sent one of the girls messages. So how can she say there isn't any stalking? Maybe she doesn't classify that as stalking. Those are her words. But others may classify that as stalking if it's grouped with something else that we may not know yet. Is there somebody that's come forward and said, yeah, Kaylee said that, described the guy, and they described, Bryan Kohberger to a T, that he was stalking, or like there was messages that she didn't answer. The guys are following her all over. We don't know because it's all under seal. Carol says, I got used to cold coffee when my kids were little. Every time I pour a cup, they cry. Yeah. Murphy's Law. So again, let me go and check over here. And we know how long-winded Ann Taylor is. The judge figured that it would take about 10 minutes the stuff that they had to do in private off camera. So far, they've been at it for 20 minutes. But the link is still not up yet to the courtroom, so to the Zoom. And it's all over Twitter too. Like, what's taking them so long? What's taking them so long? Get our link back up. So the link is not up yet. As soon as it is, you guys, I will put it full screen on screen. And I keep refreshing the page. As if like me refreshing it's going to make it come up any sooner. Can't say girl didn't try. But nope, still not up yet. I said the people on Twitter are crazy. Crazy. And I don't mean like crazy, like, you know what I mean. It's just some of the things that they've come out with. So you got a lot of people in here too saying, I think he's guilty, but I will keep an open mind. And that's more or less what I'm thinking too. I do think that there's enough circumstantial evidence that we've heard. And don't forget, there's probably tons more. Even though I think right now by the circumstantial evidence that I've seen, that we have been able to see, I think it's leaning towards his guilt. But does that mean that there isn't things that could come out at the trial that would change my mind? Nope. I could very well change my mind seeing whatever comes out during trial. And that's all you can ask for. Because that's all we've been shown, right? You can only go by what you are shown. You can only go by what the evidence is. So if we're only shown this much of it, we got to base our opinion on that much. But they've got this much in total, but we're only seeing this much. So that's what we're basing our opinions on. Now, in this much more, is there something in there that would change my mind? Could. There could be. We don't know because it's all under seal. And I think the defense did that, and they were very methodical in how they did that because it causes more of a stir, which gives them more reason to say, look at all that what's being said online. Well, it's because everybody's speculating because we don't have all the information. Because everything's under seal. This under seal, that under seal, this under seal, that under seal. So it is what it is. I'm seeing a lot of evenly balanced of not guilty and guilty. See, there's other people here saying we don't know if they did find the K-bar and the Dickies. Everything's under seal. They may have found it. They may have been doing tons of searches. Right, K-Mitch? That's what I was just saying. They are late. But we all know how Ann Taylor likes to drag things on. Like she's getting paid $200 an hour from the time she leaves to go to that courtroom to the time she gets home. She's paid $200 an hour. A lot of people still saying that they think that he didn't act alone. Okay, Mitch says we need juror 11 in here to move things along. Okay, so let me take this off. I'm just going to put this on screen for now. That's a lot easier to take off the screen than the banner. What else? Oh, they're still talking about this Papa Roach or whatever his name was. See, here's another one that says, I'm keeping an open mind, but I have seen more to say he is not guilty. I do hope they get true justice for these poor victims. And then there's another one that says, I try to keep an open mind at most trials, but when it clearly shows that the person is guilty and they have all the evidence, sorry, it's guilty for me. So, I mean, you got a mixture of people in here. Another one says, we only have some of the evidence and what the parents have said. I'm waiting till prosecution has laid out all the evidence and see how the defense handles that in the trial, that I will then make my decision. Perfect. There is a perfect juror right there. So, I mean, from what I'm seeing right now, it's pretty evenly balanced out. Another one is saying if his phone showed up on a Bluetooth list for a device in their house, they will never be able to explain that away. But I have to see if it was true and if it shows up. Okay, guys, I got it back. Get it back. Mute and get it back up for you.
Yes.
All right, Dr. Ellen, let's talk about community attitude survey. What is that?
Well, it's a survey designed to estimate opinions and experiences in greater populations, which in this case are the prospective jurors in Latah County.
Is there a specific way you set up to do a survey?
Yes, of course.
Can you tell us about it?
Sure. So a lot of the design and structure of these surveys is based on some of the guidelines, professional guidelines from APOR, which is the American Association of Public Opinion Research, and the ASTC, which is the American Society of Trial Consultants, and also 40 years of people doing this. So the way it works is we randomly select people through a random digit dialing approach. So it's a probability sample. Everybody has a known chance of being included. And the first section is a screener to assess to make sure people are jury eligible. So we have to live in the county, have a driver's license, or be registered to vote, be 18 and over, and so on. And then they're introduced to the survey. There's an introduction actually at the beginning, even before they answer a question, or they're told why they're being called. We're calling to get their opinions about an upcoming trial, and that their opinions are important because they were selected as a representative, household or whatever in the community. And then after they go through that screening process, they're instructed that there's no right or wrong answers to any of the questions. They can always report that they have no opinion or they don't know, and everything will remain anonymous. So the first few questions try to measures just basic criminal justice attitudes to get them familiar with the process, familiar with the survey, answering questions. And then they're introduced to the actual case through a case recognition question. And then if they know about the case, they continue and are asked prejudgment questions, open-ended questions to assess some key opinions, then case knowledge questions, which are recognition questions. And then they go into the demographic section, which is how they consume media. And yeah.
You mentioned two organizations, and I think earlier you mentioned that you were regularly a member of those organizations. Do they help set standards for how surveys should take place?
They did.
And tell me a little bit more about the introduction. Why do you do that?
The first introduction or the instruction after that? They get through the scale screener.
The introduction and then the instruction.
Yeah, well, you're trying to encourage people to participate to increase response rates, right? So you're told again why you're calling. It's not a sales call. We're calling to get the opinions of people in your community and why. So it's not just random. So they understand it's about an upcoming trial. We don't tell them what trial because that would clearly lead to potential response bias. And they're encouraged to continue participating because they represent their community. They were selected randomly. And then there's efforts to increase response rates we do callbacks. So everybody, each number is called up to 3 times at different times of the day. So if somebody maybe is at work, you still have a chance of being included in the survey. There's soft conversion techniques. So if somebody's kind of on the fence, like maybe they're like, maybe I'm busy, can you call me back? We try to find out when can we call you back so we can talk to them later, just to encourage them to participate and not drop off. So all of that stuff is done to increase response rates as best we can. And that's all starts with the introduction. And then the follow-up introduction or instruction kind of is similar. It explains there's no right or wrong answers. They're not forced to say yes or no. They can say no opinion, I don't know. They can refuse to answer the question, all of those things.
Can they answer some questions and not others if that's what they want to do?
Absolutely. That's called a refusal. So they might say, I don't feel comfortable answering that question, or I'm not going to answer that.
All right. So you did a community attitude survey in this case. Did you only look at Lake County?
No.
What counties did you look at?
So we looked at 4 different counties overall. So we looked at Ada County, Bannock County, Canyon County, and Lake County.
I'm going to talk to you a little bit later about the 3 comparative counties. But for now, can you walk us through your high-level findings for Lake County and Ada County?
Sure. So I think high level, you can see case recognition is very high. And it's also high in Ada County. It's 93% there. It's almost everyone in Lake County, 98%, which is similar to what I saw in the George Floyd case, where it was 99%. So this is extremely high. They're pretty much the same. And it's not just a passing familiarity with the case. It's not that they recognize it but don't know much. You can see people in Lake County reported that they followed the case somewhat or very closely. Almost 70% are closely following this case. And again, that means they're actively looking for information, passively consuming information, talking about it. So it's a big deal in this community. And there's a presumption of guilt. The burden has shifted. So 67% believe Bryan Kohberger is guilty of murder, and 25% reported that he's definitely guilty. So these are strong opinions. And 51% reported what I call a fixed opinion, where they reported that Kohberger would have a difficult time convincing them that he's not guilty. So the burden of proof is shifted on the defendant to prove his innocence. And that's undermines due process. That's not how our system is designed to work. And also on the question of sentence, you can see that 52% believe that he should be sentenced to death.
When I look at this slide and I look at the prejudgment, guilty of murder, and am I using that term right? Prejudgment means somebody's decided before we ever get anywhere near trial that Mr. Kohberger is guilty of murder. When I look at those numbers, it's higher in Ada County. And it's not a secret to anybody in this room that our argument is to move this case to Ada County. Does this seem counterintuitive when I look at the prejudgment rate and it's higher percentage-wise in Ada County?
Yeah, so first of all, in my mind, it's two questions. One is, should the case be moved? Not where, it's should the case be moved? Has presumption of innocence been undermined based on the reasonable likelihood standard, which is less than the preponderance of the evidence? So second question is where? In a case like this, you're going to see high case recognition and high prejudgment everywhere. They're essentially the same in terms of 67%, 68%. But when you look at case recognition and size, population size, you'll find that in Ada County, there's about 16 times more people in that county that have not prejudged, if you do the math. So yes, those numbers look the same for those who recognize the case, but there's a much larger swath of people who haven't prejudged. And it's not just prejudgment that matters. So that's one variable you look at, but it's not just that. There's a host of other things. Extent of case knowledge, connections to the case, been exposed to rumors. There's all these other factors that play in. It's not just one item, it's the totality of the findings, not just one question.
When I move to the other slide, what am I seeing on this slide?
So these are instances just to show how invested people in this community are. So almost 80%, 79% have talked about this case online or in person. And that's where information is spread. So even those who may not closely follow the news are learning about it from their neighbors, from their coworkers, from family, from social media, and all of that. So information is being spread through those channels as well. And you do see big differences there when you're looking at Ada County. It's much lower because they're less invested in this case. It wasn't a shocking incident that occurred in their own community. You see that 32% have watched a show, for example, that Netflix or Paramount show or Dateline or something about the case. Almost 40%, 39% personally experienced high levels of stress, anxiety, or fear during the search for the killer while they were here. So that's very high. And then 45% know someone else who has. And if you look at those together, it's actually about 63% have either personally experienced fear or know someone who has during that search. And that shows like the impact it had on them. And you'll see it later in some of the opens where people talk about, I was scared to walk outside or running to their car from work because they don't feel safe. They can see the house from their office. One person mentions that their wife was scared to go to the supermarket. People talk about they locked their doors for the first time. So it just shows the personal fear and impact this case created in this community that you do not see in large communities.
I have a follow-up question for you on this slide. The statistics that you show us show that the incident of looking at things on social media and Netflix and regular primetime news shows is higher in Lake County. And that correlates to the sampling of things you showed us a few moments ago, just your sample of what's out there on social media, on Netflix, and that sort of thing. Is that right? It's higher in Lake County?
It is higher in Lake County. Now, when you say correlates, like I didn't do a statistical analysis, I would say that's the stuff, the content out there. That's what it looks like if you just do a search and you're following it. And on the anxiety question, that number for Ada County is about 32%. So it's much lower.
Looking at this slide, what does it mean with these differences we're seeing in numbers?
Well, to me, again, it shows personal connection, the personal experience. In a big county, there might be a sensational crime, but you don't see people feeling that way. Because crime is unfortunately frequent, and they might be something else that captures their attention, or there's so much going on. It's not shocking. Here, this is something when people talk about, again, there's an idyllic community where everyone felt safe, and this person took it away from us. It was like shattering this sense of security and safety that we have. And everybody experienced it. And my guess is a lot of people can probably reflect on where they were when they learned this and how it impacted them personally. So it's very unique.
What are we looking at on this slide?
I think you skipped a slide. Yeah.
Okay.
Is this one that starts with lived or know someone who would?
Yes.
Okay. So again, this comes back to personal connections. So 78% of survey respondents either lived or know someone who lived in Moscow when the murders occurred, compared to 20% in Ada County. That's not surprising because if you look at the size of Latah County, it's about 32,500 people over the age of 18, compared to about 406,000 in Ada County. And I think it's like 66% of Latah County is in Moscow, so it's a huge percentage. So it's not shocking that people were here or know somebody who was here when it occurred. And a large number of people are students or employees of the university. It's a quarter of the sample. I ran across one citation where it was like 36%, so it's even higher, much lower in Ada County. And you can see 40% of people have visited a home or walked by it where this crime occurred. And again, if you look at some of the opens, somebody talks about seeing the house from their office window. So it's a constant reminder of this awful thing that happened. These are things, again, that jurors coming into that courtroom will see. It's like, indicators in the community of what impacted them. People may be fearful of people know they're on the jury and all those things because it's such a small community and people are so invested. And you can see that 22% of the respondents actually work or know someone who worked for a law enforcement agency involved in the investigation. 22% compared to just 4% in Ada County. So again, direct connections to this case.
And those direct connections, those are things that Latah County juror would bring in. Is that right?
Yes, and that's where we see these big differences in national cases like this. This is typically what you see when the entire state is saturated with coverage. Everybody's going to know about it and have opinions to some degree, but it doesn't necessarily have personal connection. That's why cases like the Oklahoma City bombing case was moved. I mean, that was a national case. Everybody knew about it, but they still moved it because of the personal connections.
Now advance to the slide. What are we seeing on this slide?
Well, this goes back to case knowledge. So we talked earlier in the day about how case knowledge and impacts prejudgment and how we have this belief perseverance. So people develop these more complex schema and case knowledge. They're more resistant to change. And you can see almost 80% of people in Latah County were familiar with at least 5 of the 9 media items we tested in the survey, almost 80%, and 52% knew 7 out of the 9, or at least 7 of those items. So they have a lot of case knowledge here. It's quite high.
While we're here, I'm talking about the media items. Did you test on every media item you could find?
No.
Did you have to select a certain number so that you could do the survey?
What I do is I read all of the media coverage that is local, those local newspapers, and I'm pulling items that stand out, that are repeated quite a bit. So there's like multiple references to certain things and things that are inadmissible, prejudicial, things that are likely to create bias and have an impact.
All right. I want to talk a little bit more about how you set up the survey. What are we seeing?
So this should kind of give you an indication of the flow of the survey. So this is what I call the case recognition question. And it's developed by reading a lot of the coverage and seeing how the case is commonly described in the language in the newspaper and TV to construct a case recognition item to try to trigger a memory. So if someone answers yes to this question, question 2A, they then go to the prejudgment question. If somebody answers no, we give them a little more information to see if that triggers a memory. If that does trigger a memory, then they go to the prejudgment question. And if not, they go to the demographic question. So we always have 2 case recognition questions. That's the recommendation, again, in the ASTC professional guidelines. We usually pick up 1% to 2% when we do that in most surveys.
Does this question come after your earlier questions to get them to take your survey, the introduction and information questions?
Yes, it's actually even deeper. So you get the introduction. First, you get why we're calling, and then you go through screen of questions, and then you're given an instruction about you. There's no right or wrong answers. You can always say, I don't know. I can always refuse. Your answers are anonymous. Then they answer, I think, 3 or 4 general criminal justice questions, and then they get to this question.
When you say the prejudgment question, are you talking about the media items stuff? Is that the same thing you're talking about?
Prejudgment is whether or not you believe a defendant's guilty of whatever the crime is. This is before any of the media items. You would never put those media items and then ask if you think they're guilty, because then you'll create response effects. Like maybe they didn't know that item and you just gave them prejudicial information, and now I think he's guilty because you just told me he confessed or whatever thing it is. Like, you wouldn't want to do that.
Is that why the survey is designed that way?
Yes.
All right, let's talk about some of the survey results. Walk us through what we're seeing here.
Okay, so again, the data suggests that this case has captured the community's attention. This is not a case where people have moved on. Almost everyone in the community recognizes this case. You're at 98% recognition rate. And it's not just a passing familiarity. People are closely following the case. 29% are following it very closely. 39% are following it somewhat closely. So you're basically at 60% closely following this case, which is quite high.
All right, what are we seeing on this slide?
So this is one of the ways we test the validity of our survey. So we talked again, when we talk about the research, we know that people who closely follow a case, people who have a lot of case knowledge, are more likely to believe a defendant is guilty. So one of the things we would expect is to find a similar relationship in our survey, which indicates validity. So, and that's what we find. So whether or not people are closely following this case is significantly related to bias. So if people are following it very closely, within that group, the guilt rate is 84%, and somewhat closely it's 73%. Just kind of looking at it combined, you're at basically 77% of people who are following it somewhat or very closely believe the defendant's guilty of murder. So the more you follow it, the more likely you're to be exposed to prejudicial content, the more likely you are to develop a complex memory and case knowledge, and more likely to have an opinion.
All right, what did you learn about prospective jurors who are talking to each other?
So one is the fact they are talking to each other, and we don't always see that. Sometimes that's 40%, 50%, or even less in terms of talking about a specific case. And you can see here, it's almost everyone. 88% of people who know about the case have talked about it either in person or online. That's quite high. And they're following it, seeing things on social media. They're watching, Netflix episodes or Paramount or whatever it was on. They're seeing shows. They're seeing it in their news feeds. They're closely talking about it. In a small community, that's how information gets spread. It's what we call this informal communication network.
Did you have an opportunity in your survey to learn more about different rumors and things that are going around in Utah County?
I did. So we asked an open-ended question after the prejudgment question, and then it should be what they know about the case and their opinion. And we asked what rumors or theories they've heard in the community to see if they're regurgitating some of the stuff that's been in the newspaper, on social media, the idea, again, of informal communication networks. In smaller communities, you tend to get a lot of like, well, I knew somebody who knew this person, or personal connections, and information gets spread that way. And that's what we saw here. There's a lot of references to things that, the defendant committed a murder in Oregon, like speculation, no evidence of that. It's just something they heard, that he talked about committing the perfect murder in a paper, or that he hates women and he had trouble at the university he goes to with women, and people who worked with him had problems. He stalked her because she didn't respond to him. People were looking at Reddit comments or Reddit posts he had made and from years back, all that kind of stuff. And then references to him, having obsession with some of the victims, ritual animal killings. And these are just a couple examples. Like you'll see that stuff everywhere, but the amount you see in Utah County is much higher. Like, if you go through comments in Ada County, you'll find some too. You can find examples, and I'm sure if you go to Bannock and Canyon, you're going to see them because the case has gotten so much attention, but not to the degree you have here. And given the size of the community, it's much more significant.
Did you record and document all of these comments in the actual survey report?
Yes.
Okay. And that's something that we provided to the court, and the state has no objection, so the court can read the full scope of the rumors from Latah County residents on his own time.
Yes.
Thank you.
Some fun light reading.
All right. What did you learn about Latah County residents that were related to Moscow?
Well, this is kind of the unique nature of this too, that I see in cases like natural disasters, like wildfires is a good example, where it's this like collective trauma everybody goes through. So you can see 76% of residents here lived or knew someone who lived in Moscow at the time of the murders. So they either are here, the loved one is here, and it creates anxiety, right? So I think it was like almost 40% of students left during Thanksgiving, didn't come back because they were scared for their safety. And you see that in the other questions. So asking about if people experience stress, anxiety, or fear during that search, and you can see 39% reported that they personally did, and another 45% reported that someone they know. And if you look at those, it's called a crosstab. And the big question is, did you or someone you know? It jumps up to 63%. So a large percentage of people were anxious and scared about their own personal safety or the safety of someone they know and care about.
Tell me about the open question about people's sense of security. Did people respond to that?
So one of the questions we ask is, how did this crime impact your community? And if I do this in a big county and I ask this, or big venue, federal case, you get a lot of, it didn't, or not much, or, I didn't live near it, so not me, or something like that. You get a lot of that. And I'm sure there's some of that here too. If you look at different things, Ada County probably has a lot of that, and Bannock. What really stood out to me was this shattering our sense of innocence, right? This is an innocent town and no crimes or horrible things ever happened here. And this guy took it away from us. We had this idyllic, safe community, and this person destroyed it. This crime destroyed it. And they talk about people, they never locked their cars before, their homes. I think one person said, he didn't even have the house to his key when he bought it, or a key to his house. That makes more sense. And suddenly people are locking doors because they're fearful. People are scared to go to their cars. Again, someone mentioned, you could see the house from their office, and students and staff would run to their car to be safe. People's partners were scared to go to the grocery store. And there were tons of comments about that. This idea that we have a safe community and it's never going to be the same. It's lost. It's like our sense of safety and security, this special place, this tiny little place that's a bubble from all the bad stuff in the world. And then this thing happened.
The comments that you depicted in this slide, is that all of them, or are there others for the court to take a look at?
There's plenty. On top of reading the other stuff, feel free to read all those opens.
Okay. What about the connection to the house where this happened? What did we learn?
Well, I think it's comes to again, this direct and indirect connections to this case, which makes it unique in Latah County, which you don't see everywhere, is 40% of residents who know about the case, which is pretty much everyone, have either visited the home where the crime occurred or walked by. And so there is this constant reminder of this awful thing, their daily lives. And also you see a large percentage of people are students or employees at the university, or connected to it, the investigation itself. 22% were connected to the criminal investigation. And then 25% were either students or employees at the university. And we know, if you look at it, the university is a big employer in this community. And when all of these students leave, it has an impact on the economy. Over 60% of the county is made up of people who live in Moscow. And if you look at some of the data, it indicates about 36% of people in this county are either students or employees at the university. So even higher than we saw in the survey.
All right. I want to talk about the prejudgment question. What did you learn?
So this question is one of the indicators of undermining the presumption of innocence. So I look at it, I'm always looking, when I think about due process, is the presumption of innocence. And you see when it shifts to a presumption of guilt. So in this case, 67% of prospective jurors who recognize the case believe Bryan Kohberger is guilty of murder, and 25% have a strong opinion on that. So if you think about it, given the high recognition rate here, if 100 jurors walked into this room during voir dire, 66% of them already think he's guilty before they've heard any evidence.
And that's just the prejudgment question. That's not talking about the other factors that you talked about, media awareness, case connection to the community, things like that?
No, that's just looking at everyone. And if you start looking at things like, well, do they know a lot of detail? That prejudgment jumps up to over 80%. Do they closely follow it? Jumps up to 70%, whatever it is. So that's just looking at the entire set. Start looking at other things, that prejudgment gets even higher.
You've talked about what you've defined as a fixed opinion or a fixed presumption of guilt. What did you find about that?
Yes, so the question I ask is basically based off, I'm going to start talking selective now. Based off of what you've read, seen, or heard, would the defendant have a difficult time convincing you that he's not guilty? So burden of proof shifting on the defendant. I think I mentioned this last time, but that question was developed by a judge in Tennessee. And what you were seeing was they would ask jurors, what do you know about the case? And they would tell them some information or minimize what they know. And then the question was, do you think he's guilty? And maybe they'd say yes. And then they'd say, but I can be fair and impartial. I can set it aside. I think I can do it. And then the follow-up was, well, would he have a difficult time convincing you that he's not guilty? And oh yeah, I can't change my mind. So it's just much more effective. I find it's more likely to be correlated with these other indicators of bias. So it seems to be more of a valid question. And when I did it, you see basically 51% indicated a strong opinion that would shift the burden of proof onto the defendant. And again, if you look at our analysis of 100 jurors walking in, that would be 50 out of 100 would fall into that category.
They can't change their mind.
Well, I'm sure you can get them to say they can be fair because I see it all the time. But this doesn't mean they can't. We heard a lot about that earlier today. Yeah.
All right. And did you ask similar questions, prejudgment for guilt, I guess prejudgment for the sentence?
Yes. So because this is a capital case, I did ask whether or not which sentence do they believe the jury should select if he's convicted. And you can see 52% reported that he should get the death penalty based off of what they've read, seen, or heard, whereas just 23.5 or 24% reported that he should get life.
Did you ask a fixed question about the penalty?
Yes, so I asked the same fixed opinion question, and you find that 51% believe that the sentence should be death and that he couldn't convince them that it should be life. Only 19% reported that the defendant would not have a difficult time convincing them that he should get a life sentence.
This is a small community. What did you learn about the impact of this case on this small community and the pressure of a juror in Utah County to convict?
So one of the things I wanted to look at, because it's a small community and people know everyone, and the pressure when we're coming in and out of this courthouse on a day-to-day basis, when it's been inundated with journalists, and my guess is people can figure out who's on the jury by who's not picking their kids up at school and talking to neighbors and all that. Is there pressure? Do the jurors ever feel pressure like there has to be a certain outcome? How would the community react if he's not convicted, if he's found not guilty? And there was quite a bit of strong comments on a range of themes, from people would basically kill him, to they'd burn the courthouse down, or assume that the jury failed, or that he would have to prove that he was not guilty. Again, shifting the burden. So it's like, I can't imagine that happening because they have so much evidence against him. We would be dumbfounded. Like, how could he not be guilty given the amount of evidence? Several would be on the hunt for him to make sure he gets what's coming to him. And then just emotional stuff about it would be devastating to the community. Other people talked about the fear if he didn't do it, well, who did? Like, that means this person's still among us, who creates the same stress and fear and anxiety that people had before. So this community needs closure. And you have to imagine what that's like for a jury for months on end, in and out of this courtroom in this tiny community, and trying to explain to their neighbors, what they did and why. And that shifts the burden again back onto the defendants.
The comments that you've captured in this PowerPoint slide, is this all?
Yeah, these are just a few examples.
Plenty more for the court to read?
Yeah.
Did you ask these open questions in the comparative counties too?
Yes, it's the same question as in all the counties.
Were the other counties as high of rate in these kinds of answers? Did they have a similar kind of answer as Latah County potential jurors did?
No, and now you can read through it and you will find answers that people would be angry and upset because you're talking to hundreds of people and you're going to get those. But they're much less strong. They're much more, no opinion. They wouldn't have an impact, things like that than you see in other places. Very few people in Latah County have that.
All right, I think we have a couple of slides on the questions that were in the survey. I think we know those.
Yes. So these are our case recognition questions, we call them, I call them recognition items, I guess. So we do ask an open-ended question. What have you read, seen, or heard about the case? We'll get into that, but that's the typical question you ask in jury selection. And people answer that, but they often use minimization language or unable to recall everything. So we ask later on these case recognition items to see if they're familiar with widely reported media items. And if you look at the professional guidelines, this is what's recommended. So we first ask an open-ended question, and then later we follow up with these closed-ended questions.
What did you learn when you did that in this survey with Latah County?
So I'm not going to go through all of them, but we learned that people are familiar with many items that have been widely reported in the media. And you don't always see that. Sometimes case recognition is high, but people don't know a lot of detail. Maybe they know a few items or recognition rates are 40, 50%. But what we found here are people have well-developed attitudes and opinions and have been recall a lot of prejudicial content. So in Latah County, you can see that 79% were familiar with at least 5 of the 9 media items, and 52% knew 7 or more of the media items that we tested, over half.
And you tested on 9, is that right? 9.
Yeah, up to 9.
And I think you mentioned, but I think your chart's going to explain to me why more media items, more media recognition items correlate with the prejudgment question of guilt.
Yeah, and this goes back to validity of the survey, right? We know from earlier research that case knowledge is correlated with prejudgment, and that's exactly what we found. So the more people know, the more case knowledge, the stronger their opinions, the more likely they are to have developed a perception of guilt. So people who are familiar with 5 or 6 items, you can see it's 66% guilt rate, and for 7, it's 82%. So jumps up quite a bit. So the more case knowledge you have, the more likely you are to believe guilty. And you see the same thing with that, I call that fixed opinion question. That's significantly related to case knowledge as well. So the number of people who said that he would have a difficult time changing their mind is essentially 66%. If they know 7 or more items.
Let's talk about the specific items that were known, just a few of them. We won't go through all of them. What did you learn?
So these are just going through a few that we tested, and you can see high recognition rates and significantly related to prejudgment. So whether or not people know that a knife sheath was found on the bed next to one of the victims, 81% of survey respondents in Latah County knew that detail. And you can see it's significantly related to bias. So if you knew that, 72% of people who knew that item believe he's guilty, and 55% reported that he would have a difficult time convincing them otherwise.
What about another media item?
What about what?
Another media item?
So the next one is whether or not they knew that DNA was found on the knife sheath, that there was a match for the defendant. And you can see that 67% know that detail. And if you know it, it's highly prejudicial. So 75% of people who know that item believe that he's guilty, and 60% reported a fixed opinion.
How about a vehicle recording?
So this one, whether or not Bryan Kohberger owns the same type of car recorded on the video driving in the neighborhood where the killings occurred. This was a widely reported media item. So 86% of people know that detail. And 82% of those who do know that believe he's guilty. Quite high.
How about the cell phone tower media item?
So on that one, you see a case recognition rate of, or item recognition rate of 79%. 79% of survey respondents do that detail. And if you knew that, 72% of them believe that the defendant's guilty.
How about the media items studies?
So this would go down to like a misinformation, I'll call it an inaccurate detail that was widely reported that the defendant had stalked one of the victims. And you can see recognition rate currently at 45% when the survey was done. And 81% of people who knew that detail reported that guilty.
How about following on social media?
I believe this is the last one. You can see whether or not he was essentially following them on social media. 45% recognition rate and 79% of those who know that believe he's guilty. And these are all statistically significant findings.
Let's talk about some of the comparative counties that you surveyed, and if you can give me a high level of your key findings in those counties.
Sure. So now, in my mind, this shows significant bias, that there's a reasonable likelihood that the due process has been undermined in the sense that there's a presumption of guilt in this county. And the question is, if you were to move it, is there, where would you move it? That's question 2.
We're on to the second part.
We're on to the second part now. That's where this comes from. So you'll see recognition rates are high in these 3 counties we tested. So we tested Ada County because it's the biggest county in the state. It's about 406,000 people over the age of 18, and other high-profile cases have been moved there before and recently. Canyon County we picked because I believe it's the 2nd largest county, and it is also near Ada County. So it's a big county. We picked that, and we picked Bannock County because it's just far away. And it had less media coverage. So we wanted to see if there was a possibility that people would have less case knowledge there. And you can see recognition rates vary from 90% to, from 84% to 93% across those 3 cases. And you can see that in terms of how closely they followed it is less than we saw in Latah County. So Ada is 58, Canyon is 51, and Bannock is 46. Compared to Latah County, remember, it was 68%, much higher. The guilt rates are essentially the same, or it's a little higher in Bannock County. But because of the population size, there's a big difference. So again, you'll find about 16 times more people in Ada County who have not prejudged compared to here. And then similar in terms of the strength of opinion and difficulty in convincing them that he's not guilty, similar to what you see here. And sentence similar as well. So you're in the 49 to 57%. So these numbers are also high.
Where do you start to see differences that matter?
You start to see differences when you talk about personal connection. That's where the big differences come up. So remember we said 79% of people in Ada County had talked about this case. Might be wrong, might have been higher. It's just 60% in Ada County, 50% in Canyon, and 51% in Bannock. So it's much lower. You'll see whether or not they've experienced high levels of stress. In Ada County, it's just 17%, and the other 2 counties, it's only 11%. It was 39% in the county here. And then whether or not they know someone who experienced higher levels of stress, we had 45% here. Here we're down to 24, 19, and 19. So you see big differences there in terms of the community connection, the personal connection, their case.
What about the connections to Moscow that are unique to this area?
Yes, so just 20% in Ada County know someone who lived in Moscow. 15% in Canyon and 16% in Bannock, 78% in Latah County. Whether or not they were a student or employee in Latah County, that was 25%, and we're looking at 4% and 3%, much lower. Whether they visited the home or saw it, Latah County is 40%. Here we're down to 8%, 3%, 2%, much lower. Whether or not they knew someone who actually was involved in the investigation, in Latah County, that number was 22%, I believe. And in Ada County, it's just 4, Canyon is 2, Bannock is 2. So much lower when it comes to those type of connections, the personal connection, personal investment in the case.
What about the recognition of media items?
Yeah, so we had, I think it was 79% in Latah County knew at least 5 of those media items, and it drops to 65% in Ada, 52% in Canyon, 59% in Bannock. If they knew 7 or more, that was 52% in Leda County. It's just 42% in Ada, 27% in Canyon, and 29% in Bannock. So less case knowledge. And we know case knowledge comes back to belief perseverance, right? So the more you know, the more resistant your attitudes are to change, the more likely you are to attend to and process information consistent with what we know. New information about the DNA evidence, I already know about that. That's credible, I give that weight. So you're much more likely to see that in Leda County future.
All right. I think you told us a little bit about the population size. And is that why you selected Ada as the population size?
So I'm not selecting anything. I'm just pointing out some possibilities. So I selected Ada County in terms of to do the survey because it's the largest county in the state. And, you know, I think it was the Dale case was moved there. So you know that they can take this case in. We know large counties, it's less of a big deal when the case moves there. It doesn't become the biggest story in that community. So I wanted to test Leda County. Pick Canyon because it's the second largest county, over 184,000 people. And then I picked Bannock because it's further away. It's quite far away, hundreds of miles from here, and it's in a different media zone. It does have some of the similarities of Leda County. So for example, there's a university there that's the second largest employer. So there's a risk there. Like 18% of the population is connected to that university. So there are those risks. And I think the problem there, while some of the numbers are good, are it'll become a huge deal if that case is moved there. You're gonna have the media circus move from here to there, and it's gonna become, again, a huge story in that community. So there is risk if you choose a smaller venue that something like that will happen.
And that risk is tied specifically to the size of Bannock County?
Yes, smaller counties, you don't have stories like this regularly happening. So it's more likely to become a big deal in that county. And you could end up with significant bias between the time the case is moved and the time it goes to trial, because there might be an increase in media coverage there.
When we talk about the survey itself, was it only people who knew about the case that took the survey?
No. That explain to me what you mean by that.
Well, I'm looking at your slide here about people who, whether or not they know about the case, do they finish the survey? I think one of the things the state's criticized about is a non-response bias. So I want to understand if you can tell us that about how the survey works, this one and others.
Right. So first of all, one thing we do is we do comparison surveys in a host of different cases. So if you look at other cases we've done this on, if that were true, you would find that only people who know about the case take the survey in the comparison county as well, right? So you can see in Renfro, this was an Idaho case, in Kootenai County, 89% of survey respondents recognized the case that took the survey, that completed it. In Ada County, 67% of the people that completed the survey did not know about the case. So you would expect you wouldn't see that trend if people just say, oh, I don't know about this, I'm not going to take the survey, I have no opinion. In state of Tennessee, v. Andrew Delkey, similar findings. So in Davidson County, 67% of the people who completed the survey knew about the case. In Hamilton County, 84% of people who completed the survey did not know anything about the case. In United States, v. James Cloud, which was in Washington, you can look at, we did 3 venues, and in Yakima, the 55% of the people that completed the survey knew about the case. In Richland, 82% did not know about the case. In Spokane, 90% did not know about the case. What's unique and why you see high recognition rates across the surveys here is because it's a national case. And when we have national cases, you see high recognition rates all over. So this last one, the state of Minnesota, the Alexander King, was the George Floyd case. And you can see high recognition rates in all the counties, just like we see here. The reason is because there's a lot of media exposure everywhere. But it's not that people are hanging up because they don't want to take the survey. In fact, if you look at the call data, after they were told the case recognition question and described the case, only one person hung up out of the 1,200 people that completed the survey. We had one person who terminated the survey after being told what the survey was about. Everyone else.
All 4 counties?
all 4 counties, one person.
All right. We have talked quite a bit about the bias and the prejudicial media coverage and the difficulty, the impossibility that will happen seating a jury in Latah County. I want to talk a little bit about jury selection in cases that have a lot of publicity. Are you familiar with that?
Sure, yes.
All right. Why should we talk about this now? Why do we not want to just wait and try to pick a jury first?
Well, I think first of all, I've done a lot of jury selections. I'm sure you have, Your Honor, you have, I'm sure you all have. So we all know how the jury selection process works. So in a normal case, people do not have case-specific attitudes. And we know specific attitudes are predictive of behavior. So I might just have a general passing attitude towards something. I mentioned DUI, or it's like a contract dispute. Like, you can ask me questions. I don't have strong opinions. I don't know anything about the case. So they're not specific attitudes. So jury selection is effective in that scenario. It's fine. But when people have case-specific attitudes and case-specific knowledge, and I've heard information and evidence, even if it's coming into trial, I heard it in the context of a news story. There's no rules of evidence that were applied. There was no cross-examination. There was no counter expert to refute what was said. It was just said by a public, speaker. He was on an editorial on a television station, on Nancy Grace. So it's very different. And then when I hear it as evidence, it's just confirming what I already know. It's not new, not processing it for the first time. So that's one of the big problems. So why you need to identify people that have that content and information. And there's challenges because of the way memory works. Recall is limited, and we'll get to that. But when you ask people, what do you know about the case? They are not able to give a full account of everything they know. So it's very hard to assess what people know, which makes it very difficult to exercise cause challenges and predicate challenges. And the other thing is just the nature of jury selection. It's very easy to rehabilitate a juror to get them to say they can be fair. It happens all the time. So a juror says that I had this experience, or I think I'm leaning towards one side, and it's so easy. We do it all the time to get a socially desirable response. You start with, well, the law requires everyone to be fair. Everybody has their own opinions, and that's okay. We're just asking you, can you follow the law? Can you follow the instructions? Can you deliberate? Can you be fair? And most people will say yes to that because they want to create a socially desirable response. They know what the right answer is. Give leading questions. In one study, they actually analyzed a transcript, or 3 trials transcripts, and it was like 60% of the comments during voir dire were from attorneys and judges. Just 40% were from jurors, and 63% of the comments from jurors were one-word answers. And I see that in the post-conviction stuff I do when I analyze transcripts. It's 3 pages of indoctrination into what a juror is supposed to do, ending with a closed-ended answer, can you set it aside? That's not an indicator of their ability to do. People can't just men in black flash heaping themselves and forget everything. It doesn't work that way.
I think we may have covered voir dire and honest disclosure with that, and I didn't advance the slide. Can you give us a case example or an example of this?
Sure. So this is an example of a stealth juror. So a case like this, you're a stealth juror, there's a likelihood that people want to be on this case, right? It's a high profile case. It's going to be on TV. You're going to get a lot of attention. There might be a desire to seek justice and you want to be involved in that. Well, how do you identify jurors like that? So this is an example case I worked on where it was a long time ago. It was in LA. There was this division in the police department called the Rampart Division, Rampart. And basically there were a number of corrupt police officers who were stealing drugs out of the evidence locker, shooting suspects and planting guns on them. It was these rogue police officers. And one of the people, his last name was Ovando, he had been shot by a police officer, this guy Perez, who then planted a gun on him and alleged that Ovando had shot at him. So he was convicted of attempted murder. He was paralyzed from the waist down. And then Perez got caught stealing drugs out of the locker room. So he confessed to all these things, and Ovando was released. He got like a $20 million settlement against LA County. Then he sued the public defender, claiming that, they should have figured this whole thing out and known that, there was this scandal and so on. And it won like $6 million in that case. And then later, when they looked, it turned out that one of the jurors on that case had been in a movie about the incident called Gang Wars. And when they were asked, has anybody have a connection to the case? She didn't raise her hand. But during the deliberations, she talked about stuff she knew. She talked about stuff that didn't come into trial, and it resulted in a mistrial. So that's just one example. There's other examples as well. But yeah, so that's one challenge you have in a case like that.
All right, recall and recognition. I think you're going to talk to us about how hard it is to ferret out what somebody knows.
So to me, this is one of the biggest challenges in high profile cases. So the question you ask on a juror questionnaire and an open voir dire is, what have you read, seen, or heard about this case? That's the open-ended question you ask. That is what we call a recall question. And the cognitive task is, on the spot, I need to search my memory and see what's accessible and salient and what I can remember on the spot. And I'll tell you. And then you usually followed up with, can you be fair and impartial? And what we find is people are not able to recall everything they know. And that information that they forgot to mention comes up later. So the common example is, tell me everything you know about a movie. I'm going to go with Star Wars. And you probably will tell me a lot because a lot of people have seen that movie or seen it a bunch of times. But if I asked you follow-up closed-ended questions, you'd find that you forgot to mention a whole bunch of things. Like maybe you didn't mention that Luke Skywalker was Darth Vader's son, right? And it was, do you remember that? Oh, of course I know that. I just forgot to mention it. So you see things like that. So the tricky thing is you can't ask people, have you read, seen, or heard if the defendant was stalking one of the victims? Because now you're poisoning the well. What if they didn't mention that and they're open-ended? Doesn't mean they don't know it, because we know about 45% of the population here does know it. So you're in that position where you are trying to make an assessment if this juror can truly be fair and impartial without knowing what this juror actually knows about the case. And that's one of the biggest problems you have in high-profile cases that are not a problem in your run-of-the-mill typical case.
Have you seen that bear itself out in a real case?
I have. This was a case in Texas where we actually had community members come in during the venue hearing and treated them like mock jurors in a sense and asked them what they knew about the case. And they told us it was a big case at the time in Hidalgo County in Texas. And people told us what they knew. And then we asked, is that everything you know? And they'd say, yes, that's it. And because it's not real jury selection, we had the opportunity to demonstrate this whole problem. And we would say things like, well, did you know that he allegedly confessed? And then it would stimulate a memory. And the person would say, oh yeah, I did know that. He actually confessed twice at a monastery. So it triggered a memory. And then it was, well, is that everything else you know? Do you know anything else? And they'd say, no, that's it. And say, well, did you ever hear that he had committed another crime? And they say, oh yeah, that's right. He actually attacked another girl at a different church in a nearby town. And it was, well, is that everything you know? Take your time, search your memory. That's it. And then we do it again. And it was, well, did you know there was a cover up? Oh yeah, the Catholic Church covered it up and the police department. And it just demonstrated the problem. Now, that was fine in that little demonstration we did, but you could never do that in jury selection, because if you did that, you just poison that juror. If they don't know it, you just poison them. If they did know it, then you have to get rid of them, right? So you're in this impossible position in terms of trying to figure out if this juror can be truly fair and impartial when you don't know what they know.
Do we have a glimpse of how that works in Bryan Kohberger's case based on the search warrant?
We do.
All right. How do we know? Tell me about that.
So we always use the open-ended question. What have you read, seen, or heard about the case, and code it? And what we found is, on average, people reported 1.6 details when asked that open-ended question. So we know that's the average number of details they report. And then we compare that to the closed-ended questions later, those 9 media items to see if there's additional items that they actually recognize that they failed to mention in the open. And what we found in this case was that 96% of survey respondents knew at least one of these media items that they failed to mention in the open. And on average, they recognized an additional 4.9 media items. So almost 5 out of the 9 failed to mention. And these are just some examples. So, someone said, what have you read, seen, or heard about this case? Just what has been on the TV and the papers. So that's minimization language. They use the word just. There's no specific detail. But later when we ask those closed-ended questions, that person knew all 9 of them. Another one is just what I've read and seen on the news and newspapers. Again, knew all 9. Read articles about the case, knew 8 of the 9. Just what I read in the papers, same as everyone else, 7 of the 9. So these are just a few examples, but this is what happens. This is what you see on juror questionnaires. This is what you see in voir dire. And I mentioned that, anyways.
And that's dangerous in this case because of the amount of prejudicial media coverage. Is that right?
It's dangerous in this case and in high profile cases. That's the unique problem they create. What's unusual in this one is, 1, it's in a small community, and 2, people here have very well developed schema and attitudes and case knowledge.
I think you have some specific examples of some of the media items tested about how many recognized an item that had not reported.
Yeah, so just to give it two examples to make the point. So this is the one we talked about, whether or not the defendant stalked one of the victims. Prejudicial, 45% of survey respondents recognize this item when we ask, have you read, seen, or heard it? But when we ask them the open-ended question, what have you read, seen, or heard about this case? Only 3% mentioned it on their own. So 3% of people reported this item, but 45% actually recognize it later on. And we know it's not only is it not true, but it's also prejudicial because 81% of people that know it have already judged the defendant as guilty. So it's really important to know who are the people in this panel that know that detail. So your choice is to just assume no one knows it because they didn't spontaneously mention it, or poison the well by asking the juror specifically, did you know that Bryan Kohberger allegedly stalked the victim? So that's a difficult position to be in.
Let's look at one more example of how that worked.
So this is the one about the knife sheath, whether or not police found a knife sheath on the bed. So you probably want to know that. Well, 81% of people recognize that item later, but only 8% mentioned it when asked the open-ended question. So again, just demonstrating the problem. These are items that are correlated with bias. We know that there's a high rate of recognition in the community, but when you ask in jury selection, what have you read, seen, or heard about the case? Very few people mention it. This is what you see.
All right. The magic question, can you set it aside and be fair and impartial? Is that going to work?
I'm sorry, what's the question?
Is this going to work? This question.
Yeah. So you want to, what is this a good question, bad question?
Will it work? Will it help
Will it
us?
work? What does work mean? I don't know if you think about that.
Help us find an impartial jury.
No, there's no data to suggest that this is a valid question. And just touching on the research again, what you would expect is people that know a lot about the case or been exposed to prejudicial pretrial publicity would be more likely to say they cannot be fair and impartial compared to people that do not know a lot about the case. And there's no significant relationship. People who know a lot of detail and have been exposed to prejudicial pretrial publicity are just as likely to say they can be fair and impartial as people who have not. So there's no data to support that.
And do you have an example to tell us about?
So this is some research I did on this question to see how people respond to it. And so what I did was I went to a Facebook page that was about this documentary on HBO that got a lot of attention called The Jinx. The Jinx was about a person named Robert Durst who had been a suspect for multiple murders. For his wife, he went to trial in Texas for murder, and then a good friend of his in California was killed, and he was suspected to be involved in that as well. What was unique, he was from a very wealthy family in New York, so it captured a lot of people's attention. And there was this mini series on HBO. And at the end of it, they confront him with some evidence that would suggest he was involved with his friend Susan's murder. And he takes a break and he goes into the bathroom and he forgot that he was wearing a microphone, and he pretty much confesses. He says, "Of course I shot them all," or "Of course I killed them all." He's talking to himself. So it was a highly prejudicial documentary. And later on, he was charged with the murder of his friend. So what we did was we went to this Facebook page where people had made public statements about the defendant that were highly prejudicial. So this is just one example. Someone said, "This is a true version or vision of a sociopath. I'm physically ill over the conclusion. I'm beside myself. I was overjoyed at the news that he was arrested." So if somebody said this in public about this case, I think we all agree that person probably can't be fair. You're publicly stating it to the world. You think he's a sociopath. So we recruited people that made these extreme comments on this page and went through a survey. And we asked if they knew about the case, whether they thought he was guilty, what they knew, and so on. You can see, as you'd expect, almost everybody we recruited who made these public statements reported that Robert Durst was guilty of murder, 92%. And reported strong opinion. 77% of the people we've recruited said that he could not change their mind about his guilt. So almost everyone. And then we asked those closed-ended case recognition questions, and many of these are either inadmissible or very prejudicial. That he was like a suspect in his wife's disappearance, probably not admissible in a different case. His murder trial in Texas, we asked several of these. And the confession, the captured confession, you see 100% knew that, which is considered like the most prejudicial thing that can be in the media, according to the Supreme Court. And so what we'd expect is that these people would say, "I cannot be fair and impartial." There's so much bias that they're demonstrating. So we give them the magic instruction that you often see. This came from a transcript in a high-profile case where the court had explained the burden of proof and that the defendant's entitled to a fair and impartial trial, and that the law requires that you set aside everything you know and only rely on the evidence, common things you hear. And all these people who express all this public bias and all this vitriol and reported that he's guilty and you can't change their mind, by just saying that to them, magically report that they can be fair and impartial. 81% said they could be fair and impartial after hearing that instruction. And they gave open-ended responses as to why. So this is our participant who mentioned that they were overjoyed by his arrest and they were physically ill, and that Robert Durst was a sociopath. Well, on a scale of yes, definitely to no, definitely not, they reported that they could definitely be fair and impartial. And they reported that I could start from the beginning and listen to all the information presented and follow the directions and wipe out everything that I know. I would need to be convinced beyond a shadow of a doubt. So that answer, if you see in a courtroom without knowing that this person was making public statements about the defendant being a sociopath, probably considered rehabilitated, that's a fair and impartial juror. But it demonstrates like a person like that should be answering that question no, but they don't. And even kind of going back to the Rideau case, which was recorded confession in the police station with the chief of police on one side and officers on the next, played in the media with music on it. It was highly prejudicial in a small town, and the Supreme Court ruled that threw out the conviction because of it. All the jurors in that case who saw that confession reported that they could be fair and impartial. They all sat on that trial. They all reported that they could be fair, and the Supreme Court didn't take that at face value because the content of the coverage was so prejudicial.
All right. Based on your years of experience, your education, all of the work that you do in general, and then specifically the work that you've done in this case, the survey, the hundreds of comments, do you have an opinion about this case and whether we can seat an impartial jury in Lake County?
I do.
What is your opinion?
So my opinion is based on whether or not there's a reasonable likelihood, so using that standard, which is less than less than the preponderance of the evidence. Leda County is a small venue, and the crime has been seared in the community's consciousness. People have been saturated with prejudicial coverage. Many people here have direct and indirect connections to this crime. People here demonstrated they experienced fear and stress, panic in this community. There's significant rumors and misinformation that have been spread and people have been exposed to in this community. There's a feeling of pressure to convince, I think, given the reaction that people think the community would have if he's acquitted, that's particularly concerning. We know from the data that jurors have closely followed the case, they've talked about it, they're familiar with prejudicial details. I think that the presumption of innocence has been undermined and a presumption of guilt prevails in this community. Opinions will influence how people process evidence. So even if the same information is presented at trial, there's a big difference in terms of jurors being exposed to that for the first time. I don't know about the DNA evidence. I don't know about the videos versus a juror being exposed to something that they already know, where they're just confirming what they already know. I already know about the DNA evidence. It's just triggering a memory of what I already recall. And I'm processing this information through that filter of it's consistent with what I believe and I already know. And it impacts how they see government witnesses and how they will view and evaluate defense witnesses. And I don't think voir dire is an effective remedy given the research I've done, my experience doing jury selections, and the nature of how memory works. So taking all that combined, I think it's appropriate to change that.
Thank you. I don't have any other questions, Your Honor. And Alderman Hank had a few statements.
Okay, thank you, Ms. Taylor. So this would be a good time to take a break.
Sure.
And we'll come back at 3:20. Thank you. After that.
No.
Boo! Okay, how many did I scare? Like, what time are they coming back? How long are they out? What did he just say? Like, I missed it. It's like my butt hurts. I want to get this draw done. You know what? We're going to do the draw. While we're on break, we are going to do the draw. He keeps saying, I don't think. It's like, hey, bring the dinosaurs into this, and come on, what's wrong with you? So excited. How come they didn't have Ada County and Latah County side by side in those statistics? They didn't want it there because they were so close. Okay, so let's stop sharing this. I'm going to still have it up on screen, you guys. I will put it back up. But let's do the draw now. Let me get the wheel over here. We're going to do the draw. Is everybody ready for this draw? You got 1 minute. What's going on? What's going on over here? Let me refresh my page here because I'm losing my mind. I'm losing my mind. Look at the sun's going down. The sun is finally coming in my living room window because the sun is going down. So maybe I can get some of this sparkle. Oh, you can't see it. It's sparkling so much now. You can't, Anyway, this is the diamond painting. It is sparkling. Oh, I wish you guys could see how I'm seeing this. It's reflecting off my ceiling and everything. It's sparkling so much. But now you can't really see it. There we go. So here's the diamond painting framed. Here is the book. Thinking about Willow. Stop it. Don't make it weird. Don't make it weird, Carol. Oh my God, you guys. Who bets Mitch wins? Is everybody ready for this draw? Because I'm going to bring it up. I'm going to bring it up. And we're going to do the draw now. Instead of waiting till the end, we're going to bring it up now. So here's everybody's name. So is everybody ready for the draw? Everybody ready to see who wins this? And whoever wins, please email me right away so I have your address for tomorrow because I want to get this shipped out tomorrow. So I'm going to keep clicking shuffle until somebody tells me to stop. So you can see me shuffling the names here. I'm going to keep doing that, shuffling them until I see somebody type stop to the screen. As soon as I see the stop typed to the screen, then I will stop and do the spin. I'm going to keep clicking shuffle until somebody types stop to the screen. Type it in this chat, please. Somebody, anybody. First one to type stop, I stop. My finger is going to get sore. Somebody type stop to the screen, please. Come on, somebody type stop. Come on, Carol, type stop to the screen. Somebody, anyone, type stop. My finger is getting sore. Come on, type stop. Thank you. Okay, so let's do the spin. Everybody ready? Everybody ready? Let's see who wins. Let's see who wins. Here we go. Oh my gosh. K-Mitch. K-Mitch wins. Who said that? Carol says, who bets K-Mitch wins? K-Mitch did win. We did the draw live. K-Mitch won. Told ya. So K-Mitch, I do think I have your address already, but email me it again. Let me see who said it. Right there. Who bets K-Mitch wins? There you go, K-Mitch. So email me again your address. I usually don't keep my previous addresses. I do think I have yours because you're a mod, but I'm not sure. So message it to me anyway so I can get this mailed out to you tomorrow. Okay, K-Mitch, thank you so much to everybody who entered. We'll maybe do another draw. I have a bunch of diamond paintings that I may give away, send out, depending on, like when I get a lot of super chats and that in the lives and that basically covers the shipping from Canada to the US, because this is probably going to cost me, well, I just put out a diamond painting and a few little other odds and ends that I sent out to Dolly Vision because I did him a diamond painting of Turtle Island and it says Turtle Island across the top. I sent that out and it cost me $48 just to ship it. So when I get a lot of super chats and stuff like that in chat, then I can give back and it helps cover at least the shipping. Not the cost of everything, but at least the shipping, right? Because I did pay $48 for the book. This, I think I paid like $6, $7 for the actual canvas, but then it's my time and everything putting this all together and buying a frame. So you got probably about $60, $70 value here. Not cheap stuff. So there you go. So let's stop sharing that. So this will be sent out to you, K-Mitch. Just email me so I have your address and everything that's up to date. And I will be shipping it out tomorrow. I have a bunch of stuff I have to ship out. So this will be going out to you tomorrow. I'm going to put a little note in here for you And I've already put on the back. Whoops. I don't know if you can read it here. Completed by Willow, above and beyond Ancestor readings. And I completed this August 2024. So I put the little sticker on the back. So you will get that, K-Mitch, and the book. So I will be packing that up nicely so it doesn't get broken and shipping it out to you tomorrow. Congratulations. Let me just write this down. K-Mitch and Nana. We're in a battle this afternoon to win that. All right. So let's get the court thing back up. So as soon as it starts, you guys, I'll have me down here for now. Maybe I'm gonna put you this way. There we go. So I'm here. My desk is getting pretty racked up. Look at this. That's from, I try and do all my diamond paintings here. So when I'm listening to things or watching other things or whatever, did you hear D flatline twice? Yes. I have an update on that. Also, he is out of ICU now and he is resting. He's in a regular room now. For those of you who know who Dolly Vision is, he has been transferred out of ICU. Yeah, I knew that he flatlined twice on the table. And they got the stint in and had him in ICU for a couple days. And now he is in a regular room. He is out of ICU and doing well. So, yeah, Dolly Vision, for those of you who follow Dolly, he does Turtle Island and all that. He did. He suffered a heart attack in the early hours of Monday morning. So thank God PJ was an EMT and PJ was there. He's home now? Okay. I knew that they were getting ready to release him, but I thought that they were going to keep him until tomorrow. So good to know he's home now. I best not see him on YouTube for at least another week. I know he's itching. He was in ICU wanting his phone so he could answer people and stuff. Like, he's a diehard man. Like, it's going to take more than a heart attack to take that guy out. But it doesn't matter to me whether you guys love him or hate him, dislike him, whatever. Nobody deserves, to have something like that happen to them. And I just love him to death. He really brightens my mornings some mornings, and I listen to him quite often. He's one of the ones that I do listen to. And if nothing else, I get a good laugh out of him. So we wish him all the best. If you don't wish him the best, please just keep your comments to yourself. We wish him the best, speedy recovery, and I hope he's on the mend. But I hope he does not jump back on YouTube. Although we all miss him and miss his segments, I really hope he rests up and gets all his strength back before he jumps back on these crazy streets, as he calls them, on YouTube. Right? Nobody can replace that guy, that's for sure. So we wish Dolly all the best, and I'm glad that he is home. I thought it wasn't going to be till tomorrow, but I'm glad to hear that he's home. So I guess I can turn this light out now, since we got the sun coming through. Look at my hands. It's like, ooh. That's the sun coming through my window. I only get it between usually around 5 till about 7. When the sun starts going down is when it comes through this window. During the day, I don't get any sun through this window at all because I have a covered porch, just like a roof. He's so funny. I think sometimes some of the stuff that comes out of his mouth, I think he shocks himself. And it's like, I know that feeling. You're very welcome, K. Mitch. And thank you to all of those who super chatted and put super chats in. It does help the channel, and it also helps me to be able to give back. So congratulations again, K. Mitch. Enjoy the book. Let me know what you think about it. And I will write you a little note in there. Okay, Mitch. I won't forget. And you had to, I forgot to put a note in the box with all the stuff that I packed up for Dolly because I was in a hurry. I got him 2 signs. I got another, it's a metal sign, and it has a turtle in the bathtub with all the bubbles coming out of it. And it says, get naked unless you're just visiting. Don't make it weird. And it says, and then I had Dolly soap put on it. There was a couple of other things. I got him a travel turtle to keep him safe during travels, like a keychain thing. I got some stickers for both him and PJ. I got him a bunch of stuff, and I just wanted to get it out to him because the weekend was coming, and I wanted to get him to get it before the weekend and whatnot, and totally forgot to put a note in there to say who it was from and everything. But he knew it was from. PJ knew who it was from, being as it almost a wedding gift. There you go. So congratulations, K. Mitch. My mama is out on the front porch next door. Our porches are very close together, and she's out there and she's being loud. I'm gonna go give her shit. I don't know if you guys will pick this up. Watch this. I'll give her shit. Watch. Hey, you 2 old hens, you want to keep it down? I got a live going on. Come and say hi, Mother. We're waiting. Come on. Because I told them that I was going to come out here and give you shit, so.
I thought you were off, Donna. I'm sorry.
Okay, so yeah, her friend's here with her too. So here's Mama. I'll let her say hi to yous.
Hi, everyone.
She thought that I was really giving her crap. We're on a break right now. See, we're currently on a break. We're waiting for the judge to come back.
Okay.
I think this is one of the first times that Mama gets to see it from this side. Oh, there's the neighbors across the street.
Oh, they've been yelling since we come out.
That's crazy, eh? Those are the crazy ones, you guys, that if you can hear them yelling, that's the crazy ones across the street. Cops are always there and everything. We need them to go. Okay.
All right.
I will see you.
Have a good one.
Mama says bye.
Okay, I'll take you now. We'll go up that.
No, it's just joking.
How was I supposed to know?
Oh, that's funny. Now she's gone. Now she's back out. She's gone. She's gone back next door. She's got her and her friend. She thought I was being serious. Anyway, her and her friend came over. So, but I told her, now you got to come and say hi since you're so loud out there. I can hear you. Now you got to come and say hi. But yeah, the other screaming, that was the crazy neighbors across our street. Like, they are nuts. It's been so cold. When I go out, I have track pants on and a sweatshirt that's really warm. And they're all sitting out there, all the adults across the street on their front porch. They've got all their sweatpants and hoodies and that on. And the little kids, I think one's about 1.5 years and the other one's 3 years old. They're out on the front porch in just diapers. Like, if it's cold enough that we got to put sweatshirts and sweatpants on, it was cold. Why do you have these little babies out there that can barely even walk in just diapers? The things we see from across there, you guys, you don't even know. But anyway, this other diamond painting I'm working on, it's huge. It's width-wise. And it's a photo of a tarot reader. She's got her cards in that. I'll take pictures of it and show you when I'm done. But I think it's 2.5 feet wide by 3 feet in length. It's huge. Oh, they're back. Okay, let's go to this. As soon as I hear them,
All right.
I'm going to mute. so we don't get feedback.
All seated already. All right, so we're now back on the record. This is State versus Kohberger, case number CR 29222805. Kohberger is still in the courtroom along with counsel and also counsel for the state. And Mr. Edelman is ready for cross-examination, I believe, and you're still under oath. So go ahead.
And actually, Your Honor, the state has everything it needs from Dr. Edelman, so we won't be doing any cross.
Oh, okay. May this witness be excused.
You may, Your Honor.
Okay, thank you. You're free to stay, free to leave. Thank you. Appreciate for you being here. Okay, another witness.
Yes, Your Honor, our last witness is Dr. Dare.
Dare. Okay, I thought maybe Dr. Dare was going to be rebuttal to the state. No.
Your Honor, we disclosed Dr. Dare twofold. First, to talk to the court about the survey instrument itself, and then to provide rebuttal testimony. Part of that is going to come based on the state's objection too. So I don't know if the state has any witnesses to call, but we ask that she stay for that if that's the case.
Okay. So Dr. Dare, line up. Please face the clerk. Raise your hand.
You solemnly swear or affirm that the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth under penalty of perjury.
Yes. Thank you. Now, please have a seat, and then once you're seated, please state your name and spell your last.
Yes, Veronica Dare, D-A-H-I-R.
Thank you. Ms. Taylor. Go ahead.
Thank you, Judge. Good afternoon. All right, let's start with your occupation. What do you do?
I am the director of the Grant Sawyer Center for Justice Studies at the University of Nevada, Reno. I'm also the director of survey operations for the Nevada Center for Surveys, Evaluation, and Statistics, also at the University of Nevada, Reno.
Do you also do consultations outside of your role with the university?
Yes, occasionally.
And is it in that capacity that you're here today?
No, today I'm here independent of my role at the University of Nevada, Reno. I am here as an expert consultant, and that is independent of my work at the university, although my testimony is based on my previous experience, knowledge, and education that I received at the university.
I'm going to talk a little bit more about what you do for work, but let me back up and find out about your educational background.
I have a bachelor's degree in psychology and a master's and PhD in interdisciplinary social psychology from the University of Nevada, Reno. My master's and PhD are from the University of Nevada, Reno. In terms of my work at the university, I have a joint appointment, as I mentioned. I run two different research centers at the university. One, as I mentioned, is the Grant Sawyer Center for Justice Studies, and the other one is a survey lab. I also teach in the Judicial Studies program. I teach a graduate level course called Scientific Research Methods for Judges, which is a course for judges getting their PhD across the nation. They're sitting judges that are on the bench. I teach another course called Scientific Methods for the Justice Management Program, which is a master's degree program at the university. I have taught social psychology, criminal justice research methods. I've taught other courses, but that was quite a while ago. Right now, I'm just teaching this graduate level course. I serve on several dissertation committees for various departments on campus: social psychology, psychology, School of Public Health, computer science, natural sciences. There's many. I serve as a dissertation advisor and committee member for students that are getting their degrees, and primarily in the Judicial Studies program, I have served as an advisor and as well as the social psychology program on campus. In terms of my role on campus, I do primarily, let's take the Sawyer Center first. We do research on justice-related topics broadly defined. My background is social psychology with an emphasis in justice studies and law. And so our research that we've been doing there is specifically related to research in the justice system. We have many different populations that we research and do surveys with, including jurors, judges, attorneys, both defense and prosecution, court reporters. We've done many surveys on diverse populations as well, including people experiencing homelessness, LGBTQIA populations, the elderly, prisoners, inmates, Native American populations. So we've done many, many surveys in that capacity. In my role as the survey director for the Center for Surveys, Evaluation, Statistics, I am in charge of multiple research projects that have to do with surveys nationally, regionally, and locally. Most predominantly, the one that we have been doing since I've been there in 2006 is the Center for Disease Control and Prevention, otherwise known as the CDC, their BRFSS survey, which stands for Behavioral Risk Factor Surveillance System. I am the project coordinator for Nevada, and I've been doing that role since 2000 for the state of Nevada for the last 3 years. But before that, I was the data collection supervisor for this project since 2006. So I've been working on that project for quite a while. Prior to my role in both of these programs, I also worked on surveys. I've been doing, I would say, surveys and research for almost 30 years, since I've been a graduate student, and even before that. So not before graduate student, well, I did research, but before my role in this area, I did research. Most predominantly for the Sawyer Center, we did a nationwide survey on Daubert, and it entailed 400 randomly sampled judges across the nation. And we looked at the effect of Daubert on judicial decision-making. In both of my roles, I work with many organizations to do surveys. We do work for, besides the CDC that I mentioned, many state agencies, Nevada Department of Transportation, Department of Training and Department of Employment, Training and Rehabilitation. I won't do all the acronyms. I won't do that to you, so because I can shoot off all the acronyms. But we work with the National Judicial College. They're right on campus. I'm in the building actually. National Council of Juvenile and Family Court Judges. We've worked on projects with the Federal Judicial Center, the State Justice Institute, and many more organizations. I know you're going to ask me other questions, but I wanted to get those out. So
I do have a couple of questions for you. You said 30 years about of your life you spent doing this work.
yes,
And it sounds like it has a whole lot to do with survey work.
yes,
Is that both designing surveys and then critiquing surveys?
yes. So we have done numerous projects, as I mentioned. You're probably going to ask me, so I'll just say it. We have published in academic journals. I personally have published on different aspects of survey research in Judicature, Justice System Journal, Future of Evidence by the American Bar Association. I have a chapter in there. That one's not specific to surveys, sorry. I have other publications, but specific to surveys, Survey Practice Journal, Law and Human Behavior on the judge survey that we had done. There are numerous. I don't know if I can remember them all right now, but in terms of technical reports, we do a lot of technical reports for our projects. And those are basically reports of findings that we give to our clients specifically to use for their organizations based on whatever topic it is that they want us to survey or study. So I mentioned some of them before. We DETR, which is Department of Employment, Training and Rehabilitation, Nevada Department of Transportation, Nevada Department of Corrections. I don't think I mentioned that one. And we've done 140 over my career there, 140 technical reports, all of which in some way or fashion have related to surveys or survey research. We do a lot of evaluation projects, needs assessments, and most of those always entail a survey of some kind.
Are there guidelines or standards that govern survey work?
Yes, ones that have been mentioned here already, APOR, the American Association of Public Opinion Research, and specifically for change of venue surveys or community attitude surveys, ASTC, which is the American Society of Trial Consulting.
Are you familiar with the standards of both?
Yes, I'm a member of both organizations.
I want to know why people do surveys. It sounds like you've had a hand in a lot of surveys over the years. Why do people do surveys?
Many different reasons to find out information about a specific topic or population. People do it for needs assessments. They do it to find out more about support services. That, you know, if they want to increase support services in their organization, or if they want to just find out an evaluation of what their program is, if they receive funding from a government organization or a grant to do a specific project, they want it evaluated, and that usually entails surveys. People want to know community attitudes. For example, as I mentioned, a couple of them, we did a survey for the Nevada Department of Transportation, specifically looking at highway maintenance in the state of Nevada, asking residents about their opinions on highway safety. We did another one for the Office of Traffic Safety, looking at seatbelt usage, car seat usage, and at the time when cell phones came out, texting and driving, distracted driving behavior. So we've done surveys on those. I'm currently doing a survey with DETR, which I had mentioned, DETR, on foreign labor wage surveys, where we're looking at the farmers in the state of Nevada on whether or not what their wage, the prevailing wages in the state of Nevada. There are many reasons in the justice system. For example, we do surveys on judicial, attitudes, jury attitudes, decision making, looking at specific attitudes towards specific crimes. I did a survey on human trafficking. We did another survey on victims of crime. I could go on. Marketing research. You guys have been asked to take many surveys about projects that not projects, but things you bought, things that, they ask you to evaluate restaurants. You get surveys all the time. People do it, as you know, in the election that's coming up. I'm sure you guys have got bombarded with many surveys. Not all of those are valid, by the way. They're called push polls, but anyway, that's something different. But there are lots of surveys that reasons people do surveys, primarily to make decisions and to form policy, to reform policy, to make changes within their organization. And in this case, to assess community attitudes, bias, and the potential impact of pretrial publicity.
Sounds like it's to gain information, and that's in order to make a decision.
Yes, decision making, and especially within their organizations, and then related to policy. We do a lot of policy change as well. We've actually presented reports to the legislature for whoever our clients are. Like, for example, the seatbelt survey that we did. We were trying to do a survey of Nevada residents to see if they should have a primary seatbelt law in Nevada. I was involved in what we call Assembly Bill 122 in Nevada, where they were looking at the assisted living communities within the entire state of Nevada to see if there should be change in those areas. So those are some examples. And primarily, I guess a good example would be the behavioral health, BRFSS again, by the CDC. The biggest thing that we use that survey for is to look at population health and health outcomes. So we ask questions like behavioral risk that's related to how many fruits and vegetables do you eat in a day? How often do you exercise? We ask about drug practices, substance abuse, sexual practices, whether or not they've ever been told that they've had diabetes or a heart condition or asthma. So those are examples. So we look at the indicators that could predict or have outcomes on the population health. So outcomes, basically.
I heard you mention community attitude surveys. Are you familiar with those?
Yes, I mentioned a couple of the examples that we have done community attitudes on. And that's basically measuring attitudes of the community on a specific target population on specific measures of interest.
Did you have an occasion to review the community attitude survey that Dr. Edelman conducted
Yes, I did.
relating to venue issues?
Yes, I did. Excuse me. I forgot. I have these
Okay,
exhibit F and F1. It's just my declaration and my expert report that I've already provided to the court.
okay. And I can see you just placed those face down. If you need to
Yes.
place them back face up, will you let me know?
Yeah, I will. Sorry. What was can you repeat the question?
That's okay. I'm wondering if you had an opportunity to review the survey work done and conducted by Dr. Bryan Edelman.
Yes, I have.
Okay. And do you have an opinion about whether that survey was conducted in a valid way?
Yes, I do.
What is your,
In my opinion, it was a valid survey.
what do you base that opinion on?
So there are standards and professional code of ethics that I mentioned earlier, suggested by AAPOR, again, AAPOR, American Association of Public Opinion Research, and the American Society of Trial Consulting, ASTC. And specifically, ASTC has a section on venue change surveys. And there are many things that can go into a survey to determine its validity and reliability. I guess I should talk about that before I go into that. When you're talking about scientific reliability, by the way, it's very different than evidentiary reliability. So evidentiary reliability is looking at the trustworthiness of evidence, whereas scientific reliability is looking at the consistency and repetition of a survey done over time, across different populations. And validity is more looking at trustworthiness or accuracy. So if we talk about reliability as consistency and stability of results, and validity as accuracy, that's how I'm going to talk about those things. And with respect specifically to this survey, there are many types of validity and many types of reliability, but I'm not going to go into all of them here. I think specifically for this survey, what's important is content validity, construct validity, measurement reliability, and response reliability, specifically with this survey, and looking at coverage error and what we would call external validity. There are other types, as I mentioned. There's criterion validity, there's inter-rater reliability, test-retest reliability, convergent validity. There's many types of validity, but I'm not going to talk about those here. I'm just going to talk about the things that made me come to my opinion or form my opinion based on the survey. According to the ASTC standards, we're doing a change of venue or community attitude survey to look at whether or not a change of venue should be conducted, or a change of venue might be considered. You want to look at 6 things. You have screener questions, you have case recognition questions, you have questions related to the source or the media where the information comes from, you have demographic information, and then case knowledge questions. I think I got them all. And that's what I was looking at with respect to the content. And those were all there in Dr. Edelman's survey. The other thing I looked at was the questions themselves. Do they have what we would call
big hello,
construct validity,
Chantel,
which is
my mom.
basically, does the survey measure what it purports to measure? And then does it have content validity? Does it cover all those things? And it does. I mentioned that already. That's the content validity, those 6 items. And was it done in a way that you can consider it? The measurement was reliable, and I would say yes. I read the methodology was brief, but based on what I could gather from the report that Research Strategies did, they did all of the things that we would have done. I would have probably done a little bit more in terms of looking at, some of the disposition codes were just a little bit hard to determine, but that's not that important for this. What I would say is that they did everything we do in our lab. We are very strict, I would say strict when it comes to our methodology for our surveys, because we follow APOR, which is the strictest standards that you could follow for calling on a telephone survey, or what we call an RDD survey, random digit dialing. And primarily that's because we have to do the CDC survey, and the CDC survey follows the APOR guidelines. And so for all of our projects, whether it's BRFSS, whether it's CDC or not, we follow the same protocol. So no matter what project we do, whether it be for NDOT or DETR or any of these other organizations that I mentioned, we would definitely follow the same protocol procedures. And that includes things like good questionnaire construction and design. That's the first thing. In order to combat what we would call non-response bias, the first thing you look at is questionnaire design. Are the questions written in a way that would get the responses that you need? Do they have content validity? Are the questions valid? And by that, I mean, we look at things like question order. We look at the whether they're leading, whether they're loaded, whether they're double barreled, whether there's many things we look at. So I looked at that. And then we also look at how the survey was sampled. And according to research strategies, they did use a random digit sampling frame. And by that means they probably, I don't have all the details. I'm just going based on my opinion, my experience. What we do for our surveys is we order our sample from a sampling company, and we get replicates of phone numbers. And what that means is we get them in blocks of like 30, for example, and you would call your replicates of 30 phone numbers until completion. And that's to make sure that you are not biasing your sample. So you don't want to call, here's an example. If you get 20,000 phone numbers, you don't want to call all 20,000 phone numbers just once. That's not how it works, because you're only getting those people that answer the phone on the first ring. So that's biasing. Also, you're reducing your response rate by doing that. So what we do is we call them in blocks of numbers, and we call them several times. From my understanding, they called them 4 times. Research strategies is they called once, if they didn't get a hold of them, they called 3 more times, they did callbacks. That's also proper protocol. We like to call our surveys at least 3 times during 3 different time periods, either the morning, afternoon, and evening. We also like to call them during the day and on the weekends. My survey lab that I run is open 7 days a week, and every single holiday except for Christmas, Thanksgiving, and believe it or not, Super Bowl Sunday. It's the other American holiday, apparently. Anyway, people get mad when you call them on Super Bowl Sunday versus Father's Day, Mother's Day, and Easter, believe it or not. But anyway, so we call these numbers at different times. And from what I could tell, they did follow-ups, they did different call timing, they did callbacks, they did the replicates, they used both cell phone and landline. It is customary practice now when you're looking at coverage validity, you want to get more you want to make sure you're getting the population that you're interested in. And now so many people have cell phones. So in our lab and most labs across the country now, we do like 90% cell phones versus 10% landline. Now it's customary because of the reduction in the number of people that have landlines. Anyway, those are some of the things that I looked at, and whether the questions themselves, like I said, were valid in terms of what they were being asked.
It sounds like
Did I answer the question?
you had a really
Okay.
thorough look
Okay.
before you had your opinion as to whether the survey was valid.
Yes.
Do you have an opinion about whether it was reliable?
Yes. In terms of measurement reliability, which includes things like if you are an interviewer and you are asking questions, it could be biasing if you're not trained properly. And the mode of survey that you're doing for change of venue surveys, the typical mode is RDD surveys, which is phone surveys versus paper or in person. And so the interviewers must be trained and supervised. My understanding is that research strategy has been around for 20 plus years. So I'm assuming they're like our lab where they were trained properly and they have supervision where there's supervisors also supervising the interviewers. So that's another way to combat non-response bias. which includes refusal conversion training, which is, I think Dr. Edelman alluded to it earlier, things like soft refusals. If someone calls up and says, I'm making dinner, I'm too busy, I'm giving my kids a bath, I'm running to the store, whatever it is. We train the interviewers on how to handle those situations so that we don't get only the first person that answers the phone or only those people that are saying that they're busy. So that's all part of the training to make sure that we get at non-response.
Right. I think that you have answered my questions really well, and based on, just to sum it up, based on your look at the work done by Dr. Edelman with this survey, your opinion is that it's a valid survey.
Yes, basically it's what I would have done or what we would have done in our survey lab.
Thank you. I don't have any other questions right now, but hang on, prosecutor.
Okay, thank you.
Thank you.
We have no questions for this witness, Your Honor.
Okay, great. Thank you. Is it
Nobody that easy.
so easy? So, thank you. Witness be released.
She may, Your Honor.
Okay. Thank you for being here. It's very interesting. Help yourself, yeah, such as you need.
Thank you.
Thanks. All right,
Fit for witnesses, Your Honor.
no more witnesses. Okay, any witnesses?
None from the state, Your Honor.
Okay, we prepared for argument.
Let's do it.
Okay, go ahead.
Thank you, Your Honor. Your Honor, the decision to change venue rests on what you've heard today and the court's determination that there's a reasonable likelihood that all of the media coverage has impacted the impartiality of a Latah County jury. That comes from Paul and Shepard. Your Honor, it's important to think of that standard in light of the Constitution of the United States and the state of Idaho. Mr. Kohberger has a constitutional right to a fair trial by an impartial jury. And to guarantee that, this court must change venue. Your Honor can look at the media coverage in this case and know that it's prejudicial coverage. The amount of coverage is a huge amount of coverage. The kind of coverage is prejudicial coverage, and it's had an impact on the Latah County potential juror. The court can see actual prejudice by understanding the results of that survey. Reading the hundreds of comments from Latah County residents, you can see that the media has been prejudicial and it's actually prejudiced potential jurors in Latah County. The court can also presume prejudice by looking at this case as it is. It's an extreme case that comes out of the Haddon case in Idaho, and you can presume prejudice in an extreme case. You have heard all day long how much coverage this case garners. It's Latah County, it's bigger, it's a state of Idaho, it's nationwide, it's outside of the nation, it's continuous, it's every day. Social media, books have been written, primetime television shows have happened in this case. It just doesn't stop. And you know that this is prejudicial coverage as well. The state has agreed things that were surveyed are false media items. At least some of them. This is all before the other things contained in the media are subject to admissibility rules, even if they're awkward. Subject to cross-examination and full context explanation of what they mean. So you have this coverage that permeates the community. Bigger than the community, the state, bigger than the state, the nation, and this is an extreme case. The court should think about things that have happened in this courtroom too, when considering whether this is an extreme case and the amount of prejudice that exists. This court has issued courtroom rules to determine who can have a camera, where a camera can be. The court on our motion limited things and finally removed cameras from this courtroom, and the court right now is live streaming. That doesn't take care of all of it, though. The live stream is captured and replayed almost in real time, if not real time. Everything that happens in this case is on social media, and all kinds of things that don't happen in this case run rampant in news stories, in social media stories, and impact all of the jurors. It is particularly important when you're considering this extreme case to look at the size of this community. You heard a lot about that today. You heard how bias is created. And when you think about this little community and all of the people that spoke out early on about this case, that's how the bias starts in this case. People in this community have a lot of ownership in the case as well. They're connected to the case by being related to or knowing people that conducted the investigation. They're connected to the case by knowing the community leaders that have spoken out about the case. They're connected to the case by the relationship with the University of Idaho. That's a pretty tight connection. And that is how you have to think about the human bias that exists and how it cannot be fixed if we get to jury selection. Your Honor has to look at the content and know the content of the media and know that there hasn't been positive stories about Bryan Kohberger. It's negative stories. There's not a media story talking about Bryan Kohberger's right to be presumed innocent. There's not a media story talking about Bryan Kohberger being loved by his family. Nobody's talking about the good grades he achieved all through his undergraduate career and graduate programs. Nobody's talking about the dog that he loves and helped train. It's all negative. It's false. It's misleading. It's stuff that's rumor and never coming into court. There are things about his character that are just untrue that are out there. When you have this much information surrounding a case, it's an extreme case and it's all over the place. I don't want the court to think all this social media happens and it's not centered in Latah County and think that's okay, because it's just not. There's plenty that's centered in Latah County. I'm sure the court remembers where we started earlier today with the two pie charts that we were shown by Crusoe this morning. One talks about how big the coverage is in Latah County that projects into Latah County compared to how small of a piece of the pie of the whole population in Idaho that Latah County is. So that's a lot of coverage directed into Latah County, and that's the stuff. Those are the news stories, the nightly news that's coming into Latah County residents' TVs. That's their newspaper that they're going to get in the morning. But that's not all. Latah County has as much access to primetime news stories, as much access to Facebook groups, to different podcasts, to watch things on YouTube, to buy books containing misinformation. They have as much access to do that as anybody else. So you have to recognize how big the case is, how much coverage there is, and just how prejudicial the coverage is. You understand that, we understand that learning from Dr. L. O'Leary this morning, when she talked about bias. So having that as a backdrop and thinking about the survey results that we just talked about, you can see that there is a huge correlation to the few media items that could be tested and prejudgment of guilt for Mr. Kohberger. And those are people in Latah County. You can see the case connections that are bigger than the other counties, and they just don't go away. You also should be aware that the coverage doesn't drop off. It's not going to stop. It may peak and it may dip a little bit. It comes right back up. You can expect that will continue. We have a pretty good schedule of hearings coming up for pretrial motions. The court issued a scheduling order a couple of months ago. And so you can expect that the interest in the case is going to pop back up every single time we have one of those hearings. And that's a lot of media coverage, and people in Latah County are going to see it and read it. And they're going to continue with their opinions. So what do we do? What do we do about it? It's tough. It's really tough in Idaho. There is a lot of case recognition and there's prejudgment in Idaho, but there's hope. When you look at the survey and you recognize that in other parts of this state, people don't recognize as many media items as they do in Latah County. That's good because that links right to prejudgment. So that's good. That's hope right there, that we can find a jury somewhere in this state to give Mr. Kohberger his right to a fair trial. It's also a much larger population, so the impact on people sitting on the jury would be much smaller. Imagine with me that we are here in June of 2025 and we're here and we've seated 16 or so people over here. You're going to recognize some of them. People that sit in the courtroom in our audience that want to come and listen to the trial are going to see them. Even if they don't listen to the trial, people are going to know whose car leaves their driveway every morning to get to the courthouse by 8:30 for 3 solid months. And those jurors that sit over there are going to feel an immense amount of pressure to answer the call of the community to be safe. You can read those comments about what people in this community think about Mr. Kohberger and what they think would happen if the jury found him innocent. It's hard to imagine that one of those jurors who all of a sudden said, you know what, I'm not sure, and listened to more evidence and said, I'm really not sure. I don't think he did it. Are they going to be brave enough to do that, to write not guilty, to say not guilty, and to stand their ground? That comes right to impartiality, that the court has to be sure that that's not going to happen. You can't be sure that there's a way to pick an impartial jury in this community. In Ada County, we don't have that. We don't have Canyon County, we also don't have that. Those are jurors that are not from this small, close-knit community. Those are jurors who aren't going to run into a police officer that investigated the case at the grocery store, or maybe somebody from the prosecutor's office at the jazz festival at the college. They're people who don't have those connections. The other difference that I think is really important to think about too is the location, the connection to the house where this happened. That has been a pretty big deal in the community and wider, but in the community about whether the house should remain standing through trial or should be torn down. And there's been an awful lot of publicity about that. People in this community have an opinion one way or the other. We aren't going to know what their opinion is, but they're going to bring that into the courtroom. People in Ada County do not have. And why Ada? Why not Canyon, or why not Bannock? I think that's something that we should talk about. The easiest one to talk about is Bannock. The numbers look a little better there in a lot of regards, but it's a smaller community as well. And so I think that there's a danger that if the court says, I'm going to change venue and we're going to Bannock County, I think there's a danger with that small community. There could be more interest all of a sudden, and we may run into a bit of a problem. So that's why I'm not here telling you Bannock County, but if you tell us Bannock County, I think we have a lot better shot at seating an impartial jury than we do here in Latah. Canyon County is the second largest. And Your Honor, honestly, if the court says, let's change venue, let's go to Canyon County or Bannock County, I think we have a better shot at getting an impartial jury. But we picked Ada County specifically because we're aware of the structure of that courthouse, the way it's set up. We're aware that there's at least some statewide precedent for moving these big cases to Ada County. And we're aware that it would be easier to get our jurors to and from that courthouse in a way that they wouldn't have to go through The media, they would be kept private and in secret and secure. It makes sense to focus on Ada County for a lot of those reasons. Your Honor, we're mindful that that's a lot of miles away from here. But at the end of the day, the interest that we have is to protect Bryan Kohberger's constitutional rights. His right to a fair trial is as important as our right to free speech, our right to bear arms, our right to be free from unreasonable searches and seizures. And the right to a fair trial cannot happen in Latah County. There is way too much media coverage. It is biased media coverage. It has impacted the potential juror, and it causes bias in the potential juror. This is a tiny little community, and this case needs to move where there's a chance to get jurors that haven't prejudged guilt of Mr. Kohberger and will have the ability to be anonymous and not known by everybody else in the community. The pressure to convict here is great, and it won't be in Ada County. The venue needs to be changed.
Thank you, Ms. Taylor. Ms. Beatty?
Thank you, Your Honor. Your Honor, the case law in this case just does not support a change of venue, given the evidence that the court has before it. The state does not disagree with counsel on what the appropriate standard is. The appropriate standard is that the defense has the burden of showing a reasonable likelihood that the defendant's ability to get a fair trial is going to be diminished as opposed to some other county, or put another way, a reasonable likelihood that pretrial publicity will deprive him of a fair trial. So in looking at the evidence the court has before it, we can start with Exhibit C. Those were the charts presented by TrueScope. And we can see in those charts that for at least 6 months on one of those line graphs that compared Ada County and Latah County, Ada County had significantly more coverage than Latah County. And that more recently, in the past couple of months, that line graph comes together again, and they're just a couple points off. The fact is, Your Honor, this case has media coverage everywhere. That is something that was acknowledged by the defense, and that is something that is abundantly clear in these surveys. So looking to Exhibit C, comparing Latah County and Ada County, it is clear that this could easily be a back and forth scenario where at some points Latah County is higher and at other points Ada County is higher. And it almost looks like we may have recently been headed in that direction as recently as a few weeks ago. In looking at the survey numbers, Your Honor, I'd like to talk about what the numbers from the survey actually say. And I'd like to start by looking at Defense Exhibit F1, Dr. Dare. We don't dispute any of the testimony that she gave today. We don't dispute anything in her declaration. And one of the things in her declaration that she discussed was a 5% margin of error in surveys such as this, with 400 survey respondents in a population within the range of our population in Latah County and in the population of Ada County. So if we're talking about a 5% margin of error, according to the defendant's own expert, and we're looking at case exposure in Latah County of 98% and Ada County of 93%, those communities are within the margin of error. Looking at presumption of guilt among jurors who knew about the case, Latah County, 67%, Ada County, 68%, Canyon County, 69%, and Bannock County, 76%. Latah County, Ada County, and Canyon County are at best within the margin of error. And if these results are to be taken literally, Latah County has the lowest number of jurors who knew about the case who are going to presume Mr. Kohberger guilty. Now, when you zoom out and look at the survey results for presumption of guilt among all respondents, Latah County is at 66%, Ada County is at 64%, Bannock also at 64%, and Canyon at 62%. Again, you're within this margin of error here. I would also point the court to the fact that jurors among the total sample size who had no opinion about this case, potential jurors, survey respondents, Latah County had the highest number of folks who reported having no opinion about this case at 17%. Ada County, 12%, Canyon 13%, and Bannock at 9%. And then again, jurors among the total sample who had no opinion about Bryan Kohberger, Latah County 29%, Ada County 25%, Canyon County 23%, and Bannock County 24%. Again, we have the highest number of survey respondents in Latah County saying that they have no opinion about the defendant. When you zoom out, this is the big picture. These are the questions that matter. The question is, which community is the most likely to give Mr. Kohberger a fair trial? We can split hairs and say, well, if this person knows this media item, then they're X% more likely to think he's guilty. That's not the big picture. Those are trees in the forest, but we're ignoring the forest. And if you're looking at the forest is which community has the least amount of bias. And there are obviously some personal connections in Moscow and to the University of Idaho. The state does not dispute that. We believe those can be dealt with through other measures short of venue change. But when it comes to bias itself within a community, the court can take this entire 300+ page document of all of the survey responses and look at these surveys and see that the pervasive media coverage across the entire state has simply created some complications and difficulties. Those are not unique to Latah County. The more productive conversation to have is how can we craft questionnaires that will ask jurors factual questions that help us identify sources of bias. For example, are you employed by the University of Idaho and how? Or did you know one of the victims? Things like that that are factual that will allow us to then follow up and ask more questions. And frankly, Your Honor, the state would be willing as we approach trial to engage in good faith discussions with defense counsel and the court about potentially just excusing some jurors who are too factually close to the case for cause from the outset. We're willing to have that discussion. Another thing that the court can do that would address some of the concerns that were testified to regarding bias and social pressures is to allow potential jurors to have individual voir dire and outside the presence of other jurors and outside the presence of cameras or audio recording that are being live streamed. In this case, it's going to be critically important that potential jurors who come to jury duty feel like they can give honest answers and feel like they can be forthright. And in order to do that, I think individual voir dire would be very appropriate, and the court has that option available to it. I think another possibility that the court should consider, particularly after looking at Exhibit C and those line graphs where we're talking about peaks in media coverage, is sealing some potential hearings coming up. And the defense may not want to seal certain hearings for good reason. We're not asking the court at this point to seal all hearings going forward, but the state believes that there may be certain evidentiary hearings. For example, if the state files 404B notices or motions in limine related to the evidence, some of that information might be extremely prejudicial, and the state would agree to seal hearings where prejudicial information is going to come out in that hearing. And that too is a tool that the court has before it to alleviate some of those peaks in media coverage, because of course, part of the court's consideration is going to be the intensity of media coverage over the life of the case. And so one way that the court can address that is by sealing certain hearings, and the parties can use good faith and seal certain motions or briefs addressing prejudicial information temporarily until the trial is complete. When we're talking about bias and individuals who come to court for jury selection, I think it's important to remember that we have to deal with what the law says. And what the law says is that voir dire and jury selection is the appropriate process for ferreting out bias. We don't get to hand wave the jury instructions that are based in case law and that are handed to us by the Idaho Supreme Court. We don't get to hand wave those and refer to them as indoctrination and act like all potential jurors are going to come to court and lie, that they can't be trusted. Now, certainly there are some human biases, but a good voir dire is the tool to address those. And we don't get to just burn the system down. That's not what we're here to do. We have to use the voir dire process. I would also point out that when we're looking at, well, actually, Your Honor, let's talk about some numbers. Let's assume, we've heard a lot about the Daybell case. Let's assume that this court decides to summon 1,800 jurors. Let's assume that this court decides to seat a jury of 12 with 6 alternates, given that it's going to be a very long trial. If this court were to summons a jury of 1,800 jurors, which was the amount that was summoned in Ada County in Daybell, this court could just as easily summons 1,800 jurors in Latah County with a prospective jury pool of 32,000 as a court could summons 1,800 people in Ada County. It doesn't matter that Ada County's population is 16 times higher than the population in Latah County, because in Ada County, the court, if the court moves this trial to Ada County, is not going to say, well, we're in Ada County, I guess I'll summons in 20,000 jurors. That's not how it works. This court could just as easily summons in 1,800 jurors in either location. And if this court were to summons 1,800 jurors, only 1 in 100 would have to qualify to sit on a jury in order for this court to proceed to trial. So if you look at that 1,800 number and you look at some of the survey numbers, let's look at total prejudgment. Total prejudgment by total sample. 17% of Latah County jurors had no opinion on total prejudgment. That sounds low, but when you look at it out of a jury pool of 1,800, that's over 300 people walking into this courthouse with no opinion about the case. You look at the question, given what you have read, seen, or heard about this case, would Bryan Kohberger have a difficult time convincing you that he is not guilty of murder? 19% said no, 16% said no opinion. You add those up and you have over 600 jurors out of an 1,800 person jury pool who would answer that question in that way. What is your opinion of Bryan Kohberger? No opinion, 29%. That's over 500 jurors that would come into this courthouse with no opinion of Bryan Kohberger. A large jury pool is a solution to the media coverage in this case, and this court is going to have to summon a large jury pool wherever this court holds this trial, whether it's in Ada County, whether it's here, whether it's in Bannock County, or whether it's in Camden County. And frankly, Your Honor, as we move toward the issue of convenience, if anything, these survey numbers being so close to one another and so tight with each other should tell the court that if the court did determine that a venue change was appropriate, if the court made that determination, Kootenai County or Nez Perce County would be a far more logical choice, because those are geographically closer and the state would not have to pick up and move all of its evidence for 3 months down 300 miles to Boise. The court would now have to move its entire court staff. People could still go home. There would be less witness travel expenses. So if the court decides to change venue, the court should look at more convenient options closer to Latah County. Either Kootenai County or Nez Perce County would alleviate some of the concerns laid out by the defense about the connections to the university or the connections to Moscow itself. But again, even looking at the survey on those issues of connections to Moscow or connections to the university, 39% of folks in Latah County visited or walked by the home where the murders occurred. 60%, nearly 60% didn't. That means that out of a jury pool of 1,800, over 1,000 people would not have gone by the home where the murders occurred. Are you or a family member, student or employee at the University of Idaho in Moscow? 75% of folks in Latah County said no. That's 1,300 out of 1,800. I don't want to beat a dead horse here, Your Honor, but a large jury pool alleviates these concerns so much better than simply moving venue to another locale where the public sentiment is so close that it's within the margin of error, or if you're taking these survey results literally, worse. That makes no sense, Your Honor. The other option that the court has available to it would be to bring in a jury pool from Nez Perce. Again, the state does not believe that a venue change is warranted given the evidence that the court has before it. But if the court were persuaded that a Latah County jury could not successfully be sat in this case, the court could bring in jurors from Nez Perce County. Lewiston is approximately 30 minutes away. It would certainly be a longer drive for them, but the court could deal with that in scheduling and make those accommodations. It has many months to prepare to do that. Moving to the convenience issue, I think it's important to note that Latah County is not a tiny little community. Latah County might be close-knit, but it is not a tiny little community. Latah County is one of the top 25% of most populated counties in the state of Idaho. It's 11th out of 44 counties in Idaho. There are 32,000, according to Dr. Edelman, jury-eligible citizens in Latah County. It is not so tiny that we could not summons in a jury of 1,800, a jury pool of 1,800 folks. Since the convenience argument focuses primarily on Ada County, that's what I'm going to address today. So starting with the size of courthouse and the ability to house parties and court staff, it's already built into the Latah County Courthouse for the court to have a place to go, for the court's employees to have a place to go, for court staff, for the court staff attorney. All of that is built into the Latah County Courthouse. Unlike moving to Ada County, where the courthouse would have to accommodate the court and all the court staff. Similarly, the prosecutor's office and their staff already built into the Latah County Courthouse. No separate accommodations would be needed. The defense will have to have accommodations wherever they go, and certainly they are entitled to privacy and accommodations that will allow them to prepare for this extensive trial. They absolutely should have that. But they are going to have to find those accommodations regardless of where this trial is located, unless it does get moved to Kootenai County. And so keeping this trial in Latah County would be a lesser burden on the Latah County Courthouse in the sense that they would simply have to find accommodations for the defense team rather than finding accommodations for everyone. As to juror space and security, as well as the argument of overall security, it is true that the Ada County Courthouse has a precedent of handling large trials. And it is true that Ada County does a very good job with that. But the reason Ada County does a very good job with handling these high-profile cases with security, with court staff, with organization, with getting jurors in and out in an organized fashion, the reason Ada County does a good job with that isn't because Ada County has a physically bigger courthouse. It's because Ada County has diligent, competent, and professional staff. And I have every reason to believe that with the 9 months we have until trial, that this court staff here and security could also have the time to prepare and make operation plans and all of the things that go into having a trial of this magnitude. I have no doubt that they could accomplish that with careful planning and preparation over the many months between now and trial. It is also my understanding that there is a means to bring jurors securely into this courthouse outside of the public view. Moving on to the cost of travel expenses, counsel referenced the cost of transportation to and from the airport and correctly noted that the Spokane Airport is considerably further from the Latah County Courthouse than the Boise Airport is from the Ada County Courthouse. That's absolutely correct. However, the Lewiston Airport is a shorter drive, again, about 30 minutes, and does connect to some major airport hubs. That would be another option. But even taking into account that there may be some additional rental car expense for the few out-of-state witnesses that we're going to have, that would be negated and then some by transporting all of the local witnesses from Latah County down 300 miles to Boise, by paying for accommodations in Boise for the court and court staff, the prosecutor's office and prosecutor's office staff, and the many local witnesses that will be testifying in this trial. There's also the logistical issue of transporting evidence for a 3-month trial, the chain of custody issues, the evidence tech from the Moscow Police Department, and it's my understanding there's only one, taking him out of his role up in Moscow here for 3 months and having him in Boise, trying to manage this evidence in a location that we would also have to arrange for, and dealing with the chain of custody issues, transporting the evidence back and forth. I think the court can also consider, since this is a pretty broad standard on the convenience side of things, the effect of prosecutors and law enforcement being away from the community for up to 3 months. And I think the court should also consider the nature of Latah County itself. The infrastructure of Latah County, and specifically Moscow, which has a university of nearly 12,000 students, is that this community is tailor-made to expand and contract with the rhythm of the school year. So this isn't going to be a situation where there aren't enough hotels or aren't enough restaurants. This town, as well as neighboring Pullman, which provides additional accommodations, is designed to handle large influxes of people. That should not be any concern for the court at all. Again, we are not talking about a tiny community here. We are talking about a mid-sized town that's on the, frankly, a larger side, on the larger side for counties within this state, that can amply accommodate a jury trial of this magnitude, particularly in the summer months where you don't have these major academic events. Finally, since we are talking about the interests of justice in the convenience prong of the rule, it is completely appropriate for the court to also consider the fact that most of the victims' families, not all of them, but most of them, live closer to Latah County than they do to Boise. That means that for them, traveling to this trial, which they will have a constitutional right to attend, and again, we're only asking the court to consider this in the convenience prong, will be much easier for them and more convenient for them than it would be for them to have to travel hundreds of miles to Boise. I think the court can and should consider that factor as well. Your Honor, at the end of the day, these surveys have given the court a factual basis to deny this motion to change venue, and we hope that's what the court decides to do. Thank you.
Thank you, Ms. Beatty. Ms. Taylor?
Thank you, Judge. Governor, as I sat and listened to Ms. Beatty talking about all of the prejudicial coverage and how there's a problem in other counties as well as Latah County, it really struck me that everybody knows how prejudicial this media coverage is. Everybody knows that. And that's really the question the court has to answer today. Has there been prejudicial media coverage that there's a reasonable likelihood that it impacts the impartiality of the jury, that it impacts Mr. Kohberger from getting a fair trial? Don't think about county's numbers. Don't think about Canyon County's numbers, and don't think about Bannock County's numbers. Think about Latah County's numbers. Your first question is, do you grant the motion to change venue to protect his constitutional rights? Don't get mixed up in thinking, well, Ada County's numbers aren't so great either. Maybe Canyon County's numbers aren't so great either. You have to make this decision based on what's going to happen in Latah County. You know, the jurors have been exposed to prejudicial media. You know that there's been an impact on you. You know that that's going to be really hard to ferret out in a jury selection moment. And if you know all that, you have to change venue. You can't just say, well, it's bad in Ada County too, so I won't change venue here. The question for the court is, in the county in which Mr. Kohberger is charged, can you seat a fair and impartial jury? And that answer is no, you cannot. The court then has to decide, what do we do? But answer the first question first. Answer the first question first. And don't be tempted to say, well, maybe we could go to Kootenai County. Maybe we could go to Nez Perce County. We don't have any surveys on them. We don't have any information on them, except we know that Dr. Edelman pulled a couple hundred stories from the Lewiston Tribune and looking at the local media coverage because of the closeness of Moscow and Lewiston. And except that we know that people in Lewiston have the same nightly news as those in Moscow. And by the way, so does Kootenai County. KXLY that broadcasts all the stories on their nightly news, that happens at my house, it happens at Mr. Thompson's house, and it happens to somebody who's from Lewiston too. That's the same news. The difference is the newspapers, and the difference is the community connection and what that means in this case. So don't be tempted to go to another county and haven't surveyed. We've surveyed a lot of comparative counties. Stay in the place where your decision rests on what's going on here in Latah County. For sure, when we do get to jury trial, you should do individual court. For sure, we should do a jury questionnaire and we should talk amongst all of us and try to figure out if we can excuse some jurors before they're ever brought in. They should never be on camera. We should try to keep them as anonymous as we can. Those are all things that we absolutely must do.
I agree with that.
To be the very most protective, you have to answer the first question. And that question is, we have to get this case out of Latah County. That's an important decision, and it's important to make now. We're 9 months from trial, and we need to have the venue issue settled. We need to be able to have our subpoenas out. We need to have our experts plan. We need to have time set aside. I've got my time set aside, but we need to have our experts be able to get tickets and reservations for hotels. Don't answer all the questions at once, Your Honor. Answer the first one first. And then think about where it's most reasonable to have the trial. Think about the differences in the communities. But answer the first question first. We can't have this trial here. There is no way Mr. Kohberger can get a fair and impartial jury.
Well, I'm not gonna give you a decision now. Number one, I would say this is probably professionally the most difficult decision I've ever had to make. Both sides, okay, have made really solid positions and supported that. I know there are a lot of considerations. Practical, you know, in terms of logistics and prejudicial media. So I have some work to do. I'm gonna go through everything, okay, even if I got most of everything, but that's gonna take me a little bit of time. And go through the law again, too, including the rule itself and the interpretation of that. So I'll do my best. It's a challenge. So that's probably all I should say at this point. But I listened carefully all day, and I thought there was some really important things to think about, both sides, and that's what I'm going to do. So with that, I will adjourn and take care. Have a good rest of the week. Thank you all.
All righty, so there we have it. I don't know what he's going to decide. Usually I have a feeling. And it's like, I didn't like that funny ass side grin that he was giving Ann Taylor during the last part of her spiel, where she was saying, you have to do this. You should be doing this. And he's giving her this side smile. I didn't like that. I didn't like it at all. But anyway, that's it. 8 hours, you guys. 8 hours of repetitive BS. And I'm glad the prosecution, I do believe that the prosecution gave a good fight there at the end. I believe now, even though I was like, why didn't you ask any questions of this witness? They didn't want to tip their hat to the defense as to what they were going to argue. I get it now. I get too involved in these cases and get too wound up. That's my problem. But anyway, so it's a 50-50 chance right now, you guys. I think I hope he keeps it in Latah County. I really do. I think the county deserves that. The things that Anne said about the residents, they can't be trusted, they can't be unbiased, they can't be this, they can't be that. It's like, do you realize who's paying your bill? It's these taxpayers that you just degraded and said they couldn't do the job of what Ada County jurors, potential jurors, could do. Ada County jurors. What? Anyway, that's just me getting aggravated with her in totality. I hope after this trial is done, I never have to see that woman again. Please, Lord, don't put her on any other trials that we're covering. She just goes on and on and on and on. And the thing is, if she does that during trial, she's going to lose the jury. Whether the jury's in Ada County or Latah County, she'll lose the jury like she lost us. You know what I mean? When you go on and on and on and on and on and on and repetitive, the same people saying the same thing, and it still does, it doesn't matter. You got 5 people trying to preach your word, but it still doesn't make any sense. So I'm glad that the prosecution came out with that at the end, that's how tight those numbers were compared to Ada County and Latah County. So why do the extra expense of moving everything to Ada County when we can get the same results as Ada County can get, we can get here? So I do think she made a good fight at the end there. We'll have to wait and see. But for now, you guys, we're going to wrap it up. Thank you, everybody, for being here and listening to this with us for the past 8 hours. I appreciate each and every one of you. Mods, for keeping things on track here. Thank you so much for all your donations today, your super chats. Congratulations again, Kay and Mitch, on your win. I will get that shipped out to you ASAP tomorrow. So you should have it sometime next week. Carolyn says, tell you what, Willow, it was my sister in Missouri, and I told her I was watching the Bryan Kohberger trial, and she said, who? Move it to Missouri, right? Okay, you guys, gonna wrap it up. Like I always do, please take care of yourselves. Please stay safe. Always be aware of your surroundings. I love you guys to the moon and back. We'll see you on the next one. Bye-bye for now.